Creditors with our esteemed faculty, Ashish Makhija, sir. We have two sessions today with him, and first session is specifically going to work on compliances and timeline of Committee of Creditors. So I welcome Ashish, sir, on behalf of ICSI IIP in this workshop. I would like to read his brief profile before the participants. He's a leading legal practitioner in insolvency and corporate law matters. He bears top credentials in corporate law, insolvency and bankruptcy law, corporate litigation, and advisory. He was the standing counsel for the official liquidator attached to High Court of Delhi for 6 years. He is a doctor of judicial science from Emory Law School, Atlanta, USA. He is a chartered accountant as well as a cost and management accountant. He holds 2 LLM degrees, Master of Law in International Bankruptcy from USA and Master of Law from Kurukshetra University. He has the distinction of being World Bank trained corporate trainer. He is a master faculty and has spoken extensively on insolvency and bankruptcy code, corporate laws and corporate governance, etc. He has served as a member of committee formed by Ministry of Corporate Affairs, Government of India, for drafting rules for several chapters, merger, revival and rehabilitation, winding up NCLT and NCLT under the Indian Companies Act 2013. He has significant corporate board experience and has served as an independent director in Shipping Corporation of India, Caterpillar India Limited, and other public and private limited companies. So we welcome you in this session, and it's truly a privilege for all of us that you've been agreed to address the participants in this workshop. Over to you, sir.
Thank you, Surbhi. I think, friends, a very good morning to all of you. I think it has been on our Saturdays and Sundays when I see the people from one fraternity, I'm so delighted. I think this is the time when we can learn together. That's very important. Friends, as usual, may I request everyone to please open their videos. As I always say, I don't want to speak to the blank screens. So please open your videos. I can see few of them, but I think the more you open, I think that will be wonderful. I know you would be at home, maybe not in a position to open videos, but yes, try to do that if possible. Okay. Friends, first of all, again, once again, a very good morning and welcome to this particular program. I think learning together is one of the important aspects. And let me share with you, I learned so much from the wisdom of the people who ask different types of questions, and it naturally enhances, you see, the knowledge also. And you need to learn more. So for a 6-hour session, naturally one has to prepare for 18 hours to come here, because definitely the experience of the people and the wisdom is too great. Now, the important part, friends, is this. Today, we are going to make it absolutely practical. I will take you back to some theoretical part where we'll refresh our memories and also see whether we are complying with those provisions or not, because this is sometimes it becomes important. And then some changes do take place. Of course, it has been a long time that the changes have come now, but yet, whatever the latest changes which have taken place, so therefore, those must be complied with. And why I'm saying this? Because insofar as COCs are concerned, it is more of a regulatory or more of a procedural part, isn't it? We have to stick to the timelines, whether we are sending proper notices or not, along with the agenda, whether we are recording the minutes properly or not. Now, and everything, and mark my words, friends, this is the one tip which I would like to give you. Because I'm seeing a lot of disciplinary matters going on, and 6-7 matters coming to my table every month is not a good sign. I mean, I really don't like them. But be that as it may, since I have to defend the IP, so naturally I do that. But all I'm saying is in some cases, these things are avoidable. Now, what happens in an investigation? Let's try to start from there, and then we will see the importance of the other things. The moment any complaint goes to IBPI, it will form its prima facie kind of a opinion, and then it may order inspection or investigation. Now, inspection is less serious and investigation is a more serious aspect. In inspection, they're just trying to find out if there are few non-compliances are there, whether you have complied with the provisions of law or not. And in fact, the end result will not be that serious. But in investigation, they are trying to see whether you are negligent in doing certain things or not, whether the IPs are negligent. Now, in that case, definitely the orders can be a little serious. So how to avoid that? Let's target that. And the best way, and the first tip which I can give you, and please mark my words, and I'm going to repeat it a number of times. The minutes of the COC will speak for yourself. Whatever you are doing, my dear friends, the minutes of the COC meetings will reflect, or SCC, of course, when the company comes into liquidation. So therefore, you have to draft them very, very carefully. Every material, you see, in every inspection or investigation, besides other compliances, of course, whether you have published Form G in proper places or not, that's something different. But every case is built by IBBI for inspection investigation based on COC minutes only. So therefore, my dear friends, please do not ignore that how do we draft minutes is very important. So they become your evidence later on, or rather, I would say they will become your defense mechanism. They will become your safety net. Now let's talk about safety net. How do we create a safety net so that the problems don't come? And COC, my dear friends, is the heart and soul of any CIRP. Naturally, it has to be facilitated by the RPs and the IRPs. Well, as an IRP or an RP, we all understand that you become the owner, not the owner, I would say you become the kind of CEO or the managing director of the company. You are whole soul in charge. If you are in charge, my dear friend, if you are having those kind of powers and rights, naturally the duties and liabilities will also come. So breach of right, the right always results in a duty, and a power may result in a liability. Please understand that. Look at IBC this way. Wherever your rights are there, duties will also be there. But wherever your powers are there, and if there is a misuse or abuse of power, a liability may come. Do my friends remember a section where even for misconduct during CIRP, the IPs can also be held guilty? Penalized, guilty in the sense and not in disciplinary matters, but also can be prosecuted. So those are certain sections, my dear friends, and section 70 is very important. Misconduct, punishment for misconduct in CIRP. And this is one section which says even the IRP or RP can be held guilty under this if there is a misconduct. So misconduct, how to avoid misconduct? Naturally, we'll have to be absolutely transparent. We have to be honest in our dealings. We have to treat corporate debtor as a separate entity. We have to treat the assets of the corporate debtor as totally independent. We are not the owners. We are not going to use those assets for our own personal benefits. Because you see, those kind of things can raise fingers. Now, assuming, let's take an example before I come to the other parts. Supposing you become a IRP of RP of a say hotel, hotel company, which runs a hotel or resorts or something like that. Can you use the premises which the resort gives for rent or for some functions and parties by you or your relatives? Well, some people may say yes, if we are charging the same amount of charges which are being charged to the others, what is the problem? Because it is an arm's length transaction. But according to me, you should not avoid these kind of situations, because you see, these can result in a problem tomorrow. And the employees, they are not loyal to you. They will definitely be loyal to the erstwhile promoters. You can take my word for that. So therefore, they will become a good source for complaints and other things. So let's be very, very, particular about insofar as the COC meetings and the minutes and other things are concerned. Because let's look at another aspect. I said COC is the heart and soul of this, because naturally most of the decisions are approved, ratified, and even your CRP expenses are ratified by COC. So managing COC, in fact, the last topic is conflict management. So you have to manage COC somehow or the other. Managing does not mean that you have to manage by, you can say procrastinating before them, or giving into whatever whims and fancies are there. I'm not saying that. I'm saying managing conflict in a polite manner, explaining them the legal position. Of course, we'll discuss that in the last session and with some examples. And if you have any questions also, we'll like to have a discussion. And friends, I also want to make it very interactive in the sense that you might have faced certain situations in COC, you might have experienced, and you must have handled them, right? So please come out with those issues so that everyone knows that what problems can come, or because nobody can anticipate any situation. So if we are able to contribute with our experience, then of course we can think of whether that solution which you found out was good or not, or what best could have been done. I think analyzing those kind of situations is always a good thing. But that we will do it in a little while. I have a small presentation on the COC aspect. So let's look at it, because, okay, I'll just try to share. Surabhi, do I have the sharing rights here? Yeah, I can see that. Okay. Okay, so I believe you are able to see. Okay, let me go to the first slide. Yeah, Committee of Creditors. Okay, so friends, let's talk about Committee of Creditors today, because the focus today entirely is on COC and various aspects. And we will be talking about the conducting meetings of the COC. So therefore, it is we need to go back and refresh our memories on the regulations, on the provisions which are given in the code. That's very, very important. And the second, of course, which is related to this, is compliances relating to COC meetings. Now, this is very, very timelines and compliances. Now, timelines are very important, isn't it? And you see, if there is some delay in compliances of the timelines, naturally, IBBI also comes down heavily. In the sense that if you are able to explain, like in one of the cases, I'll just tell you, there was a gap of 9 months between the 8th and 9th COC meeting, 9 months gap. Of course, that was during a COVID period. So now the question which was raised by the IBBI was why there is a delay. And imagine, I am defending the RP, and trying to convince the IBBI that, look, this was justified. Anyway, I'll tell you what was the fate of that case also in a little while. But these are the things which can come up. So your minutes and everything will defend you and can also expose you. Because if there is a too much of gap, they will notice it. Even if somebody has not filed a complaint, during investigation, inspection, they can find out and they can ask questions on that. So therefore, a complaint is only the starting point. But then when you supply all documents, then the material comes out of the documents which you supply to IBBI. So therefore, if your documents are absolutely correct, nobody will get a chance to do that. Then, of course, for IPs, what are the do's and don'ts? We're going to discuss about that. And lastly, the conflict management during COC meetings. It might be, I mean, I'm not saying I'm categorizing all these 4 issues, in 4 compartments of 1.5 hour each, but we may have some overlapping in these discussing those issues. Okay, I hope you will permit that to me. Now, friends, this is about meetings. So this is one quote. And it clearly says that people who enjoy meetings should not be in charge of anything. So naturally, as RPs, we are not interested in having meetings, but yes, we are supposed to do that. Okay. But don't start enjoying the meetings. Okay. So the majority of the meetings should be discussions that lead to decisions. Now that's very important. So, and you as a facilitator, being an IRP, RP or liquidator, I think you can make it happen. Depending upon what agenda is there and how you are taking the discussion. Taking discussion in a particular direction is in your hands, my dear friends. Let me share with you. And initially, when the IBC came in 2016, 17, 18, I could see many of the IPs did not have the experience to hold meetings, because naturally, if you are practicing as in your own profession, or in a bank or something, you may not have that kind of an experience how to conduct a meeting. So naturally, it was a learning process for all of them. So let's refresh, my dear friends, because COC points are very, very important. So if we go to the code, and I'm talking very broadly, I may not go into the finer details, but this is important. If you look at the code, my dear friends, section 21 is the very important sections which talks about committee of creditors. How the committee of creditors is formed, who will be their members, what are their, who can attend, who can participate, all those aspects which are mentioned in section 21. This is a section, I believe, which we must go through once again, isn't it? Okay. Friends, I also need the support here. We may need to, go through some of the provisions, not all. So may I request anyone who can help me on that, can open a book and volunteer themselves that, yes, I'm ready to read out whenever I require that. Anyone who can mention that in a chat box, or maybe you can open your video and say, yes, I'm ready to do it. I think that will be good. Okay, anyone who is volunteering? Otherwise, if you want me to read, then I'll have to read it. Okay.
Sir, I can read if it is required.
Okay. Thank you, Sandeep ji. Okay. Right. Great. Thank you. Okay. So not right now. Maybe at few places I will go ahead and tell you. Then we have section 24, which talks about the meetings of the committee of creditors. Now, this is also one of the important sections, that how the meetings are to be conducted, to whom the notice can be sent, and who can attend. Now, that's very important, and we'll definitely deal with it, because there are some judgments on certain aspects here. As far as the procedural part is concerned, how to conduct the meeting, what will be the contents of notice, those are part of regulations. We'll also talk about that. Now, this is also one of the important sections which we must not ignore. Approval of the COC for certain actions. In fact, this is the heading of the section, but the heading of section is a little deceptive. In fact, if you read between the lines and after the sections, it says prior approval. So in fact, the heading should also be prior approval of the COC for certain actions. So section 28 actions, my dear friends, require prior approval of the COC. Mark this one. No ratification, no post facto approval. It is prior approval. You will not go ahead and do anything which is mentioned in section 28, because it has serious consequences. So I'll talk about that in a little while. Then we have CIRP regulations. Of course, you are aware about the CIRP regulations, but these are the important ones. Regulation 21, contents of the notice for the meeting, very important for us to read. 22 talks about quorum at meeting. 23 deals with participation through video conferencing. 24 actually talks about conduct of meeting, how the meeting will be conducted. And then, of course, 25 and other provisions are also there. So I've not noted down everything, but yes, these are more important ones which I have brought to your knowledge. And of course, we are going to deal with them. So Sandeep ji, I would like to just want you to open 21, 24 and then see IRP regulation. So if you can just flag it, or if you have in a PDF format, then it's easier to.
So I have got it in PDF format.
Yeah, whatever you are comfortable with, right? I generally am more comfortable with the printed books and all. Okay, so friends, let's do this. Let's start with section 21. Section 21, my dear friends, makes the IRP responsible to constitute a COC. Now, how a COC will be constituted? The important aspects to note here is that the section says after collation of claims. Now, some people do ask me a question, supposing I have collated the claims, so should I form the committee right now, or I can form it after 2 days, 7 days, or is there any time limit? Friends, there are time limits which are coming indirectly also. But remember this, once you are done with collation of claims, you must form it immediately. I mean, I'm not saying as soon as possible, I'm saying immediately. Then there is no stoppage, because the formation of the committee is dependent upon the collation of the claims. And after collation of the claims, naturally, you will determine who are the financial creditors. And those who are financial creditors will become part of the COC, which we are all aware as per Section 21. And of course, if there are no financial creditors, then we will have to go to the regulations, and which talk about that top 18 operational creditors, one representative of workman, one representative of employees. That is, I think we are aware of that. And this is one of the important things also. The Section 21(1) clearly says that IRP must constitute COC after collation of all claims received against the corporate debtor and determination of financial position of the corporate debtor. Now, can I take advantage of the fact that, look, I have been able to collect the claims, but I have not been able to determine the financial position of the CD, so therefore I have not constituted? Well, friends, determination of the financial position is a very important aspect, and which can be obtained from the whatever latest balance sheets or the books of accounts available. But many times the promoters do not cooperate, and the books are there absconding sometimes, and the books of accounts are not available for the RP. So in that situation, whatever financial position you are able to get hold of it, once the claims are collated, I think you should constitute. You should not wait for that, oh, I was not able to determine the financial position, because that is a continuous process according to me. So that is the second tip, friends, that as soon as you are able to collect the claims, and collation obviously has some different meaning also. We'll come to that, because people do ask a question, what is difference between adjudication and collation? We'll deal with that. Now, this is Regulation 17. Now, Regulation 17 also talks about that IRP must file report of constitution of COC within 2 days of verification of claim. So if you are talking about the legal timelines, these are the timelines. So point is, now here the word is, Sandeep ji, can you just open Regulation 17 and read this specific sentence, what is written there as far as IRP filing of the report is concerned? Because then we will be able to move forward and we'll try to analyze. That would be 17(1). Yes, sir. But you will have to unmute yourself.
Yes, I'm unmuted now.
Yeah.
So regarding Regulation 17, this is subpart 1. So the interim resolution professional shall file a report certifying constitution of the committee to the adjudicating authority within 2 days of the verification of claims received under sub-regulation 1 of Regulation 12.
Right. Now, friends, what it says is that within 2 days of the verification of the claims. The Section 21 does not talk about verification, it talks about collation of claims. Now, here comes the confusion. Here comes the confusion. What do you mean by collation? What do you mean by verification? What do you mean by adjudication? Because there are 3 words which are being used differently. Friends, let's do one thing on this. The question which is asked typically to me is that, is it does the RP has to simply receive claims, and on the basis of the claims which have been filed, he has to merely collate it. Collation basically means making a list. That's all. This is the dictionary meaning of the word collation, collate. But the point is that this code is naturally to be read along with the regulation. So we'll discuss about that. But let's go here first, and I'll talk about those aspects. I think I've got a separate slide on that. So we all know that financial creditors are only a part of COC, but the related party financial creditors are not part of COC. Now, there was initially a confusion because the language of the section typically said that they have no right to represent, participate, and vote. So somebody said, oh, they are the members of the COC, but they will not be able to represent, but they will not be able to participate, but they will not be able to vote. So I said, if they are not able to participate, forget about representation and voting, then what is the point of their being members of the COC? So please mark my words, friends. A COC, they are not members of the COC if they are related party FCs, because supposing there are no other financial creditor, only related party financial creditors are there. Can you constitute a COC? The answer is no. So therefore, they are not part of the COC. Participate means kind of membership. Now, if you are not able to participate, then what is the point of being a member? So they are not typically considered as participation. Now, there is, in one of the judgments, there was a confusion. A director, because suspended directors have to be given notice as per section 24, we'll come to that. The question which came before the Supreme Court was that whether suspended directors who are related parties, will they also be covered under section 21? Because they are related parties. So will they be entitled to represent, participate, and vote? So that was a question which was answered in one of the judgments. We'll deal with that. So I'm just parking it right now because we are talking about theoretical things right now. And of course, voting share is determined on the basis of the financial debt owed. So I think all of us are aware the total of the financial debt of the COC members, that becomes the denominator. And then, of course, individual financial debt is the numerator, and then the percentage of voting share is calculated, which is quite simple. So whatever you have rejected, so it's not a claim filing, whatever you have collated after verification will become the basis. Now, if a person is a financial creditor and an operational creditor at the same time, because you can be in two hats, then naturally the part of the COC to the extent of amount owed as FC, he will become a part of the COC to the extent of the amount owed as a financial creditor, and voting share will also depend on that. Naturally, that's very logical, that if somebody is owed operational debt also along with the financial debt, so he will become a member of the COC only to the extent of the financial debt, which is very normal. I think I don't have to explain too much on this. Financial creditors in a class. Now, this concept, my dear friends, I think are aware, it was introduced primarily for the real estate matters, because there was a lot of hue and cry. And when section 5(8)(f) was amended, then these home buyers typically became financial creditors. Now, they becoming a financial creditor means now the committee of creditors will consist of, say, 10,000 members, 15,000 members, or maybe more than even 500, 600 is a large number. Then how the COC meeting will be held by the IRP or RP? Well, in that case, the law very clearly provided, and those are the amendments which came in section 5(8)(f), section 21(6)(a) was added, and 25(a) was also added. So if you are talking about the financial creditors in a class, my dear friends, you have to read these three sections: 5(8)(f), 21(6)(a), then we have to read 25(a), and two regulations, 4(a) and 16(a) of CIRP. So please read them all together. I think you will be able, I think you must be knowing it, but if you are still want to refresh your memories, that how an AR is selected and all that, those kind of things are. So AR will represent and vote. Now, this is crucial. I think we must deal with this also. First, you need to determine whether there is a financial creditor in a class or not. Right? That is extremely important, that those who are the people who are financial creditors in a class. Now, financial creditors in a class is dealt by, now this was a provision which was brought in, or amendment was brought in on 6/6/2018. And this section 6A is extremely important. And section 6A, Mr. Sandeep, may I request you to just read section 6A, clause,
Yes,
clause number A, then take a pause and then read clause B.
Yes, sir. Section 6.
Sir, I have a query.
Yes, sir.
Yeah. May I proceed, sir?
Yeah.
Sir, I appointed as IRP and I verified the claim within time and I submitted a report to NCLT.
Shreyansh, I will answer your question if you open your video.
Yeah, sure. Sorry.
It's important that we see each other, okay?
Yeah, yeah.
I'd like to see the smiling faces. I mean, of course, if you are in a position to open it. Yeah, okay.
Yeah,
Good.
Shreyans here.
Yeah,
Uh,
yeah.
yeah, I was appointed a IRP and claims were received and I verified the claims and I submitted a report to the NCLT, verification of claims. Okay, then on the same day, the CD was applied in NCL enclave for CD was submitted in NCL enclave for means stay for the COC constitution.
Okay.
So can I understand that the COC has been constituted or not?
Okay. I think that's a very important question which you have asked and very practical question. And in fact, there are one or two NCLAT judgments are there which says that when an appeal was filed before the constitution of the COC, what was why the IRP was in a hurry to constitute and hold the COC meetings. Now, this is sometimes it is a more of a practical question rather than any theoretical thing.
Yeah.
As far as theory is concerned, friends, the moment you are able to verify and collate, you have to constitute. There is no permission from the COC. There is no permission from the adjudicating authority required for constitution. Regulation simply says the moment you verify and the moment you constitute, you will have to file a report within 2 days. So after constitution, so AA does not come into picture. But having said that, sometimes what happens is that before the constitution, because constitution typically takes 10 to 15 days, and the promoters or the suspended directors, if they are filing an appeal, so naturally they also inform the RP that, look, we are in the process of filing it. And most of the IRPs, what they do is they are in a hurry to constitute the COC meeting so that they are appointed as an IRP. Don't do that, my dear friends. Don't do that.
Okay.
Give settlement a chance if that is possible, right?
Yeah.
But don't delay it too much. Supposing he has filed an appeal and no stay has been granted, right? If no stay is granted, then you are free to constitute. Or
Yeah.
and the best part would be the day the appeal is listed for the hearing, make sure you or your counsel is present.
Yes.
And please ask NCLAT, sir, can I constitute? If you have not constituted it so far, sir, should I go ahead with the CIRP? Seek clarification. And in most of the orders, they say, we are not staying the process of the CIRP. Sometimes they say that also. So take that clarity, but don't wait too much time. Supposing today the promoters has informed that the matter will be listed, but it is not listed for 30 days. I can't wait for that.
Yeah.
So therefore, if there is a delay, so this is based on facts and circumstances of each case.
Actually, CD has not informed us about that.
Okay.
We received a order after 1 day of the order given by enclave.
Right. So therefore, if the CD has not given you advance notice of the appeal, then naturally you are doing your duty as per the law. Nobody can put a blame on your head.
Then
Right?
the stay will be continued as given by enclave, or it will not be.
See, it depends upon the language. Supposing the NCLAT says that we are staying the constitution of the COC.
Yes.
If you have constituted already, right?
Yes.
Yes,
It is the situation.
So 1 day before constituted, but the stay comes later. But naturally, if you have already constituted it, you will not do any further action.
Yeah. I will not call for any COC meeting.
No, please do not do that.
Yeah.
If you do that, you will be in contempt. Otherwise, then second situation, when the matter is coming up for later on another date, before that date, you must file an affidavit saying that, look, this was an appeal which was filed. I was not informed. I did my duty as per the law and I constituted on so, and this order came to my notice on so and so date. But before that, I already constituted. But looking at the order, I have not called for any meeting of the COC. So therefore, please make your position clear by way of an affidavit to the NCLAT.
Yes.
I think they will consider that.
Okay. Thank you, sir.
Okay. Great. So now we were talking about financial creditors in our class. Now this is certain typical situation. First, you will have to identify. I think we were asking Mr. Sandeep also to read 621(6)(a) clause A. Yes, sir. Please go ahead.
Yes, sir. So in case of financial debt, it is saying that is in the form of securities or deposits, and the terms of the financial debt provide for appointment of a trustee or agent to act as authorized representative for all the financial creditors. Such trustee or agent shall act on behalf of such financial creditors.
Okay. So therefore, friends, if the financial debt is in the form of securities or deposits, like company has taken public deposits. Now, public deposits typically, or debentures, let's say debentures also. So debenture holders typically appoint one of the persons as a trustee. So generally IDBI trustees, ICICI trustees, there they have got those trustees there. So if they have appointed a trustee or an agent, then they will be considered as a class of creditor, and that will be the authorized representative. Authorized representative will be the trustee or the agent. So here, RP is not supposed to do anything. Find out the trust deed or the debenture trust deed. Then, as per that, whosoever is the trustee, he or she will attend as a part of the AR. That's the job becomes simpler here. The second, yes, sir. Please read B.
Okay, sir. So B says, is a financial where financial debt is owed to a class of creditors exceeding the number as may be specified other than the creditors covered under clause A or subsection 6. The interim resolution professional shall make an application to the adjudicating authority along with the list of all the financial creditors containing the name of insolvency professional other than the interim resolution professional to act as their authorized representative who shall be appointed by the adjudicating authority prior to the first meeting of the committee of credit.
This is very important, friend. Now, here you see there is one more question before I go into these details. Supposing there are supposing there are 15 financial creditors. I'm not talking about real estate right now. Normal, like 15 bankers, or say some private companies or NBFCs who have given loans to the companies, and they are not forming part of consortium. Now, the question that is whether they will be treated as class of creditors. People do ask me this question, and in fact, this was put in before one of the NCLT benches, and NCLAT also dealt with that. But at the end of the day, friends, we'll have to read section 6 also. Because if we do not read section 6, subsection 21(6), so we will be confused about it. So let me clarify for you. First, I think, Sandeep ji, can you read 21 subsection 3? Now that is important. First, we'll start with 21(3).
21.3, okay. Subject to sections 6 and 6A, the corporate debtor owes financial debts to two or more financial creditors as part of the consortium or agreement. Each such financial creditor shall be part of the committee of creditors and their voting share shall be determined on the basis of the financial debts owed to them.
So this section very clearly says that where the CD owes financial debts to two or more financial creditors as part of consortium or agreement, then these creditors shall be a part of the committee and their voting share shall be determined on the basis of financial debts owed to them. But the opening sentence is very important, subject to provisions of section 6 and 6A. Which means if there are debenture holders, naturally they will be represented by AR. But we will talk about that. Let's go to subsection 6 now, because subsection 6 becomes important.
Okay. So where the terms of the financial debt extended as part of the consortium agreement or syndicated facility provide for a single trustee or agent to act for all financial creditors, each financial creditor may, subpart A, authorize the trustee or agent to act on his behalf in the committee of creditors to the extent of his voting share. Subpart B, represent himself in the committee of creditors to the extent of his voting share. Subpart C, appoint an insolvency professional other than the resolution professional at his own cost to represent himself in the committee of creditors to the extent of his voting share. Subpart D, exercise his right to vote to the extent of his voting share with one or more financial creditors jointly or severally.
So friends, if the financial debt is a part of a consortium and they are providing for a single trustee, because sometimes in consortium funding, there will be single trustee or agent, even then the financial creditor has got an option. Number one, they can authorize the agent to act on their behalf, or they can represent themselves in the committee of creditors to the extent of their voting share. See, this is very important that even then you see the option is given. So insofar as the financial creditors who are bankers are concerned, now they, if it is in a consortium with an agreement, then they have a choice that one representative can go. Otherwise, they can go on their own itself, because their voting right and is obviously they can of course join hands with another creditor also, financial, like SBI joining hands with Bank of Baroda. Both of them can say, okay, one representative will be there and he will vote for their joint voting share. That is also possible, but typically that does not happen. So therefore, friends, if we look at the language of subsection 3, if we go to section 6, subsection 6, and then 6A. Now 6A gives you 3 situations where the AR is to be there. But it is not covering a situation where there are 12, 15 bankers are there, then they will be treated as class of creditors. That is not the situation. Because let's be very clear. So authorized representative will be into 4 situations now. Let's talk about that. The first situation is where there is a consortium agreement and there is a trustee. Then the financial creditors can go ahead with that authorized representative. 2, where there is a deposit or securities like debenture holders. That is the second situation, which is given in 6AA. Third situation is given in 6AB. Now 6AB is primarily talking about is owed to a class of creditors exceeding the number as may be specified other than the creditors covered under 6A. And then they will make an application with a list of all such financial creditors. Now, this was introduced primarily for the large number of the creditors, financial creditors, particularly if you ask me, for the home buyers. So here the name is to be given to the adjudicating authority, and the caution which you have to take is, of course, you'll have to follow 4A and 16A regulations. Those regulations are there. But the most important is, please do not hold any COC meeting unless and until AR is appointed by the adjudicating authority. Because what the IRP is doing, he is only selecting. So how the process goes? In case of a home buyer, naturally you will identify whether there are class of creditors or not. So this has to be done even before publishing a public notice. So you will publish a public notice and you will say that, look, these are the 3 names. And out of these 3 names, because you belong to class of creditors, so these are the 3 names which you have to select. So in any case, you will have to speak to 3 of your friends, 3 of your IPs, who will give their consent to act as an AR, and their names will be reflected in the public notice. And when the home buyers are filing their claims, then in that claim, you will find that they will have to give a choice of 1 name. So out of 3 A, B, C, they will pick either of them. Once the claims come, you will collate that information. Besides the claims, you will collate also the information about the ARs or the 3 IPs. The person who gets maximum number of votes. Here, the votes are not dependent upon the debt owed. My dear friends, please mark my words. It is not dependent on the debts owed. It is merely dependent on the number of votes. Supposing there are 500 home buyers and 400 have said A should be appointed, that is a simple arithmetic or majority you will have to find out. The person who gets maximum number of votes on the basis of the claims received. So 1 claim is equal to 1 vote. I hope I'm clear. 1 vote is not equal, 1 claim is not equal to the amount of the debt vote. No, vote is not equal to the amount of the debt. It is 1 vote. As far as AR is concerned, that's all. So the person who gets maximum kind of votes or maximum choices, now that person is naturally selected, right? Now, selection does not mean appointment. Once that selection is done, you will immediately move an application as an IRP, RP, or naturally you are IRP right now. So you will move an application to adjudicating authority for approval of his name. And once an order for approval of the name of the AR comes, only then you will be calling the COC meeting.
Sir, I have a question, sir. Sir, actually, this is very small. You see, sometimes, it takes a huge time to come the application on board.
Right.
For the approval of the AR.
Right.
So I have a case where more than, 45 days has been passed, but the application still has not been approved.
Right.
Now the question arises, the COC, just as you know, the COC cannot be held without the approval of the AR.
Correct.
So matter is still standstill. That means the IRP is nothing's doing actually, because not able to do anything because a COC is already delayed.
True,
So
true.
ultimately, all things comes to the IRP.
True.
So how to resolve this issue? These are the basic issues which day to day we are facing actually.
No, absolutely fine. I think, friends, I think Mr. Khatri, I believe you're also an advocate.
Yes, yes, I'm advocate side actually.
So,
I'm hardly doing any IP things, but however.
Right. So I know you know better than me also. But anyway, we'll try to answer this because everyone is facing these issues. Friends, delays at the NCLTs or adjudicating authorities are very, very common, right? We hope that with the new members coming in, the benches being strengthened, naturally they will be sitting for the whole day and not taking two benches at the same time. So therefore, the things are going to proceed in a better manner. And you see, we also have seen that the applications for approval of the resolution plans are pending for 1.5 years.
Yeah, that is another aspect.
Another aspect. So replacement of the RP also sometimes you see is pending. And then what happens is the earlier RP does not work because he knows that he has been replaced by the COC and the new one cannot take over. So those kind of issues are definitely there. And what Mr. Khatri is saying, my dear friends, is absolutely right. But my suggestion, and naturally, if there is a delay on the part of the NCLT, we should not be holding any COC meetings because it simply says, because the regulation also clearly says prior to that, I mean, the section clearly says that it should be done prior to that meeting. Because
that
supposing
there is a question actually, the learned NCLT has issued a notice. Why you have not, hold the COC only for want of approval of the AR? Actually, this is the complex question, the same regulations we are referring actually, but learned NCLT is not been able to consider. So the practical difficulty is the adjudicating authority. We are facing a lot of issues about this.
Yeah, see, that may be, you can say, an opinion of one bench.
Yes.
But typically speaking, we also know that judicial utterances at the time of the hearings do not form part of the order at many times.
Yeah.
So therefore, they are in power. They are naturally entitled to say whatever they wish to say. We respect them for that. But the fact of the matter is, like, let's take an example now. Supposing it's a case of home buyers only. In that case, generally the bankers are not there, isn't it?
Yes.
Speaking, there are no bankers.
Most of the time, yes.
So there are 700 home buyers are there. Now AR is not appointed. How will you hold the COC meeting? Who's going to attend? So if you see, this thing is brought to the notice of the bench that, look, my lords, this is the situation. How do I hold a COC meeting? You guys have to understand this.
Correct. So, who will obtain the instructions from the home buyers? IRP is basically doesn't have any divine powers to manage 600 people.
Right. And actually, you are not communicating directly with the home buyers. You always go through the ARs only. So first, how will you send the notice? Then who will attend the COC meeting? Then how the meetings will be carried on. If you are simply sitting in a COC meeting, now you can't hold a meeting on your own. There has to be somebody else. So therefore, I think, and the section very well defends you, 21(6)(a)(b). It clearly says it shall be appointed by the adjudicating authority prior to the first meeting. So which means you cannot hold a first meeting.
Correct.
So that's very, very important. So any delay which happens is on the account of NCLT. According to me, the IRP is protected to that extent. Only thing what you can do is, as lawyers, what we do is, we can keep on moving the early hearing application. That's all, just to show our bonus that we made an attempt.
Mr. Makhija, early hearing applications, most of the time, God knows where it goes actually. Most of the time, practical actually. I know.
But it comes to your defense. I'm telling you.
Yes, sir. I agree to that.
2-3 cases, IBBI questioned, and we said, look, we filed it. He said, okay, then you are okay with that. So please do that. Even if it doesn't, if I know it is futile, but please do that just to protect yourself.
Correct.
Okay. Thank you, Mr. Khatri.
Thank you, Mr. Makhija. So nice of you. Thank you very much.
Sir, may I ask one question here?
Yes, sir.
So, in my case, actually, I'm facing some practical situation.
Okay.
So it is not related to the discussion as of which is actually being held as of now. So thing is that you, in the very first slide, you mentioned that we have to ascertain the financial position of the CD.
Correct. Correct.
So regarding that very financial position, in my case, actually, what I'm facing actually is that the 2 years balance sheets are not prepared.
Okay.
So the last balance sheet prepared is of financial year 2021,
Right.
and I will actually basically calculate the entire thing. So I will do it as IRP. So thing is that whether I should regarding the suspended board of directors. So they are actually not cooperating in the very first place. So
Okay.
thing is that how this situation is to be handled. Who is to sign this very balance sheet? So what are the actually there are certain judgments which state that uh, the suspended board of directors are mandated to sign the financial statement. So what is your view, sir?
Okay. Okay. See, as far as the number one non-cooperation of the suspended directors, I believe you must have filed 19-2 also.
Yes, sir. Yes.
Right. That is, of course, the first step which we must do that. That's a precaution which we must do. Now, as far as signing balance sheets are concerned, and particularly for those years when you were not there, right? As an IRP, you are appointed in 2023 and 2021 balance sheet or 22 balance sheet is not there. So, and you don't have the books of, but do you have the books of account with you?
Sir, yes. So those are getting actually, we are arranging those very books of account from the directors as well as from various other sources.
Okay. Okay. See, there are 2-3 aspects which are important. As far as the requirement of the Companies Act is concerned, it clearly says that it must be signed by minimum 2 directors, right? So that is what it talks about. But if you look at section 17 of IBC, it says the power of the board of directors is now vested in the IRP or RP. So
Yes,
you are the board of directors. So you can naturally you are having all the powers of the board. So once you are having the power of the board means you can approve the balance sheet. You don't require the board meeting to happen. Naturally, no board meeting should be called, and you don't require that. But the fact of the matter is, as a matter of suggestion, I have also said in many of the other forums also, that since you were not there when these balance sheets or these transactions happened,
yes, sir.
is always important. And here comes the conflict management also, right? So it is not that the suspended directors are always the rivals. They will not cooperate with you because they don't know you, they don't believe in you, they don't have trust in you. And you have replaced them. Naturally, there is some kind of a friction. You see, initial friction is there. But
Yes,
if you start talking to them, right? You start approaching them, talk to them politely, call them to the office of the CD. They will actually gain confidence. And once they do that, I have seen in many cases, and I can give you a number of examples in real estate also, where initially they were absconding. The RP, due to his persuasive powers, please understand what I'm trying to say. Because of his persuasion, now they were good with him, and he was able to get their signatures on the balance sheet, which is always a good sign. And naturally, you will also countersign it because you are the board of director today, so your countersign is always required. But then in the notes to accounts, you must protect yourself. What is the protection?
Okay.
Yeah,
There
write as many notes, write as many disclaimers, write as many things which you want to write, because the data may not be correct. The data may be, you can say, very small. I mean, you may not get the full data. Auditor may be qualifying it. So before auditor qualifies, even in your notes, you should add odd disclaimers. So that's
one or two more things are there regarding this very scenario.
yeah.
So whether balance now, let's say if I am preparing the balance sheet from the basically the bank statements, maybe bank
Right.
statements or maybe some income tax document or GST document. So entire thing has to be collated and the balance sheet has to be prepared. So now thing is that whether balance sheet is to be prepared in the current date or maybe 2 years balance sheets are not there. Moreover, so whether I should actually take provisions regarding the impairment of assets like inventory, there is a huge inventory in this very unit. So whether those very provisions are to be made, huge receivables are there. Fixed assets are actually not much in that very actually company.
Okay.
So what is to be done, sir?
Okay. So see, these are very typical problems, but there are very no easy answers. But yes, there is a step by step what you have to do. Number one, if you do not have the books of account, right? If you have a books of account, then it becomes easier as part of the balance sheet because then you have the previous year figures and then you can do that. But if you don't have the books of account, then naturally you are recreating the books of reconstructing. We call it as reconstruction of the books of accounts, right?
Yes, sir, yes.
On the basis of the say bank statements or GST data or whatever data is available. So you are trying to reconstruct, but reconstruction may not be absolutely correct. You may be missing many things. You may be having the figures of the debtors because some debtor statement might have been given to the bank you get possession of. Similarly, fixed assets, I don't know how you're going to do that. If there is a fixed asset register, then you can do that. So on the basis of that, you will reconstruct the books of account. And this fact must be disclosed in the notes to accounts. That they were reconstructed on the basis of the data which was available because the books of accounts were not handed over or not available. So this is something which you need to protect yourself. And
so what about inventory? What about inventory? Let's say 24 crore inventory is there in the last balance sheet of 21. So
right.
as of now, little inventory is there. So what is to be done regarding this very practical situation?
Sandeepji, it's very simple here because as an auditor, when we audit the books of accounts, what we do, the inventories are always physically verified on the last day of the financial year.
Yes, sir. Yes.
If on that year you find there is nothing, zero. So naturally you will put the figure 0. So that means everything is written off naturally because opening inventory will be say 10 crores, closing inventory will be 0. It will form part of the profit and loss account. That impact will automatically come. But if the fixed assets are not there, then probably you will have to write them off or maybe charge them or you have to erase from the books of account. So those are the on impairments and everything have to be followed. So if you are not finding anything, naturally it has to be charged. So who is answerable? Answerables are the suspended board or the previous employees. But put that in the notes and disclaimers.
Okay. Okay. Thank you so much.
Otherwise, you are preparing on a very minuscule information which is available. Okay.
Thank you.
Sir, one point here, sir. Please.
Yes, sir. Sir, I am not able to see you, sir.
Sir, actually, my camera is not working.
Okay. Okay.
I have tried a lot of times. Sorry for that. Though
Okay.
my video is open, still I'm not visible. Sir, what happens in this case? Sir, the power of the board of directors is suspended, not their duties. Signing of financial statements or filing of report and returns are part of duties, not power. So the suspended board of director, they must be compelled to sign such documents. That's my opinion, sir.
See, you may be right in one sense, but let us look at the practical issues, right? The duties, and initially I also mentioned that duties naturally come from the rights. Now, if you have suspended their powers completely, now who is the board of director today? You are the board of directors. Now, you are holding a board meeting. I mean, naturally, you are the only one who is attending it because you have the powers of the board. You need not call any board meeting. So you will decide that X will sign. So then X will sign. That's good enough. But that's what I'm saying. You should make an attempt that you see the directors should sign it. But supposing the directors are absconding, even if you go to NCLT, how will you force them to sign? So there may be practical circumstances which will be there.
Sir,
So
my question is on point of law. Sir, if the law says the person who is in power, it is his duty, then those people, they will simply deny to sign or to they will simply refuse. But if the position of law is that it is their duty, not power, then they can be pressurized. That is my simple point, sir.
Mr. Jena, let us understand. Please, let's look at it. IBC is a unique thing, right? And there are provisions which clearly say that IBC will also override the Companies Act. We are all aware of that fact. So if the directors A are absconding, B they are refusing to sign. Can you force somebody to sign it? You cannot. You go to NCLT, NCLT will also not pass the orders for signing. And even if they pass the order, they don't sign. They say, sorry, we are not signing it because we are not sure of the facts of the case. So you can't force somebody to sign. Can somebody force you to sign on a document which you don't want to sign?
Then in that case,
I don't think.
Sir, just one line. Then in that case, the non-compliances which has remained, that should remain as it is. Because the IP, the IRP or IRP, it is not his duty to get it compliant. If for last 2 years it is not filed, then let it be remain unfiled. So why should RP take the responsibility of getting it filed?
My dear friend, I think we are just talking in a different aspect now. You know that as far as your duties are concerned, you have to comply with all the laws. And that provision also was modified and put it in the law itself. So compliance of all the laws is your responsibility, including if there is a non-filing of GST returns or income tax returns or even with the ROC. So what I'm trying to give you a solution, friends. Let's not be rigid about anything, right? Directors not signing, they are in jail, they are absconding, they have run away from India. How will you get it signed? That does not mean the company will not function today. So therefore, it is important that we should know how to proceed ahead. Let's not get fixated that if the directors don't sign it, well, I will not prepare the balance sheet. Let there be non-compliance. I don't think, sir, that's a good idea.
Sir, I will prepare the balance sheet only for this year,
sir,
not for previous year. That I'm telling.
Mr. Jaina, we are not in an argument here, right? If we
Sir, I'm not arguing, sir. I am just putting just to know it, sir. I'm not arguing.
Let me complete my things also. Now, first, you need to really understand what I'm trying to say. I've understood your point, and this is not your only problem. It is a problem which comes in most of the CIRPs, and it's not a new thing. It is coming from 2017 and onwards. And today, still the suspended directors are aware of the fact, right? And they start cooperating because they know that they have to do it. Earlier, when in 2016-17, when this law was new, they were totally non-cooperative. I'm telling you, the situation has changed over a period of time. Today, they are more cooperative than what they were cooperative in 2017. So all I'm saying is, I am giving you the steps also. A, please use your persuasive powers, discuss with them, and try to get it signed from them, which is very, very important. If for any reason you are not able to get their signatures, there is a refusal. In fact, in one of the cases, they refused. We went to the NCLT and NCLT called them. They said, why you are not signing it? And naturally, then they said, okay, sir, this was an issue. He said, okay, sit down with the RP and sign it. So naturally, they were able to do that. I'm saying use that whatever in best way it is possible. But for some reason, they are absconding, you're not able to trace them, then what is the option? If you sign as a board of director, nobody can stop you. The only thing is you need to protect yourself because it's an old information. It is a half-baked information. It is a minuscule information. So there you have to take steps to protect yourself, write as many disclaimers as possible. And you can also, the auditor can also say that, look, this balance sheet does not represent true and fair picture. That's all right. I mean, I can't do any damn thing. I'm only making a compliance and I am making the best endeavor to comply. That's all. Nobody is forcing you to sign. But the only thing is, if you, whatever data is available, you have made all your effort in 19.2 to get that data, to cooperate. But on that basis, whatever information is available, please get it done and so that the compliances can be done, right? As far as you were talking about duties and other thing, friends, please tell me, you take away somebody's power and you say you are still under a duty. Does that happen? Powers and authority, responsibility and authority, they both go hand in hand. You can't say that you don't have power, but you are still under a liability to sign it. So therefore, looking at from that angle, that's also not, correct. So use your persuasive powers, go to NCLT, try to get an order. If not, and still there are, because if you don't sign a balance sheet, income tax return will be pending because you need audited balance sheet. So therefore, compliance is a responsibility of the RP, and IBBI, my dear friends, has issued show cause notices to many when these non-compliances are there. So we are stuck in between. So therefore, we must do everything in our power with all the disclaimers, whatever is are there. Okay. I hope I'm clear on this.
So just one point related to this, as we are discussing this very thing. So one point is like, let's say now 2.5 years balance sheets are, financial statements are pending. Moreover, so what I've come to know is that GST filings are pending, income tax filings are pending, company law filings are pending.
Correct.
So in that very case, let us say if I reconstruct the financial statement on this very date, so what is my actually duty regarding the previous filings which are pending with various statutory authorities, and whether I should reconstruct the balance sheet in the current date only and forget about the previous 2 years which are for which balance sheet is not filed.
See, the point is, let's try to understand. Can you read section 17, subsection 2, clause number E?
1 second, sir.
Yeah, please do that, sir.
So this is from the act you are saying.
Yes.
Okay.
And this was a specific clause number E was added on 6/6/2018. Now, why it was added? Because of this reason, what the question which you are asking.
Okay,
Earlier it was not there. Originally it was missing in the IBC. Please read 17(2)E.
Okay, sorry. 17(2)E, yes, sir. Yes, sir, it is there. 17(2)E. So, sir, it says that it's part 2 starts from interim resolution professional vested with the management of the corporate debtor shall be responsible for complying with the requirements under any law for the time being in force on behalf of the corporate debtor.
Sir, does it leave for any confusion?
It doesn't leave for it doesn't leave any confusion, sir. But the thing is that since the data is not available, so
sir, you have to understand one thing, sir. I think I have repeated this in number of forums also earlier also when this provision came. As an RP, if you do not have data, can you do something?
No.
Supposing आपके books of account ही नहीं है, कुछ भी नहीं है, bank statement भी नहीं है. Can you prepare a balance sheet? The answer is no. But the only thing what you need to do is compliance here means, mark my words, friends, compliance is equal to endeavor to comply. Please understand my words. Here, compliance will be read as endeavor to comply. I must take proactive steps to comply. That's all.
Okay, sir.
Now, if somebody raises a finger upon me, I'm able to show that I took these steps. Like, as I asked you a question, your directors are not cooperating. I asked you whether did you file 19(2) or not. See, this is an endeavor. Now, if you say I don't have a data, but you also on simultaneously don't file 19(2), then IBBI will come after you. I'm 100% sure. So you can't say, so did you try and write to the bankers? Did you try and write to the income tax department for the last, you see, income tax return or GST return? Because you can get that data from all the government authorities. You have read E, na? Please read D also. 17(3). That gives you so many powers.
So it says that the interim resolution professionals shall have the authority to access the books of accounts, records, and other relevant documents of the corporate debtor available with government authorities, statutory auditors, accountants, and such other persons as may be specified.
But the most important word is government authorities here.
Yes.
Like earlier, when we were, you see, practicing as a chartered accountant or a company secretary, income tax department used to call the company and the chartered accountants for information. Here, it is reverse now. You will call upon the income tax officer to give you the information. So you can write to excise department, you can write to ESI, PF, get whatever data is there. So today, if I don't do that and say, sorry, sir, I did not get any data, then naturally NCLT is watching you and IBBI is watching you. So therefore, please read very carefully. So compliance, my dear friends, is equal to endeavor to comply.
Yes,
and endeavor to comply will be the steps which you are able to show that you made efforts to get that data. Now, supposing you get an information, in one of our cases, the RP got an information that most of the books of accounts were kept by EOW, right? So they took away. Now, RP came to me, he said, sir, what should I do? I said, go and write to the EOW department, get a copy. If they are not releasing the original, I can understand, right? Ask them the photocopies of the complete set. What is the problem? And ultimately, the EOW said, sorry, you have to go to that PMLA or whatever before that court, they will allow you. Fine. We went to that court, we asked for it because of the IBC, they allowed. So you will have to take steps. That's all what I'm saying.
Okay.
So whatever best is possible to reconstruct. Okay.
Okay,
I
sir.
think this is one
Thank
of
you,
the
sir.
important aspects. Yes, sir. Okay. So we were talking about the authorized representative. So authorized representative is very important that he should be appointed by the adjudicating authority. Now that is extremely important that it should be appointed by them. And only then naturally you will, hold the COC meeting. Now, here is one of the important aspects, friends, which you need not, which you should know and should not ignore. Now, this is also one of the questions which is asked to me. The section 21 very clearly says, if you read subsection 9 and 10 of section 21. Now, what does it say? It says the committee of creditors, they have got the right to furnish, to ask the RP to furnish any financial information in relation to the corporate debtor. And RP, if this information is sought for by any financial creditor, then it should be furnished within 7 days of the requisition. So this is very important, friends, that if any financial data or financial information is asked for by the financial creditors, or rather I would say not financial creditors, if the committee of creditors, then naturally the RP must comply with that. So please remember, this is another timeline compliances, because I'm covering the timelines also along with this. This is very, very important. Okay, I think we have discussed few of the issues, but there are many other issues which come up. And I'm going to deal with some of the issues. And if any other issue comes to your mind, so please tell me so that we can have a discussion on that. So I have just noted down a few of the issues which we discussed earlier also. Whether adjudication of claims is the responsibility of IRP or RP. Now here, there are three words which when we started, we noted down: collation, verification, and then adjudication. Adjudication word, my dear friends, if you ask me, it is completely missing from CIRP. You will not find neither in the code nor in the regulations. Now, where do you find the word adjudication? Now, adjudication is the word which is found during the liquidation. Now, liquidation is where we will find that word. And in fact, even adjudication is not written there. It talks about admission or rejection, primarily which is written there. So if you look at section 40, let's go and read section 40 of the IBC also along with this. Rather, we'll start with 39. 39 talks about verification of claim. This is in liquidation. Then the liquidator shall verify the claim. So verification word is there, right? And for verification, subsection 2 is very important of 39. It says that for verification, if you need to ask any document or any other evidence, then you can ask for that. Then section 40 comes in. He says that liquidator may, after verification, either admit or reject the claim. And naturally for the reasons to be recorded, right? So reasons have to be given. If you are rejecting, if you are accepting, then probably you may not give any reasons, but if you are part rejecting it or you are completely rejecting it, then reasons are to be given. And then naturally your decision becomes appealable. And that appeal can be filed under section 42. And here, my dear friends, this is very important. Once you reject, there is an order which is passed by you, that is a rejection with the reasons. Now, a person can file an appeal. And this appeal does not go to NCLAT, but it goes to NCLT. So here, please remember, even adjudicating authority becomes an appellate authority to that extent. I mean, it's not an appellate authority, but to that extent, because they are now dealing with an appeal. And then here, the unique feature of IBC is this person gets 3 chances of appeal. First, the first appeal goes to an NCLT, second appeal can go to NCLAT, and third can go to Supreme Court. Because your order is there. So here, because you are adjudicating, appeal is only against an adjudicating order. So therefore, it is known as adjudication under liquidation. Now, this part is missing. The part of filing an appeal against your this thing is missing. Naturally, if you reject somebody's claim in CIRP, what happens? They go under section 60 subsection 5, which is an application for that RP has rejected it. So please direct him to allow my claim. But that is not an appeal. So therefore, because it is not an adjudication. Now coming to the CIRP part. CIRP section 21, we have seen it uses the word collat. But if you go to, my dear friends, if you go to the regulations, right? So IRP and RP will collat after substantiation and verification. Now, this is the word. Collation does not mean, my dear friend, 10 people file claim. You simply make a list that A's claim filed is 1 crore, 10 crore, 20 crores, and then total is this much. This is not simple collation. Making a list is not collation as per CIRP. What you need to do is you need to do substantiation and then verification. Let's go to that part where that substantiation and collation verification is mentioned. If Mr. Chitkara is there, Mr. Sandeep, are you there? Okay, I think we are missing him. So regulation 10, I'll just read it for you. Regulation 10. Yeah.
So I'm here only. I'm here only.
Yeah, I'm so sorry. I was not able to hear you. So can you just read regulation 10 and regulation 13 of CIRP?
Okay.
Regulation 10, my dear friends, calls for substantiation of the claims, and regulation 13 deals with verification of claims. So there is a differentiation. Yes, sir. Go ahead.
Okay, sir. Regarding regulation 10, the interim resolution professional or the resolution professional, as the case may be, may call for such other evidence or clarification as he deems fit from a creditor for substantiating the whole or part of its claim.
So please remember, friends, the same line was written in section 39, subsection 2. You can call for information for verification. So here the word uses substantiation. For substantiating the whole or the part of the claim, you can ask for more evidence or more documents. You have got full authority. So it is not mere somebody filing and you are collating it. If NCLT tells you to do that, they're sadly mistaken. That is not the role which is required. In fact, we also faced, I'll quote you one of the instances where I was able to convince the bench. Now let's read regulation 13. Yes, sir.
So regulation 13, verification of claims. The interim resolution professional or the resolution professional, as the case may be, shall verify every claim as on the insolvency commencement date within 7 days from the last date of receipt of the claim, and thereupon maintain a list of creditors containing names of creditors along with the amount claimed by them, the amount of their claims admitted, and the security interest, if any, in respect of such claims, and update it.
Yes, sir. Just stop here. Rest, of course, is sub-regulation 2 is a little different. But here, friends, we always look at, within 7 days we have to do it. That's fine. Timeline is all right. But please look at the word which is used in the second sentence. Shall verify every claim. It is mandatory that after collation, you have to substantiate and you have to verify. This is what I've written on my slides. IRP, RP to collat after substantiation and verification as per regulation 10 and as per regulation 13. Now, there is a very thin difference between adjudication and verification, friends. I mean, the Supreme Court has said RP does not have adjudicatory powers because you're not passing any order to that extent. But at the end of the day, if you ask me, it is actually admission or rejection of a claim, isn't it?
Yes,
because if you are not able to substantiate something, naturally you will say, sorry, I'm not able to verify your claim. And that is nothing but rejection. So therefore, the confusion which has come out from one of the judgments is, no, the RP does not have adjudicatory powers. It is coming from Swiss ribbons. It is coming from earlier other judgments also. But be that as it may, my dear friends, let's do our duties. Let's not be bogged down by adjudication word or substantiation or verification. What we need to do is, number one, we will, whatever data claims are filed, we will naturally try to substantiate because we need proofs. Like a home buyer says, I have paid 50 lakh of rupees. 30 lakhs he has provided you receipts by way of a check. But 20 lakhs he says, I paid cash. But he has got a receipt. Now this is very crucial. He has got a receipt. But when you go to the books of account, that 20 lakhs is not accounted for. So therefore, you are not able to substantiate. Therefore, you are not able to verify at times. So those are the things which you will face in a practical aspect. So therefore, I would say that verification is a very, very important part. In fact, this question, as I was telling you, came to us in one of the cases. And two ARCs, not small ones, right? ARCs, they filed huge claims, roughly around 210 crores to the RP. RP was not able to, he rejected after complete verification. He carried out his activity and he said that this claim is not a genuine claim. So therefore, he did not admit the claim. Naturally, those people went to the adjudicating authority. Now, adjudicating authority, and an argument was taken that, look, he is only responsible for collating. There is a Supreme Court judgment. I said, my lord, Supreme Court judgment is fine. I'm not disputing that. Nobody can quarrel. It is binding on me also. But let's look at Regulation 10 and Regulation 13. Do I have to do my job with my eyes closed? Or do I have to substantiate and verify? And here is the verification which I did. And if I have done this verification, I find that their claim is not genuine. Now, if you feel that their claim is genuine, please allow. I'll admit that. So I am putting now the onus on adjudicating authority. And when they went into the facts of the case, they said, yes, you are absolutely right. This claim cannot be admitted. So it has been rejected rightly. So therefore, my dear friends, all I'm saying is this. If you are substantiating, if you are verifying it, please have your reasons ready. If you are rejecting it without any rhyme or reason, then you will be in trouble. So therefore, please make your case what you are trying to do, but don't accept any claim blindly. That is one part of it. Okay. There may be some other questions relating to this. Yes, sir.
Sir, can the RP admit time-barred claims?
Okay. Good question, sir. I'm just parking it. I'll answer it. Okay. Time-barred claims. So whether the IRP or RP should collate on the basis of the claims filed without verification, the answer is no. I think I've already explained it in detail. Collation does not exclude verification. We have already read Regulation 10 or 13. So collation, after receiving, there will be substantiation, there will be verification, and then it will be equal to collation. So collation is equal to, my dear friends, if you want to write down a formula, collation is equal to receiving plus substantiation plus verification. This is the meaning of collation. Adjudication is also another form of a verification, but it is little more stricter in that sense that now in liquidation, you will have to pass a specific order, giving reasons specifically, and then telling it pie by pie. But here you are doing it on the basis of the whatever documents are available. So, I mean, if you ask me, in liquidation, it requires more scrutiny than the CIRP. Now, another question. A claim which is admitted in the CIRP, can it be rejected by the liquidator? The answer is yes. The person who has filed the claim, he may have a good case. Oh, IRP admitted, why you are rejecting it? Well, because I have to independently examine it. Of course, naturally, if a claim has been admitted, I will be more inclined to admit that claim, no doubt about it. But if I still find that IRP also admitted it without any proper basis, then naturally I can differ with them. So this is another aspect, friends. So do that. But it will not happen in 99% of the cases, but in 1% of the cases, that is also possible. Okay, another question before I deal with our friend's question. What about the claims not filed but appearing in books of account? Books of account show creditors worth 210 crores. Claims filed only of 100 crores. Now, what happens to 110 crores? Should you admit those 110 crores on the basis of the books of account? Or should you not? Okay, Before I answer this, I would like to have some views from our friends here. So,
in my opinion,
yes, sir.
You should communicate to the creditors
Okay. Sir,
and
communicate.
get the response from this.
Okay. Okay. This is one. Okay. We will discuss about it. Yes, sir. Any other thing, sir?
Sir, we can admit up to the claim amount only. Maximum amount of admission can be up to claim amount only. If claim amount is 100 crore, we can admit up to 100 crore.
So you are saying that as per books of account, if there are more than that, we should not admit it. That's what you are saying?
Yes, that I'm really saying that we can claim up to the claim amount.
That means the reverse side is not as per books of account, right?
Yes, yes.
Okay. Okay. Yes, sir. Any other view? Okay. I think I agree with Mr. Jaina, and very clearly, friends, this is the practice which you also need to adopt. Let's go back and try to understand the basic concept first, and then we will come to that answer. Why the IBC requires a notice to be published for submission of the claims? If we were supposed to admit on the basis of the books of account, what was the point of calling for a public notice? So public notice has two purposes, friends. Let's understand. Let's go behind. There are two purposes. Number one, only genuine claims should come, because books of account, my dear friends, can be manipulated. 100 claims might have been entered as creditors, but they are not genuine claims because promoters have done that manipulation. So therefore, only genuine claims will come. So this is the purpose of one of the public notice. Number two, some claims which are not reflected in books of account, they may also come because the books were manipulated. Their claims were not recorded in the books of account. So it is not necessarily that only those claimants will come whose names are entered in the books of account. There may be extra claims also, isn't it? Which the promoters might be hiding, not accounting for the liabilities. So this is the dual purpose of publishing a public notice. So books of accounts per se, my dear friends, are not treated as the base, are not treated as genuine. Yes, you can take a support, no doubt about it, but you will take it with a pinch of salt. So therefore, the purpose is that the claims as per the books of account should not be admitted. Now here I'll give you another example. Mr. Sandeep Chitkara Sahab, can you go to the liquidation regulations now?
Okay.
I'm going to liquidation process regulations. I'm going to show you something and it will open up your eyes. Probably some of you may be aware of it. And this will also support our view, mine and Mr. Jaina's view. And because I want to give you logics and reasonings behind it, rather than saying, oh, you should do this or you should not do that. That's okay. But it is important that we must understand this. Yes, sir. Are you able to open, sir?
Sir, give me 1 or 2 minutes. Give me
Okay.
1 or 2 minutes. I
In
have
the
to download it.
meantime, yeah. Please download it. In the meantime, I'll just continue it.
Sir, which regulation, sir, in liquidation?
Yes, sir. Regulation 17. Have you got it, sir?
Yes.
Sir, just read very quickly 17.1, 17.2. I mean, maybe at a glance. We don't want the full reading.
Yeah.
Yes, sir.
Regulation 17, claims by operational creditors.
Yes, sir.
A person claiming to be operational creditors of the corporate debtor, other than the workman or employee shall submit the proof of claim to the liquidator in person, by post or electronic means in Form C of Schedule 2.
So sub-regulation 1, my dear friends, as our friend has read, is that a operational creditor shall file in such form and in such manner and in the way it is to be done. That's fine. 17.2, if you look at the 17.2, our friend will read it. It talks about that these are the evidences which you can attach, right? And the existence of the debt can be proved by way of records which are available or other relevant documents and so, right? Record available with information utility. It doesn't say record available with the corporate debtor. So there are only 2 sub-regulations there. Now, sir, can you go to regulation number 18?
Yes, sir.
Similar things?
Yeah. Claims by the financial creditors.
Right.
1. A person claiming to be a financial creditors of the corporate debtor shall submit the proof of claim to the liquidator in electronic means in Form D of the Schedule 2.
So same thing, same language which was there in 17.1, 18.1 is a repetition, but only thing is it changes the form, that's all. And it also changes the mode, right? Here it is mentioned that it will be submitted in electronic form because other things are not permitted here. Now, subsection regulation 2 again talks about the existence of the debt can be proved by way of the following documents. So simple, end of there. Now, please go to now 19, sir, regulation 19.
Yeah.
First of all, sir, tell us how many sub-regulations are there?
In 19.
Yeah.
4, sir, 4.
In 19, there are 4, isn't it?
Yes, sir.
And in 17 and 18, friends, mark my words, there were only 2.
Yeah.
Now, why there are 4? Let us read 1, 2, 3 first. Forget about 4 right now. 1, 2, 3. Yes, sir.
Shall I read one or
19,
1? 19. Okay. A person claiming to be a workman or an employee of the corporate debtor shall submit the proof of claim to the liquidator in person, by post or electronic means in Form E of Schedule 2.
Yes, sir. So here 19.1 says if a workman wants to file, this is the form. Now let's read 19.2.
Where there are dues to numerous workmen or employees of the corporate debtor, an authorized representative may submit one proof of claim for all such dues on their behalf in Form F of Schedule 2.
So this is a facility, my dear friends, which has been granted to employees and workmen because they may be illiterate, they may be spread out. So they say instead of filing individual claims, one person acting as an AR can file a common claim. So this is a special provision which is mentioned in for the workman. It was missing in operational creditors, missing in financial creditors. So this is an extra regulation. Now, regulation number 3, sub-regulation 3, 19.3 is similar to what we have in 17.2 and 18.2. It is ditto, right? It is the same language.
Yeah.
19.4, my dear friends, is something which is extra. Yes, sir. Please read 19.4 now.
The liquidator may admit the claim of a workman or employee on the basis of the books of accounts of the corporate debtor if such workman or employee has not made a claim.
Yes, sir. Now, friends, did you notice a difference? This sub-regulation 4 was missing in financial creditors, was missing in operational creditors, and this is missing in the entire CIRP. Please remember, I can go back to now CIRP regulations, claims by FC, claims by OC. This sub-regulation 19.4, similar thing is missing everywhere. What does it say? It says that if any of the employees are not able to file the claim, then the liquidator may, the word is may, it is not shall, it is your discretion, may admit the claims of the workman on the basis of the books of account. Here comes the books of account for the first time. So friends, please mark my words. Now here comes the logic and the reasoning. The legislature, the parliament, or the IBBI, of course, who created these regulations with the open eyes, gave a facility to the workman that look, you can file either individually or jointly by representing through someone, or even if you don't file a claim, your claims may be admitted by the liquidator on the basis of the books of account. But this facility for the books of account is not given to FC or OCs. So if I you see, give a reverse logic now, apply the reverse logic to CIRP, this is entirely missing in CIRP. So therefore, my dear friends, we can conclude, and as Mr. Jaina also mentioned, we will not admit claims on the basis of the books of account, except in liquidation and except only in cases of workmen and employees. We can do that. It's not that it is mandated. We may do it because those people are considered as at the bottom of the, you can say, the chain. So therefore, some facility, additional facility is given. And our country naturally works, you see, for the benefit of the workmen and the employees for that matter, isn't it? That was the logic that this was put in. So therefore, my dear friends, and another logic I've already given, that the claim in the books of account may be manipulated. Some are missing, some are wrongly entered. So idea of public notice is that we should invite claims And when we invite claims, my dear friends, then we will have to collate them. So you will not admit any claim without receiving it, without substantiating it, without verifying it. I hope I'm clear about it, friends. Okay.
Sir, one small query here.
Yes, sir.
Regarding, as you said, regarding the invitation for the claims. So one thing is public announcement, which is
Right.
actually mandated by a regulation
Right.
in the CIRP regulations. So other thing is like what exactly what process is to be followed? Like let's say we give the public announcement in one regional newspaper and one other newspaper, the national daily. So
Right.
that process is done. So now thing is that maybe regarding GST or various government bodies or various other authorities, so they usually say, and there are various judgments on that, that they skipped this very public announcement, and so they didn't receive any communication from the IRP regarding the claims, regarding the invitation for the claim. So what is actually your thought process, sir, and how should this be done?
Okay, I think you see the law is very, very clear, friends, and I think let's go about it. And I will deal with one of the judgments, and particularly the confusion started from Rainbow also, right? Rainbow judgment also created some confusion, which I'll deal with that. But having said that, the basic principle applies to all, whether they are government dues, whether they are operational creditors, whether they are financial creditors. No claim will be admitted unless filed. Number one. And naturally, the announcement is made on the website and also on the public announcement. Here, you must take one precaution because there are certain cases of disciplinary inquiry against the IPs also. Please make sure that when you are issuing public notice, you do a wider publicity to that. I mean, I'm not saying if your company is small, say 50 crore or 10 crore turnover, and you're publishing all over India, spending 10 lakh rupees on advertisement, I don't want that. I'm not saying that. Look at the scale of operation of the company. Supposing if the company was operating pan-India, naturally the creditors may be located pan-India. Then you may not like only to restrict it to say registered office or principal place of business or any other. Maybe you can say where the factory is, you will also publish at that location. And sometimes like publishing in Delhi and Mumbai may be costly. But if you include all other pan-India along with Delhi and Mumbai, naturally it becomes cheaper. Sometimes it becomes cheaper, right? Publishing in all editions becomes sometimes it's cheaper. So take a call depending upon the scale of operation, depending upon the location of the offices of the company. Give it a wide publicity. Because most of the claims, those people who don't file a claim and they file the claim late, which you reject, naturally they go to NCLT. Can you believe what are the reasons which are given? Sir, I was abroad, I did not see. That is one. I was under a medical this thing. Third, which is a very interesting in one of our cases, he said that the RP did not publish at a place where I was residing. You are supposed to do that. Are bhai, how? I mean, I supposing somebody is living in Hisar, should I include the Hisar edition also? That's not possible. Let's try to understand. Law, we'll have to follow the law. Registered office, mandatory. Principal place, which you have to identify, right? Or any other place where the operations are carried out. This is also mentioned in regulation. So please be little broad on this, on the basis of data which is available. If you scrutinize Google, you go to MCA's website, and if you are able to get hold of balance sheet, then you know where your assets are located and where the factories are located. So do it, give a wide publicity. That is what I can tell you. But of course, spending should be minimum. You cannot spend 20 lakh rupees just on the public announcements only. So
Sir, in addition to this very public announcement, should the IRP go for maybe communicating through emails and whatever other mode has to be there?
Yes. I think one of our friends has raised that aspect. So friends, let's understand this. Can I distinguish between a normal creditor and a government creditor? I am writing to the income tax department, but I'm not writing to any sundry creditor. This will be too inconsistent. Then that creditor can come and say, you gave a notice to income tax department, they are operational creditors, why didn't you give me the notice? So friends, let's understand this thing. You are not supposed to give that notice. अरे भाई यही काम करते रहोगे तो फिर CIRP कैसे करोगे? Please understand, CIRP is a certain process which requires publication. That's all. Your job is over. You are not supposed to write individually because you may not have the addresses. You may not have the email IDs. सबकी आप क्या स्पीड पोस्ट चिट्ठी बनाओगे पहले, फिर उसको पोस्ट करोगे? If you don't have the email IDs, and in books of account, sometimes the address is also not written. And some are companies, their addresses, then will you go to MCA, find out their addresses? And if they are a partnership firm, where you will go? So therefore, there will be inconsistency. So don't do that, my dear friends. Under the law, please mark my words,
Sir.
you are not supposed to do that.
Sir, there is one regulation 6A in the CIRP regulation,
Yes, sir. Yes, ma'am.
which says that IRP shall send a communication along with a copy of public announcement made under Regulation 6 to all the creditors as per the last available books of account of the corporate debtor through post or electronic means wherever the information for communication is available.
This is, see, the point is, this is the position which has come recently. Now, this I was
Yes.
coming to, right? So thanks for pointing out. In any case, I was trying to come. So this 6A, what our friend is pointing out, this was added in September 2022.
Yes. Sir,
Now,
I have a question relating to this, sir.
yeah,
So if if a case is admitted before this regulation has come up,
right.
then is that regulation applicable to that specific case which is admitted before this regulation?
Okay. Typically, you see, we all understand the law that any amendment which is made, it is always prospective in nature. So it will not apply to the past things. But having said that, I will not say that it will not apply totally, because this is something which should have been done at the beginning, right? So suppose
Yes.
the time period is passed, naturally today you will not go back, because those 60 days for filing the claim, everything is over. So naturally you will not go back. But assuming there is another, say, regulation which has been added, that you have to reconstitute COC based on this, then if it is applicable, then you will apply to that. So typically speaking, it really depends upon the situation. It is all situational, because
But
these are procedural. So procedures can be changed middle way also. Like you remember that in liquidation, formation of the SCC was modified, and then it was applicable even for existing liquidation also. So the existing liquidator also changed the constitution of SCC as per the new regulations. So it is sometimes it is always prospective, but it may apply to you also. But here, in this case, you
sir,
can't
if a claim is filed after filing the resolution plan with the AA,
right,
a claim has come after that,
right.
and now they are claiming that since 6A has come up and I have not communicated this to them via email.
Your best defense is that, look, this particular clause came effect from 16/9/2022.
13 September 22.
13 September or 16 September, whatever it is.
Okay.
So if it has come from, say, a particular date, then the claims were invited, say, in January 2022. The time limit was, say, 15 days, and then 90 days have also gone. End of the story. So you will not be responsible.
If that was in August, then?
See, even if it is in August and the time limit to file the claims is still there, right? Then naturally you may comply with this.
Okay.
Then you should comply with this, because that time frame has to be there, because then it is applicable from that date. So that is there. Anyhow, so let's look at 6A, because 6A, what our friend read is there. But if you look at the proviso also gives you a leeway. What is that? It says where it is not possible to send the communication to the creditors, the public announcement which is made under sub-regulation 6 shall be deemed to be communicated to such creditors. So regulation 6, which talks about the public announcement, is good enough. Because the problem which arises is you do not have addresses, you do not have emails of the creditors. So therefore, this proviso has also been given to modify the to change that. So with effect from, so now let us look at the entire scenario. Number one, the law which says that you do not have to communicate has been modified in September 2022, which says that a copy of the communication must be sent to all the creditors. Therefore, if you look at, if this amendment was not there, you were not supposed to do it earlier. So now with this amendment of 6A, there has to be a communication to the creditors, wherever you are able to find their addresses. If you are not able to find the addresses, then naturally the public announcement will work. But there also, again, you must take precaution that you must publish it at a places which is required, right? Where the operations are there, the principal place and everything must be there. Okay, I hope we are clear on this. This is very important that we must go ahead with this. Now,
So, sir, but regarding this very 6A,
yes,
which
sir.
is pointed out, so endeavor has to be there from the IRP.
Yes, naturally. You'll have to comply with effect from. That is why I was coming to. First, I wanted to make you clear about that position. Then I wanted to show you that this is the change which has been brought in September 2022. So that is why we all are here today to look at the amendments also. Okay.
Okay, sir.
Okay. So now the claims which are not appearing in the books of account, naturally we will have to comply with the you can say the regulation 6A, which is there, because that has come in now. Okay, so let us go further, because in most of the cases the position are also not there, right? Now there is one more aspect. Before I deal with that time barred kind of a thing, let's look at a very important aspect also. And I'll just try to share. Okay, yeah, right. Now, this is another aspect. What is the position of the claims of the allottees who are not filing the claims? One was the other creditors, right? Today, another aspect is the position of the claims of the allottees. Naturally, you will communicate. But even after communication, supposing you know, because sometimes what happens is in one of our cases, where the RP was there of a real estate company. Now, in that real estate company, there were, say, 500 allottees were there. Out of 500 allottees, only 300 filed the claim. 200 did not. Now, after 69, now this was the case prior to that, so individual notice was not sent. But after 6A insertion, now that notice also has to go. Assuming you have sent that notice also, and still 200 people have not filed the claim. Now what will happen? So friends, will you admit the claim on the basis of the books of account? The answer again comes no, because if that was the case, then what was the need of inserting 6A? 6A says that you have to send a notice to file the claim. Now, if they are already appearing, because if we read 6A once again, the IRP shall send a communication along with a copy of the public announcement made under Regulation 6 to all the creditors as per list available in the books of accounts of the corporator. So 6A is not telling you to admit the claims as per the books of account. It is simply telling you to send them a notice to file claim. So therefore, my dear friends, as per books of account, you are not going to admit the claims. That's the basis. Filing of the claims is important. Now, sending communication, not communication, that of course has been now amended now. So this is very important, friends, which you must take care of. The other aspect, particularly in case of allottees. So you notified them, they still do not file it. Say 100 are missing. Now, if the claims are not received, the resolution applicant who is submitting a resolution plan may not deal with them, because he's supposed to deal with the claims which are received. That what is the haircut he's giving and some other things. This was our understanding, isn't it? But this understanding, my dear friends, has undergone a change because of the judgment of NCLAT, and particularly in respect of real estate matters. And here is this. Please go to the judgment of Puneet Kaur versus KV Developers. This is a judgment of the NCLAT dated 1st June 2022. There were, in fact, you see, 5 appeals which were there. They were disposed of by a common order. But the lead case is Puneet Kaur versus KV Developers. Now, let me give you some background of this case to really understand. Okay. In this case, what had happened? The allottees were there. And naturally, this case was prior to 6A, because 6A was added later. So prior to 6A, it was there. So no individual notice was also given. Now, if the individual notice has not been given and still the claims have not come, then what is the situation, how that is to be dealt by the RP? That has been clarified in KV Developer. The RP did not receive these claims, did not inform in the information memorandum. RA, while submitting the resolution plan, did not talk about them in the resolution plan. So that means their claims, the people who have not filed claims, were not dealt. Now, bench, while considering this, naturally they were sympathetic with more with the home buyers, because in case of home buyers, they have deposited say 50 lakhs or 1 crore of rupees, and tomorrow their claims do not come, and RA does not deal with them. So can he take away their money and don't give them flats? Now that's a question. As a human being, you go on a sympathetic factor, on an equity. Of course, the courts are not there to go on equity. But this thing happens. So the same thing happened there, because a large number of people had not filed a claim in KV Developers, and they were not dealt in the resolution plan. And the mistake which the RP did, which you are not going to do, my dear friends, is that he did not mention this in the information memorandum. So what you need to do is, this is the another tip which you must take. So forget about real estate matter. I'm talking generally now. The books of account show 200 crores of creditors. Claims received are only 100 crores. 110 crores are not filed. You must mention that fact in the information memorandum, that as per the books of accounts, the creditors are this much, only this much claims have been received. Your duty is over. So all you have to do is that give that information or data in the information memorandum, because that is also an important document, just like minutes I mentioned earlier. Similarly, your information memorandum will come to your rescue at many times. Here, it did not come to the rescue of the RP, because they say that it is an admitted fact that such claims were not disclosed in the information memorandum. So therefore, my dear friends, a person who is filing a plan, he needs to take a call. If he takes a call on the basis of the claims admitted only, then he may be missing some hidden liabilities later on. So therefore, it is very important that all the liabilities and assets must be disclosed as per the books of account also. And in fact, if you go to regulation number 36, which talks about information memorandum, it gives you all those details, that you have to give the details of the assets and liabilities as on the insolvency commencement date. So as an ICD, you'll have to make efforts to get that data and mention that. So please do not make that mistake, so that otherwise strictures can be passed. So it is your duty to disclose all liabilities, whether claim filed or not, in the information memorandum. And then second, this is one part. KV Developer in the same breath also says that it is the duty of the resolution applicant to deal with such kind of claims also. So there should be a mention. Whether he says, I'm giving 100% haircut to such people, but there has to be a mention. The dealing of their claims must be there. typically speaking, in the real estate matters, now what people are doing, what the RAs are doing, they say that even if the plan is approved and if the claim not filed, but filed after, say, 6 months or 1 year from the date of approval of the plan, will also be considered by the RA. And then he says, from these people, I will charge 1,000 rupees per square feet extra or 500 rupees per square feet extra. That's all right. But there has to be something mentioned about them, right? You may not equate them with other home buyers, because if somebody is filing claim late, naturally you will not give them the advantage of that. And you can also fix a period that 6 months after the approval of the plan resolution, plan approval, I'll still consider them. But if you don't want to consider that, please mention that. So you say that claims not filed will tantamount to haircut or whatever you want to say. So deal with that. And not only RA, it is the duty of the RP to see whether they are dealt with or not. So you have got now twofold duties. Number one, mention and disclose all the facts in information memorandum so that it comes to your second safety net. And third safety net is, please see whether it is dealt in the plan or not. If it is not, you can't force anyone to make it, but you must bring that fact to the notice of the COC, record that in minutes. Again, I'm coming back to the minutes. Minutes will become an evidence later on. Everything you do must come in minutes, my dear friends, because it will come to your rescue at one point or the other. So that is extremely crucial, my dear friends, that we must do. Okay, I think we don't have a break in between. No? We have to straight away go for lunch.
Yes, sir, I think it is so.
Okay, so we started at 9:30. We are almost at 11:30 now. Okay, so what time we have to go for lunch break? 1 p.m. or what?
1:30, sir.
1:30.
This is 12:30, sir.
12:30, sir.
9:30 to 12:30, right? And then 1:30 to 4:30.
Sir, you please take a 5 minutes break.
No, that's all right. I mean, if we need a break, we can take a 5 minutes break. Otherwise, I'm okay with that.
Mr. Makhija, we appreciate all. Actually, you have a good amount of patience. I mean, so much of speaking and so much of knowledge actually you're throwing.
Right.
Very nice. I appreciate all this.
No, I thank you for that. But do you want a break or?
Of course, 5-10 minutes of
Okay.
break. Actually, we
Let's-
needed it.
Okay, let's do that. So it is right now. It is 11:30. Let's come back and meet at 11:35. Let's have 5 minutes foot break. Okay. Right.
Okay, sir. Okay.
So we just mentioned that in a chat box whether we are taking a 5-minute break. Friends, welcome back. I think we can start now. So I'll request everyone to please join back. And as usual, I'll request everyone to please open your videos if possible so that we can start. Okay. So, friends, we were talking about KV developer. I just want to show you a few of the issues which were there and what was the view of the bench. I think this is extremely important for you to take care of this. So let me share my screen once again, and we will deal with this particular case. Yes. So this was the judgment. I think probably you would have noted down Puneet Kaur versus KV developer. Very important judgment insofar as real estate matters are concerned. But it gives an idea, and this can be emulated in other matters also, where the claims are not filed. So what exactly needs to be done? So these were the one. This was one of the issues before the bench, whether the resolution professional was obliged to include the details of the home buyers as reflected in the records of the corporate debtor in the information memorandum, even though they have not filed their claim before the RP within time. I think it can't be more clearer than this. So we can apply this to all claimants, not only to the home buyers, right? Please make it a practice. And the second question was whether the resolution applicant ought to have also dealt with the resolution plan regarding home buyers whose names and claims are reflected in the records of the corporate debtor, although they have not filed the claim. So therefore, the treatment, whether what treatment should be given to the people who have not filed the claim, whether you will, if you are remaining silent, will it be treated as a haircut, or what will happen to that? So those kind of treatments must be mentioned in the plan itself. So what does it say? The bench in its order noted that the claims of the home buyers who could not file their claims, but their claims were reflected in the record of the corporate debtors, ought to have been included in the information memorandum. So very clearly they are saying they ought to have been included in the information memorandum, my dear friends. And the resolution applicant ought to have taken note of said liabilities and should have appropriately dealt with them in the resolution plan. So they are not saying that you must provide for them. They are saying, please deal with them in appropriate manner, appropriately deal. So this is what it has been mentioned. So appropriate dealing is also to be seen by the RP and advise COC if it is not appropriately done. Your responsibility is over after that. Then so therefore mention it in the IM. So this is the takeaway from this judgment. Mention it in the IM and ensure that their claims are dealt appropriately within the resolution plan. So these are the two takeaways, particularly from this judgment.
Sir, the word appropriate is quite subjective.
Sir, in law, most of the things are, you see, what is appropriate under the circumstances, you'll have to see to it, right? Like I'll give you an example. Supposing, say only 80 crore claims have come and 400 crores have not come. Will you say I'm writing off 400 crores? I mean, I'm talking about the real estate. That cannot be appropriate. So under the circumstances, you will have to deal with that. Give them an opportunity to file their claim late and claim their flats also. So this is something which is very particular to the real estate. For the other creditors, naturally, you can say that 100% haircut and other things are there. So appropriate will depend upon all circumstances. So, sir, law always cannot explain and and mention that this is appropriate, this is not. Okay. I think two more questions were asked. One was about the government dues, which were asked by Mr. Sandeep, and another was for the time bar. I'll deal with that. Let's talk about first how to deal with the government dues. The government dues, which are there like for excise, income tax, and many others. And there are certain typical things. I'll talk, about certain things. Let's take an example. Okay, friends, before I deal with that, tell me how many of you are chartered accountants here? Are there any CAs out there? Yeah, or maybe professionals like company secretaries, cost accountant. Many of you would be aware, right? Let's see one thing. The TDS, which is deducted by the company, tax at source on payments given, needs to be deposited with the tax authorities. If not done by the corporate debtor up to the date of ICD, Do you think income tax department will come to know of it and file a claim about it? I mean, you may have credited in your books as far as the income tax is concerned, but income tax department doesn't know how much is to be deposited. So can they file a claim? The answer is no. So these are certain typical situations of the statutory dues. But anyhow, that apart, why the confusion arose as far as the government dues are concerned. So let me share my present PPT. Just give me a moment. Okay. Yeah, I just shared that. So why the confusion arose, I think also needs to be explained. So how to deal with the government dues? And what is the effect of the Rainbow Judgment 6th September 2022 of Supreme Court? Now, what does this judgment say and why the confusion arose? Let's deal with that because that is extremely important for us to know. Friends, in Rainbow, two statements are, you see, mentioned. Two things are mentioned, my dear friends. And one of the important aspects which is mentioned in Rainbow is that the timelines in IBC are directory. This is a very strong statement which was made. I'm not dealing with that because at the end of the day, we are not talking about the COCs and other things. But the two other aspects which are very important. Sales tax department was not required to file any claim before the IRP or the RP. This is what is mentioned in that judgment. And the third statement which has been made, which caused confusion, was the resolution professional failed to include the sales tax department in information memorandum as per books of account. So again, we are coming back to the same thing, isn't it? That is why I said KV developer apply it in all cases nowadays. So what they are saying is that RP should include the claim of the sales tax department. In fact, it was a GVAT and the information memorandum. To that extent, my dear friend, there is no quarrel. Is there any quarrel? The answer is no. If it is appearing in the books of account, mention it. It's your job to give a financial position as per the whatever is available. The second is little riskier. It says sales tax department was not supposed to file the claim. They say IRP should have admitted it. Now here, this particular thing caused a lot of confusion. But friends, let me tell you why this confusion arose and why this is not applicable currently, right? This is also very important. Whether you will follow blindly the judgment of Rainbow, the answer is no, my dear friends, because things have actually changed, right? Now, what is the change which has happened? Friends, I think I can request one of our friends to just open Regulation 7 of CIRP. I think if you are able to open it, please open it.
Yes, sir. Yes, sir.
Yes, sir. Yeah.
Claims by the operational creditors.
Yes, sir. Just read the sub regulation 1, sir.
Okay. A person claiming to be an operational creditor other than workman or employee of the corporate debtor shall submit claim with proof to the interim resolution professional in person, by post, or by electronic means in Form B of the Schedule 1.
Yes, sir. Friends, what I want you to draw your attention to is, please take a highlighter if you have and highlight the words submit claim with proof. This is the word which is written. This is written in Regulation 7. This is also mentioned in Regulation 8. This is also mentioned in Regulation 9. And this is also mentioned in Regulation 9A. Right? 4 regulations are there for submission of the claims. And in all these, it is written, the operational creditor, financial creditor shall submit claim with proof. Underline this and highlight this. So it is clear that you have to file this claim with the proof. So filing of the claim is primary and then proof is secondary to it. Obviously, it has to accompany that. But remember, my dear friends, submit proof of claim with proof was substituted. It was not there in the original. in the original, and this was changed on 4/7/2018. Please write down this date, 3rd July or 4, with effect from 4th July. In fact, this was a notification dated 3rd July 2018, but it was effective from 4th July 2018. What was the earlier language? The earlier language was shall submit proof of claim. There is a placement of words, English, the meaning changes. Now let me read it for you. Submit claim with proof, which is now appearing. That means you have to file a claim along with proof. Clear. What was earlier? Submit proof of claim. So the Supreme Court actually got hold of this because this was a case prior to 3/7/2018. Remember this. So that is why I am saying Rainbow does not apply now, my dear friends. Why it does not apply, my dear friends? Because of a simple reason. They were persuaded by this word, submit proof of claim, which was appearing prior to 3rd July 2018. The Supreme Court said the sales tax department was not supposed to submit the claim. It was appearing in the books of account. If the RP had any doubts, they should have written to the department to ask for proof, to submit proof. Because they were only supposed to submit proof. They are not supposed to submit claim. Please remember this. The words have been played very smartly by the Honorable Supreme Court. But friends, let us look at the current situation. That situation is gone because that was a case prior to 2018 amendment. All cases now fall after 2018. So it will not apply. So Rainbow doesn't apply to you. Very clear. Because today it is the duty of every claimant to file a claim with proof. So this is, friends, Mr. Rajiv, can you mute yourself because my voice is... Okay, thank you. Okay, so friends, this is very, very important. So you will not admit any claim unless filed, including that of common entities. But what is your duty? Again, coming back to Rainbow as well as KV Developer, mention it in the information memorandum. This is what Rainbow also says, that RP mention in the IM. So mention it in the IM, your job is over. So whatever is appearing in the books of account, mention that, but don't admit the claim without filing it. That is not your job. Even Rainbow does not apply. I made a distinction also, friends. Okay. This was very important that I should talk about this. Okay. So, and in any case, my dear friends, we also must take into account that Rainbow judgment is pending for review. The review of Rainbow is pending. But having said that, my dear friends, let me show you the latest development also, because I think that is also important. Let me share my presentation again. Rainbow review is still pending in Supreme Court. Now I think it is listed somewhere in the month of September now. So maybe we may see the light of the day. But whether what happens in review, we don't know. But we have got some idea. Let me show you what the idea is. This is a judgment, my dear friends, which has been rendered by Honorable Supreme Court very recently. Pashchimanchal Vidyut Vitran Nigam Limited, let us call it as PVVNL. Okay, PVVNL. Pashchimanchal Vidyut Vitran Nigam Limited versus Raman Ispat. This is again a Supreme Court judgment, and let me share my next slide. Here it gives a detail. And friends, one more thing. I don't know whether you are aware or not. If any judgment comes, the courts always look for a citation, isn't it? SEC, AIR, so and so, right? Isn't it? We remember that 2002, 1 SEC 402. 2002 is the year, 1 is the volume number, SEC stands for Supreme Court cases, 408 is the page number. So this is the way to read the citations. Typically, any bench or any court will ask for citation because it is easier for them to find by the citation and not by the name, because name can be very common in those cases. But Supreme Court, with effect from 1st July, my dear friends, going back to 2023 itself, they have started given their own citations now. So this is the judgment which says 2023 INSC stands for Indian Supreme Court. 625, this is the number dated 17 July 2023. So if you start giving this citation number also, it is now will be acceptable in the courts, because Supreme Court has started the process of giving their own citations, right? So therefore, if you give this citation only, you will be able to find the judgment from the Supreme Court's website. And this is good enough. You don't require now SCC or AIR citations. This is one thing which I wanted to tell you. In fact, Delhi High Court started it much earlier. So in fact, Delhi High Court started giving its own citation 2 years back, but now Supreme Court has also started doing it. Now here, what are the facts of the case? Now this is very important, but please remember, friends, this was a case under liquidation. This was not a case under CIRP. But we can apply similar principles to CIRP also. This is what the Supreme Court also talks about. Here, what was argued by PVVNL was they were a distribution licensee. Naturally, for distribution of electricity, a private organization is given a right, because we know that it has been bifurcated. Transmission and distribution have been bifurcated. Transmission is typically done by the government electricity corporations, and now, of course, private players are also there. But then there is a distribution. Distribution is done by some other player. So they were distribution licensees, PVVNL. And they argued that their dues must be given priority over the secured creditors, must be paid in priority of other dues being the secured creditors, because of rainbow judgment. What rainbow judgment did? Okay, let's talk about first. You see, we talked about rainbow in a very brief manner, only relating to those two issues, but let's try to understand rainbow in other sense. In rainbow, there was a claim of the sales tax department under Gujarat Value Added Tax Act, GVAT, Gujarat Value Added Tax, Section 48. Section 48 says two things. It says that the claim of the sales tax department, which may include interest and penalty, that means the claim plus penalty plus interest, they shall have the first charge over the assets of the company or the entity in default, whatever. Because they are not using the word corporate debtor, they're using the word entity or company. So what the law is saying, that any dues which are payable to the sales tax department, which may include the tax amount, interest or penalty, it shall be the first charge over the assets of the company. So now the question before and the argument before the Supreme Court was that, look, because of the operation of law, the dues of the sales tax department are secured creditors. They become secured creditors. And the Supreme Court said, yes, you are the secured creditor. Why? Because they went to IBC, Section 3, subsection 30. Mr. Sandeep, can you open that? Section 3, clause number 30 and clause number 31. They talk about secured creditor. There is a definition of secured creditor, and then there is a definition of security interest. 330 and 331, right? So 330, sir, have you opened it? You are muted. Okay. So
Shall I read it, sir?
yeah, please go ahead, sir. Read it. 330.
Secured creditors means a creditor in favor of whom the security interest is created.
Yes, sir. So let's understand the meaning of this. Secured creditor means a creditor in whose favor the security interest is created. Right? So now we have to know the meaning of security interest, which is given in next definition. Yes, sir. Please go ahead.
Security interest means right, title or interest or claim to the property, created in favor of or provided for secured creditors by a transaction which secures a payment or performance of an obligation and includes mortgage, charge, hypothecation, assignment, and encumbrance or any other agreement or arrangement securing a payment or performance of any obligation of any person, provided that the security interest shall not include a performance guarantee.
Okay. Friends, if you look at the definition of security interest, which was just read by our friend, it has got two parts to it. First, it said security interest means. So it's a meaning definition. Meaning definition, as you are all aware, this is always restrictive, right? Whatever is written, only we'll have to apply that meaning. We can't go beyond that. So it says right, title, interest, claim, and so forth. But then it says and includes. So it is an inclusive definition also. So typically you will find definitions as meaning definitions or inclusive definition, but there is a third category, meaning and inclusive both. Including means the examples which are written after the word inclusive or includes, they are only illustrative, they are not exhaustive. So it can include something more than that also. So they are only just citing by way of an example, like mortgage, charge, hypothecation, assignment, encumbrance, or any other arrangement or agreement. So the Supreme Court said, Section 48 of this GVAT Act secures the amount of these dues of these creditors. There is an encumbrance because it is treated as a first charge. So it creates an encumbrance on the assets. It is covered in the inclusive part. Therefore, sales tax department has security interest and therefore they are secured creditors. This is the logic which they have given and I do not dispute that. Friends, let's not dispute that. Yes,
sir.
Sir.
One question here, sir.
Yes, sir.
Sir, here it is secured. Security is created by the application of law.
Correct, sir.
Sir, like that, under Sales of Goods Act, the unpaid seller, suppose a supplier has supplied some raw material and he has not been paid. So that supplier has general line over the raw materials that I have. So in that case, will that supplier be not treated as a secured creditor?
Okay. Good question, sir, but the answer is no. I'll give you the logic also. If you go to this Sales of Goods Act, it only creates a lien. And lien, my dear friends, what does it say? Lien means that you have in possession. That means, supposing you buy certain goods from, you see, X, like you go to a shop to buy a TV, you pay 50% of the dues of the TV, and you tell him to supply, just listen to me, sir, and you ask him to, okay, I think there are some background noises are coming. May I request everyone to just mute? Yeah, thank you. So you say, okay, then you deliver that. But the supplier says, no, give me 100% payment first, only then I'll deliver. Now he's an unpaid seller to that extent, 50%. Now that seller has got a lien over that property. Lien means it is in his possession, he may not deliver you. Lien is that got meaning. So therefore, there is no question of secured because he has already got possession of that. Lien is always linked with the possession. You can create a lien only on a property which is with you. The property which is not with you, then if you are creating, then it is treated as a mortgage or a charge or a hypothecation. It is not lien. There is a difference, my dear friends. So therefore, the seller may not supply it to you and can recover his, then he can sell it to somebody else because he's an unpaid seller. That goes according to the Sale of Goods Act. But as far as that is concerned, they are not considered as a secured creditor because that word is also not covered here. Because see, even if in inclusive definition, do you remember that we'll have to apply for the rules of interpretation, rule of jusdem honore? That means something similar to mortgage, something similar to hypothecation, something similar to charge, something similar. It can't be a different category altogether. So the charge which was created under the Sales Tax Act was actually a charge. And charge is included in the word security interest. So therefore, the Supreme Court said that is the secured creditor. I hope, sir, I'm clear on this. Okay, let's move forward. So to that, I do not fault Supreme Court. And that is fine. In fact, In the latest judgment of PVBNL, the Supreme Court has admitted that fact that they are secured creditors because of the operation of law. There is no agreement between the sales tax and the company, because generally the charge is created by way of an agreement, right? You enter into an agreement with the bank, hypothecation agreement or whatever. But this is a charge which is created by operation of law, which cannot be faulted with, my dear friends. The another question will come whether Section 77 of Companies Act will apply or not. That's another question. We're not dealing with that, because Section 77 is also a very typical section, which was 125 in Companies Act 1956. Section 77 of Companies Act, where it says that a charge which is not registered, it will not be taken into account by the liquidator. It is only for liquidation. And it applies to the liquidator appointed under IBC also. And that amendment was done after IBC. So therefore, we can't say that IBC will override a Companies Act. Here, amendment was made by way of an IBC only. Schedule 11, if you read Schedule 11, it amended Section 77 of the Companies Act. So it was a part of the amendment only. So therefore, there is no question of overriding any other. So we'll have to take into account Section 77 also. So if the charge is not registered, well, should it be binding on the liquidator? Well, that's another question. We will deal with that separately. In fact, that question has also been dealt in PVNL in a very smaller way, because there's some situation was different. But anyway, I'll mention that. So let's come back to our presentation now. So as far as security interest and secured creditor is concerned, no quarrel. Okay. Okay, one more thing which I want to show you is, okay, let's do one thing. Okay, let me share something else. Okay. These are all Microsoft. Okay. I just want to share with you, I wrote one article on, just give me a moment. I don't know why I'm not able to share it. Yeah, okay. Now I think you can see. Okay, I believe you can see the PDF now. Okay. So this was an article which was published in the Resolution Professional, the journal which is published by IIIPI ICI. And I wrote it for them, and I had analyzed this. I can share this PDF also. I think you can also get it from their website. So this was what was mentioned here. Look at this. This was what was mentioned by the Supreme Court in its judgment. Timelines in IBC are directory. Sales tax department was not required to file any claim. RP failed to include the claim of the sales tax department in the information memorandum. Sales tax department is a secured creditor. Right? We have covered all these four. We have discussed. Let's go to the fifth one. Section 53 of the code does not override Section 48 of the Gujarat Value Added Tax. Because if you read Section 53, any of our friend can just read the opening sentence of Section 53. Because it says, notwithstanding anything contained in any other law for the time being. I think that's the word. Can somebody read that?
Yes, sir, I can read that.
Yeah, please read, sir.
Okay. Sir, one second. It says, sir.
Yeah, notwithstanding anything contained contrary to the contained any law enacted by the Parliament or any state legislature for the time being in force.
Correct. So then the proceeds from the sale of the liquidation estate shall be distributed in the following manner. So manner of distribution is given in Section 53, which says, notwithstanding anything contained in any other law, contrary to this. So if some other law says, pay me first, well, sorry, we'll ignore it, we'll go to that. But here the Supreme Court says that Section 53 does not override 48. Number two, security interest could be created by operation of law. This we have already seen. Now here comes two more things. Of course, this is plan not meeting the requirement of Section 30 subsection 2 is invalid. Friends, can we have all the mics muted, please? Thank you. Plans not meeting the requirement of section 32 is invalid. We all know that 32 is to be complied, and it should see that it should conform to it should comply with all laws. So they say then it will not be binding on the central government or another. If the resolution plan, now look at this. If the resolution plan, I'm reading H. If the resolution plan ignores the statutory demands payable to any state government or legal authority altogether, the AA is bound to reject the plan. Now, this is something which created a lot of confusion. First, they say you don't have to file the claim. So the claim should be admitted on the books of account. And if the plan also ignores statutory demands, then the AA should reject the plan. So look at this scenario. It caused confusion. Resolution, and this is something which came out of nowhere. A resolution plan must contemplate dissipation of those debts in a phased manner, uniform proportional reduction, or else the company would have to necessarily be liquidated and assets sold and distributed. Friends, this paragraph written in the same manner, I had to read it 5 times to understand. Dissipation of debts in the phased manner, uniform proportional reduction. I'll explain you what does it mean, but anyway, let's look at the last. The COC, which consists of financial creditors. Now, this was a very important statement. There are strictures against COC. Cannot secure their own dues at the cost of the statutory dues owed to any government or government authority, or for that matter, any other dues. So all this judgment said was that it is giving a priority to the statutory dues. A, they are secured creditors. And if any of my friends will read section 53(1)(b). Sir, can you just read 53(1)(b), sir?
Yes, sir, I'll read.
Yes, sir.
The following debts which shall rank equally between the amongst the following: 1, workmen's dues for a period of 24 months preceding the liquidation commencement date, and 2, debts owed to the secured creditors in the event of secured creditor as relinquished security in a manner set out in section 52.
Friends, we are aware that waterfall mechanism is given in 53. 53(1)(a) talks about pending CRP cost and liquidation cost to be given the topmost priority, right? We call it a super priority. Then the second priority comes to 2 parts, two kinds of creditors. One, workmen, only up to 24 months prior to LCD, their dues. It does not mean that if they have dues more than 24 months, they will not be paid. It simply says that up to 224 months, they will be paid under this level, that is level 53(1)(b). And if they are more than 24 months, they will be paid as a remaining debts and dues, right? So that is also there. But the second sentence is very important. The subclause 2, it says debts owed to a secured creditor. Underline the word secured creditor. It does not write the word secured financial creditor. It simply says secured creditor. So now, if statutory dues become secured creditor, the question that arises is, should they be paid under the level 53(1)(b), or should they be paid under level 53(1)(e)? Because that was original. The government dues were included under 5th level, 53(1)(e). Isn't it? It says any amount due to the central government, state government, including the amount received to be received on account of Consolidated Fund of India. So, or the state. So that comes under 53(1)(e), 5th level. Now, in a case of CIRP, you must be wondering how come section 53 comes? And why Rainbow considered that? Because that was a case under CIRP or the resolution plan. Well, my friends are aware section 32 is a very classic case, 32B particularly, isn't it? So it refers to section 53 for the creditors who have not voted against and so and so. And otherwise also, if you read section 30, subsection 2, the last subsection also says that it must comply with all the laws, right? I think in 33 or 32 it is mentioned. So we have to comply with all laws. It does not contravene any other law. Yeah, I think that is the statement which is written there. So they say it is contravening 53 because the priority has to be seen in accordance with section 53 and they are secured creditors. So how can you ignore? Though, despite the fact we are aware of this fact that secured and unsecured have no relevance as far as CIRP is concerned. Their relevance comes 32 applicable to 53 only. So anyhow, this was a problem in this was a judgment. Anyway, I have given some solution also. If you look at my article, I've given a table how to distinguish. 1 or 2 points I've already given you, but I'm not dealing with that right now. Let's go to the latest judgment of the Supreme Court, which I have just showed you a little while ago. Let's go that. I think that will clarify most of the things. But of course, you must take it with a pinch of salt that it is under liquidation. It is not under CIRP. Okay. So application, because they wanted themselves to be treated as a secured creditor, application rejected by NCLT. And this decision of NCLT was upheld by NCLAT. They said that, look, you are, in fact, NCLT held them that you are secured creditor, but your priority is under 53(1)(e) only. Right? So there was a distinction. So NCLAT also said that, yes, you are a secured creditor, but you would rank lower in priority. You will not be paid under 53(1)(b). Though 53(1)(b) uses the word, my dear friends, I'm again repeating, it uses the word secured creditor only. It doesn't say financial creditor. Had there been secured financial creditor, then we would know it only financial creditors would have been there. But it simply uses the word secured creditor. So now if they are treated as secured creditors, then why should they not be paid under 53(1)(b)? Why should they go under 53(1)(e)? Anyway, that was the issue before that, and this judgment actually deals with that. Liquidator also argued that PVVNL dues are government dues, but they will fall under 53(1)(e). That was the argument of the liquidator, very natural argument. In fact, this argument has also been rejected by the Supreme Court, and I will request you as an RP, friends, you will have to scan it with a telescope or microscope nowadays. Microscope. Don't go just because there is a government due, electricity department due is there, therefore it will be treated as a government due. I'm sorry, that is not possible. Supreme Court has given you a leeway, you have given you a handle. And rainbow paper was naturally relied upon. So here, look at the situation. PVNL is saying that treat me, I am a secured creditor and I am entitled priority in accordance with 53(1)(b). Simple case. RP says, no, you are a secured creditor, but you are a government due. Therefore, you fall under 53(1)(e). But I am admitting you are a government due. And this judgment says they are not even government dues. Can you believe this? But they are secured. Because there is a charge, the same language is there, which is there. But anyway, we'll deal with that. We'll come to that, how it has gone through. Now here, why they are saying that these are not government dues, friends, this is the word of caution. Electricity distribution companies who are getting a license, they are not government, my dear friends. PVVNL, though has a government participation, does not render it as a government or a state government. In fact, the word is or. Sorry, I've written off. It is or. Neither it is rendered as a central government or state government. Because look at 53(1)(e). Let us read that, my dear friends. What does it say? Any amount due to central government. This distribution company is not central government. Or the state government. This is not a state government. Including the amount to be received on account of Consolidated Fund of India or Consolidated Fund of State. Now, the electricity dues to be received by a distribution company are not on account of Consolidated Funds of India or Consolidated Fund of State. Consolidated Fund of India or Consolidated Fund of State is what? Like stamp duty which you pay. It goes to the Consolidated Fund of India or the state. If it is a state, Stamp Act is a state subject. Similarly, The other things which you are paying, like other taxes, they go to the Consolidated Fund of India. This is not a Consolidated Fund of India because this is not a tax. So therefore, Supreme Court says that the dues or amounts payable to PVVNL do not fall within the description of 53(1)(e). He says even liquidator is wrong. They are not government dues. So friends, word of caution. Please do not treat electricity dues blindly. If the electricity dues are being charged by a state electricity department, right? Like say Delhi government is providing directly. Nowadays, of course, nobody is doing it. Say UP government is providing directly and you're getting a bill from the state electricity department, then it might be considered as a state or an instrumentality of state. But if it is a distribution company operating under a license, it will not be a government. This is what the Supreme Court says. So please scan it with a microscope nowadays. Don't simply take it. Go to that act, go to all those provisions that where that is looked at. So you have to look at this. Now here comes the distinction factor. Supreme Court says in this judgment, Rainbow Papers did not notice the waterfall mechanism under 53. Though factually speaking, they have talked about 53. I'm saying that. But here they say no council brought to their notice section 53. If that would have been brought, they would not have done it. And then why they gave a logic. Friends, let's go to the preamble. Preamble of IBC. Can any of my friends open the preamble? Let's look at the preamble. Very important. What does preamble say? The preamble says, besides an act to consolidate and all that, let's leave that. Let's read the last sentence. And balance of interest. I'm reading from and only. And balance of interest of all the stakeholders, including alteration in the order of priority of payment of government dues. Underline that, my dear friends. This was the objective of IBC. They say alteration in the order of priority of the government dues. Now, what does that mean? Let me explain that to you. I was the standing counsel for the official liquidator in Delhi High Court for almost 6 years. And I have dealt a number of cases under winding up, under the Companies Act. Now, if you go to the Companies Act 56 or 2013, both, they also give a waterfall mechanism because companies come under winding up. And this waterfall mechanism is quite similar to what we have in Companies Act. I mean, in IBC, it is not a fresh thought. They have borrowed it from the Companies Act. There, my dear friends, the difference is that government dues are treated as preferential creditors. So they are paid after the secured creditors, then the preferential dues are paid, and then of course other waterfall mechanism is there. But while making that section in 53, looking at the objective, the government dues were brought down a step lower. They were brought down at 53(1)(e). And if you look at very carefully, unsecured financial creditors are paid before the government dues. Now, this is actually the alteration in order of priority of payment. So here the Supreme Court has gone into that detail. They say, look, if that was the intention of the legislature, and they have been placed below the secured creditors and also below the unsecured creditors, unsecured financial creditors, then how can the government dues be paid at level 53(1)(b)? Then there was an argument, sir, they are secured creditors. He said, I will not read that. What they read in 53(1)(e), my dear friends, they said government dues, whether secured or unsecured. He said, we will read it like that. Because if they are government dues, they will come under 53(1)(e). Whether secured or unsecured, sorry, we don't care about it. In fact, if you read my article, I have given 2 suggestions actually to amend the act. And that article I wrote in November 2020, November 21, or whenever that, November 22. It was published in November 22. And I gave 2 suggestions. I said, look, to clarify, you can add the word secured financial creditor in 53(1)(b). Instead of secured creditor, add the word financial so that confusion goes. And second, if you don't want to do that, do it in 53(1)(e), government dues, comma, whether secured or unsecured, comma. Just add this. This is exactly what the Supreme Court has done today. Government has not amended the law, but Supreme Court in a different judgment says, I will read the government dues in 53(1)(e) only, whether secured or unsecured. So, my dear friends, this is a judgment which is in liquidation, treats the government secured creditors under the level 53(1)(e). Now, if that is the case, if I apply this principle in Rainbow, then actually Rainbow has no effect nowadays. But of course, I can't say it has been you can say it is overwritten or this thing, but because it is the same bench, right? The bench is same. So I mean, 2-member bench cannot override another judgment of 2-member bench. Either it has to be reviewed or it has to be done by a higher bench. But now we have two contradictory judgments, so to say. So the design, now what the Supreme Court says in a very lighter vein, now they can't blame the court. They simply say the design of the IBC was either not brought to the notice of the court in the Rainbow or it was missed altogether. बेचारे यही लिख सकते हैं, इससे ज्यादा क्या लिखेंगे?
Sir, 1 point, please.
Yes, sir.
Sir, in 53(1)(b), it is written creditor, not secured or unsecured. Secured creditor, not financial or operational. So suppose an operational creditor is also a secured creditor.
Right.
Then that secured creditor will come here in 53(1)(b). And if it is written financial creditor, a secured financial creditor, then where will the secured operational creditor will be put?
Okay. See, you are right in when you are saying that, because the problem is in the use of the word secured creditor only. This is what I've also brought out. And in my article, if you read it carefully, I've given these two suggestions that please make it secured financial creditor, because the government dues, we have this judgment today. But tomorrow, an operational creditor who is secured, he will also say, pay me in accordance with 53(1)(b) and not under 53(1)(f). The same problem will come, isn't it? Like in the case of in the case of the government, the preamble also says alteration in order of priority of payment. So therefore, Supreme Court concluded. But this same thing is not with respect to the operational creditors. So therefore, tomorrow, a secured operational creditor can claim that, look, I have a security interest. Please pay me in accordance with 53(1)(b). Yes, sir, the problem can come. But if we look at the scheme of the things, so let's forget about secured or unsecured right now. Let's go to 53. Now, what does 53 says? Unsecured, the first one, obviously, the IRP cost and the liquidation cost. Second is workman dues along with secured creditors. Third is unpaid wages or workmen more than that 2 years or whatever. And then financial debts owed to unsecured creditors. So here, can you believe this? Unsecured financial creditors come next.
Yes.
And then comes the government dues, and then comes remaining debts. Remaining debts means operational. So if I go by this logic, looking at the scheme, looking at the intent of the legislature, the intent of the legislature was that unsecured financial creditors should also be paid in priority than the operational creditors, whether secured or unsecured. Of course, I agree with you. There is no clarity as of today to that extent. This case can come and again go to Supreme Court. But applying the intention of the legislature, I would read even operational creditors, remaining debts and dues, whether secured or unsecured. So that is what has to be read, because Supreme Court also says Section 53 has to be read with Section 52. Right? So they said,
Sir, don't you think that here the spirit is that more priority is given to secured creditors, not financial or operational? It seems priority is given to secured creditor over unsecured, whether financial or non-financial.
At the first blush, if it looks to be that only, but let us not read the section alone. We have to read it with the BLRC. If you go to the Bankruptcy Law Reforms Committee report, it was intended that it is meant for financial creditors.
Okay, sir.
So therefore, it is not that every and all or any secured creditor will come under here. So I mean, intent of the law was little different. Of course, we need clarity. I mean, I'm saying that we need clarity on this. Your question is absolutely valid. Okay. So this is what has been mentioned, my dear friends, in the latest judgment. Then in one of the ways, they have mentioned that even Section 77 of the Companies Act cannot be relied upon. He says charge registered, not registered. We don't want to go, because that was an argument given by the liquidator that look, they are not secured creditor because Section 77 has not been complied with, charge has not been registered. Supreme Court has simply ignored that. They say, sorry, Section 77 cannot be relied upon for these things. And then they have specifically mentioned PVVNL dues will be paid under Section 53(1)(f). They are not even government dues. Forget about secured. So therefore, this actually judgment changes a lot of things as far as Rainbow is concerned. But since Rainbow is still under review, we are expecting that judgment soon. I think it should be on these lines only. So I think let's hope for the best that it will be on these lines. Okay, so friends, before moving forward, I think we are at 12:30. We have to break for lunch now. We have still got 3 minutes. So any questions or any issues? In fact, time barring debts is remaining. I'll answer that after lunch. And if you still have more questions, friends, so please note it down. If you want to ask it right now, that's a good time, or you can write in the chat box so that we can have a discussion. And friends, now the next 2 sessions, particularly the difficulties, I want this to be absolutely practical. Those who are doing, like I know Mr. Khatri is doing, and many other friends are doing a lot of CIRPs or liquidations. Please come out that you face this situation and you handle it this way, so that others are benefited. So I want everyone to contribute. I will ask each and everyone to please open mics and share your experience after lunch. Yes, I think.
Only one question, sir, actually.
Yes,
See, there is a particular problem which actually erupted in my case only. So I want to share this problem. We can discuss later on, no problem.
Yes, sir.
When is suspended director of the CD against whom an NBW has been issued, brought before the adjudicating authority.
Okay.
Right? Brought before the adjudicating authority in execution of NBW.
Right.
Can the AA, adjudicating authority, NCLT, send him in judicial custody pending initiation of prosecution against him? The idea is whether adjudicating authority has got power to send particular person to the judicial custody.
Okay.
So this is the question actually I want to know. So how to deal with this issue?
Good question, sir. This is an important legal question. And in fact, I very jokingly used to say, and this practice of issuing bailable warrant and NBW, do you know that? Who started that?
Yes, initially NBW.
No, first the bailable warrants were issued and
yes.
then NBW.
Then NBW issued, yes.
Justice Ina Malhotra started this practice.
Correct.
In Delhi. She was a district judge. She was coming from that background and she started doing that. So initially there was a doubt whether NCLT has power to issue NBW or not. And we will discuss that. That's an interesting.
Yes, this is the interesting. In NCLT rules it is defined. However, I will throw some light also. Because it is not there.
Yes, we will hear about that also from you. Yes, Kshitij, you want to ask something?
Yeah, sir. I have 2 questions. So one is that section 30, subsection 2, clause B, read with section 53. Right. Now, there is a proviso in this section which says that the dissenting or maybe the financial creditors who have not voted in favor of the resolution plan will have to be paid in priority over the ones who have voted in favor of the plan. Now, what does this term priority means? The dissenting creditors are many times of the view that priority means that they should be paid upfront. My view in those meetings has been that priority means that yes, before a debit to the assenting financial creditors is done, a debit to the dissenting financial creditors should be done in the same deferred payment mechanism or deferred tenure, because an upfront amount can be a lesser amount of what has to be paid to the dissenting creditors. So, what has been the general thought on that or practice in this?
Okay. I will answer that after lunch. I've noted down that. In fact, I remember dealing with this situation at many occasions, but definitely it's a good question. Yes. Any other? You said
Another one, sir. I have one more question, if I may permit.
yeah. Please go ahead.
So this is regarding the Jet Airways judgment under Section 53, which has declassified PF and gratuity dues from the labor workman dues, 24 months.
Right.
And the Supreme Court and has now specified that PF and gratuity has to be paid in full over and above all. It is outside the purview of Section 53, even if a separate fund was not there or not there, it is irrespective of that.
Right.
Now, my question is, assuming the company is a going concern and the company was on and during the CRP also in the liquidation also, the liabilities or the claims have to be frozen till the date of LCD or the ICD. Now, I've been running a company since last 2 years under liquidation, and now the company is not being able to be be sold as a going concern, and the company is shutting down now. Now, my question is, till what date the gratuity dues will be calculated? Will it be till only the LCD? Then what about the gratuity for the interim period? Or will that be a part of liquidation cost? Because that will be a huge amount, gratuity in PF. I mean, how to deal with this gratuity in PF issues has become a little point of concern for me. Sir, I'm not able to hear you.
Yeah. Now, can you hear me?
Sir.
Yeah. So I think these are very important aspects which you have raised. Very important questions. I think we'll answer it after lunch. Okay.
Sure.
Right. So let's any other questions, my dear friends, if you have, just put it in the chat box or please note it down. We're going to have a lot of interactions. I've got very little of presentation left. We'll talk about these all other aspects together. The timelines, of course, you are aware. I don't have to repeat that clauses there. Few of the things I have already highlighted. But we will talk about more about the problems and the difficulties, as now Kshitij also mentioned and Khatri Sahab also mentioned. We would like to have these kind of issues and how you sort it out, right? I have my opinion, but naturally your opinion and wisdom will also help others to understand the whole aspect. Friends, let's take a break now. We'll meet at 1:30 after lunch. Thank you so much.
Thank you.
Participants, we have 1 hour break. We are going to meet for the second session in the workshop at 1:30 sharp.
Madam, can we log out? Actually, can we re-log in, right?
Yes. You can log out and you can log in again as per the timings. No issues.
All right. Thank you.
Sir, at my end, you're not
Yes,
audible.
I can hear you.
Participants, can you confirm if sir is audible at your end?
Yes,
he's audible.
Yes.
Okay.
Okay.
So, sir, can we start with the second session?
Yeah, definitely we can do that. Okay. So welcome friends back and welcome back. And I think let's start in the right earnest. And in case any more questions and anything is there, so let me see. Okay. There are few questions in the chat box also. We'll definitely look into that. Okay. At an appropriate time. Right. Okay. So let us look at okay, I think let's deal with few questions because they are more relevant to what we have discussed. Okay. Mr. Rajendra Joshi is saying in a CRP process, can IRP accept the claim on provisional basis due to insufficient data for verification? Well, you see, there is nothing like provisional basis. In fact, in one of two cases, some strictures have been passed against RP that they have admitted on provisional basis. So naturally, if there is insufficient data for verification, then there is no question of provision. Either it is accepted or it is not accepted. Provisional basis cannot be any acceptance. So therefore, please avoid doing that. Okay. Otherwise, what you can do is, supposing the data is insufficient with you for verification, but on the basis of the documents which have been provided by the claimant, or you can ask for some more documents, maybe you can insist on that. And if he provides you, say, bank transfers and all those aspects, so naturally you can look into that. Okay. Okay. Then Mr. Rajneesh Sharma, I think he sent me a message directly rather than to this. Let me try to post his question in the main chat box. Just give me a moment. Yeah. So I think I posted this. Okay, he says in my COC, there is no financial creditor. So COC consists of OC, which include GST and income tax department. My question is that do GST and income tax department contributes towards CRP cost? As per IBC, they have to do it, but whether in practice they contribute towards CRP cost, what we should do to get the contribution from them? Okay, I think Rajneesh, it's a good question. The recovery of CRP cost is always a problem. We know that. In fact, we raised this issue with IBBI at number of stages that look, do something about it. But unfortunately, no solution is forthcoming. The only solution which came was because even IBC also does not provide that who is going to bear the COC cost. You're writing that IBC provides for contribution. There is nothing. The act is silent. It is through few judgments where the applications have been made by the RPs to the NCLT, where NCLT have directed them. And some RPs are very smart. They persuade and they cajole the COC members to pass a resolution that they will be at the CRP cost in this manner. So typically, either you can get it passed in the COC, B, or you can go to the NCLT and approach them so that a direction can be given, which has been given. I've got few judgments here. If you want, we can share it. There are judgments of NCLAT also, which clearly say that CIRP cost should be borne by the COC members. They are obliged to pay it. Now, in your case, the direction to pay the CRP cost is not towards the financial creditors only. It is to the COC members. So in your case, if the COC members are government bodies only, naturally they should also be liable to pay. But typically speaking, they won't pay, right? Because being a government, they are not going to pay. Who is going to approve that? So that you are in a little complex situation. If you approach NCLT also, probably they will also not be able to order anything on that. But you can try your luck. Go to NCLT, take the support of what you call it as few of the NCLAT judgments. If you want, I'll just show them on your screen. Just give me a moment. I think I have, yeah. So I can share this on your screen and you can note down those judgments so that try to make use of it. Okay. So these are the liability of the COC to pay CRP costs. Of course, this was a part of another presentation, so I'm just showing it to you. This is the one judgment where way back in October 2018, Mumbai NCLT bench, they wrote in their order, and this is the order number. I mean, if you wish to note down, or you can take a screen photo or a screenshot of this. It is the responsibility of the COC to make the payment of the resolution process cost. And in this case, ICICI Bank was directed to make payment of the resolution process cost plus IRP cost, which has been ratified by the COC before 5th November 2018. So this was one of the cases. Okay. Let's look at the NCLAT judgment again in 2020. A COC member is to bear his share of CRP cost in proportion with the voting period and the period he was a member of the COC. So here, supposing you admit a claim, say 6 months later, so then they will be asked to pay from that period. I mean, it's not that they will have to pay from beginning. So they say pay it from the date when they are becoming the member of the COC. But this is another judgment, which is company appeal number 1053 of 2020, and order was dated 10th December 2020. Okay. So this is the second case, and this is the third case. This is 10th January 2020. This is company appeal number 48. Again, here they are writing, the committee of creditors is to pay the fees and the cost incurred by IRP, who also acted during the resolution process beyond 30 days till the date of liquidation, having not allowed to continue as liquidator. So there are instances, and there are many more other than that also. So these are the few cases which I wanted to show you. So these are the 3 cases. I think if you want to note it down, I'll just, or maybe you can take a screenshot so that the appeal numbers are with you. Okay. Or otherwise you can connect with me on offline. I'll share these with you. So these are the judgments which say that COC members should bear it. So if COC members are only comment this thing, I have my doubts that they will order it. I have my really my doubts, because there's no way to pay. So that's, but you can try your luck. Let's try to set precedent. And in IBC, I always say, let us create precedents. You never know, you may be successful. और पता चले नाम आ जाएगा रजनीश कुमार आरपी वर्सेस सो एंड सो, तो आपकी जजमेंट काम आएगी लोगों के. Okay. Ankush Munjal, okay. Ankush, you are hiding somewhere, okay? I believe. So you must open your videos. I think I should consider only those questions if they show your videos. Okay.
Sir,
Anyway.
may I ask you a question?
Yeah, please go ahead, sir.
Sir, video. Sir, actually, in one case, there is in COC only one member, 100% voting right, one member.
Okay.
And in the second meeting of COC, first meeting of COC, they confirmed the RP. In second meeting of COC, they proposed to remove the RP.
Okay.
What RP did, he did not put that in the form of resolution, though he, in the minutes, he wrote that so and so proposed to remove the RP, but he did not put that in the form of resolution. As he did not put that in the form of resolution, then the financial creditor could not go to NCLT, and after 2 months, anyway, they filed the application under section 27.2 and also section 60 subsection 5. They filed the application, but adjudicating authority asks where the resolution. There is a specific section 27.2 to remove, and 27.2 specifically says there must be a resolution. As there is no resolution, how can we remove? Then my point is that the RP has prerogative to keep what is to keep or not to keep in the minutes, because he is the chairman of the meeting. The chairman of the meeting decides not to keep that resolution. So that means effectively the RP cannot be removed if he does not wish. So in that case, what to do? What the financial creditor can do? How to remove it?
Okay. I think the process which has been, see, let's understand one thing. As far as the RPs are concerned, I believe, friends, we should be fair. If somebody wants removal, I don't think you can impose yourself upon some people. I think go gracefully, get your fees settled. Naturally, those things are there, but please go gracefully. Let's not fight, because there are judgments of the NCLAT also, which clearly say that no reasons are required for removal. Initially, there was a thought, and a lot of RPs were saying, no, there should be a provision which reasons should be given. I was totally against that. And I explained them. I said, look, if you are asking for reasons, they will write 10 reasons. The first line they will write is you are incompetent. Then what will happen? It will be a blot on your career. So don't ask for any reasons. Go gracefully. That's one. And in any case, if I'm not the RP, my fraternity friend is the RP, how does it matter? Doesn't matter. Tomorrow he will be removed and you will be there someplace. So it's all a matter of rotation. So let's take it very gracefully. Number one. Number two, the regulations, Mr. Jaina, I think you know that the regulations clearly require the matters to be discussed and matters to be voted upon have to be mentioned in the notice, isn't it? This is a statutory requirement. It is not the wish of the RP. So, and I'll show you some slides also. Of course, we are aware, we're just trying to refresh our memory, that if the financial creditors or the COC members request for any agenda item to be added, it may be added, and it must be added if more than 33% want it. So supposing only one member asks for it, which has only 5%, then you may or may not add it. That's up to you. But typically speaking, generally one adds it. But if it is requested by more than 33%, then agenda item can also be added and a meeting must be held. So if you are adding an agenda item for removal, it is a matter for voting. So naturally, he has to disclose it under voting and he has to conduct the voting. So tomorrow, if he makes the minutes in a fraudulent manner, assuming, I'm just saying, in a wrong, not fraudulent manner, in a wrong manner, not showing that the resolution was passed, then what the committee of creditors were doing when they received the copy of the draft minutes, they could have objected at that stage itself that, look, you have wrongly recorded it. So all these things are complex. We don't know what exactly happened between the two parties, but the fact of the matter is...
Coming. Yeah, sir, actually, that is not my point. My point is that resolution in 27.2, it is clearly written resolved. That resolution, it does not mean that the resolution should be in the written form and in the minutes itself. I have demonstrated the financial creditor has demonstrated, because it is written, it is proposed, and he has filed the application, and he is 100% voting right. That means it is demonstrated. When something is demonstrated, then how can the adjudicating authority say, give me resolution in the form, in the written form? That is my point, sir.
Okay. I think I've got your point. See, what you're trying to say is that minutes record that this was voted and the replacement of the RP was voted upon and it was passed by so and so. But he is not writing in the word that resolved that so and so. That is what you're saying.
Yes.
Oh, okay. I got your point. See, insofar as this is concerned, the view of the NCLT is quite restrictive. Let me share with you what their view is not correct. Because if we read 27.2, it says the committee of creditors may at a meeting by a vote of 66% resolve to replace. So resolve to replace does not mean a proper resolution is required.
Yes.
Resolve to replace can be the intention of resolving to replace can appear from the minutes which are recorded. So
Yes.
if you are saying that your minutes are recorded and saying, I don't think they should be so fussy about it that resolution nahi pass hua, jaise Companies Act mein wo minutes mein resolution banta hai. I don't think they are it's not fair on their part. Kaun si bench hai, sir? Katak bench hai?
Katak bench, sir.
Okay. Try to explain them. I think
what NCLT Delhi has very clearly in one of the most probably, sir, you are representing one of the parties. In NCLT Delhi, it is very clearly mentioned in such cases, adjudicating authority has the power to remove. The authority who has power to appoint, he has the power to remove. In such cases, if the RP is doing such things, then adjudicating authority can remove.
correct. Absolutely. In fact, they can remove on their own also. They have done that. Here there is a decision. See, which let's not talk about resolution. It doesn't say resolution, it's a decision. Decision to resolve. So that has been taken. According to me, it is a sufficient compliance of the law. I don't know why they are doing it. Maybe advocate is not able to convince them. I can only say that. Okay.
I am representing.
No. So nothing.
Yes, I am unable to convince them. But thing is that if this happens, then RP cannot be removed because you saw a resolution. Sir, one of the cases in SG Chowdhury versus Sriram Urban case, most probably you are representing one of the parties. In that case, RP did not call the meeting in which the agenda was to remove the RP. As he did not call the meeting for years.
Right.
No, in this case, RP is not keeping that resolution in the minutes.
No, you're right. This is exactly what happened in one of our cases also, rather two cases. Another case is Earth Infrastructure also happened the same thing. All I'm saying is, see, I'm sure you must have presented your case very well, but Mr. Jaina, let's understand our limitations as lawyers and as counsels. We can only argue to a certain point, right?
Yes.
After that, we have to just leave it to my lords because we are always obliged to them. So if you are not happy with that decision, later on we will go to NCLAT. That's all right. So don't argue beyond a point. Forget about it, because at the end of the day, you have to appear on a daily basis, right? So that's about it. Okay. I think good observations and good experience to share with. Okay. So I can see Ankush now. So Ankush, good afternoon. We are meeting after a very long time.
Yes, sir. Good afternoon, sir.
Yeah. So can you ask your questions since you are present?
In case of a CD application made under Section 10, if there is no financial creditor in the COC, there are only 4 operational creditors.
Okay.
And even out of these 4, 2 are related parties, being shareholders of the holding company, who normally don't have the voting rights. Now, will this constitute a quorum, and will these balance 2 will also have the voting rights? The first and the foremost is, will they constitute a quorum? Balance 2.
Okay. See, insofar as the COC is concerned, I think, Ankush, we all understand that related party FCs or OCs, same provisions apply. They are not part of the COC. So I will treat that only 2 operational creditors are part of the COC, right?
Right, sir.
Probably 1 representative of employees, if any, or one representative of workmen if there are. I mean, if there are none, so obviously these two will be there. So that's a sufficient quorum. I mean, as far as the constitution of the COC is concerned, there is no quorum. Even a single creditor can also form a COC.
Right.
Okay. Okay. But of course, for attending the meeting, there is a quorum, right? There is a regular. We'll talk about that. Yes. Okay. What's your next question? I think you have raised.
Another question, sir. A foreign shareholder is also the ECB lender to the CD, and he is the only FC in the CD company. Now, despite sending the proper notices for AGM to approve filing of application under Section 10, the shareholder does not attend the AGM. Then how the special resolution will be passed in AGM? Overall, there are only 3 shareholders, including this foreign shareholder.
Okay. So all you are saying is there are 3 shareholders, and the quorum, of course, is 3, right?
Yes.
Is it a public company or a private company?
It's a private company.
So private company में तो 2 का ही quorum है, shareholders का.
Only 2 will suffice.
So therefore, you hold that this thing, or in any case, if the meeting is not held for the want of quorum, it gets adjourned to 1 week later, as per Companies Act.
Right.
Same time, same day, same time and same place next week.
Right.
So and then whosoever is present is treated as a quorum. So
both will have to approve for a special resolution.
Absolutely, it has to be 75% minimum. So present, वहाँ पे present and voting वाली बात.
Voting and present, right? Perfect.
So therefore, you are happy there. But in IBC, of course, we are not happy about those kind of things that change. Okay.
Thank you, sir. Thank you.
Great. Thank you. Okay. So I think these are the questions, and let us also answer 1 or 2 questions which were raised. Yeah.
Can I ask?
Yes, Rachna.
Okay, in one of the case, like no claim has been received, and so the COC was not constituted. The applicant wanted to withdraw, but they have not submitted the form FA, and they are not paying the fees and expenses also. So, like in such a case, what should be done? Like,
okay, there are 2 things. One is, even if they submit a form FA to you, you don't have COC, so you can't formally get it approved by 12 under 12A. So there are 2 solutions. Number 1, those people who want to withdraw, like OC, naturally OC will be withdrawing, or whosoever started it.
Yeah, OC.
They have not filed a claim. So unko to
no, they have not filed the claim also.
Wow. So, same scenario happened in one of the cases. OC started it. They did not file a claim. And what we did, I advised RP, after trying his best, asking him to file claim 2-3 times, they did not do that. We filed an application for liquidation. Sir, kuch information nahi hai, directors are absconding, the creditor who has started, he's not coming forward, not sharing information, not filing a claim. What do I do? The bench did, right? Bench 5 of NCLT, they issued a A-level warrant to the OC. Okay, let him come. A-level warrant में नहीं आया. उसके बाद NBW में आ गया. Naturally, he had to come. So when he came, then he said, why have you not filed the claim? That means you have started the proceedings on a malicious basis. I will apply Section 65 and I'll impose a cost of 1 crore on you. Oh, dar gaya. After that, he filed a claim, and then the COC was formed. So you can also do that. File an application for liquidation, giving all this. But please make sure, Rachna, that you have made a lot of attempts. You had requested him to file claim 2-3 times.
Many times I have done that.
So then you straight away go to there, or if they are willing to withdraw, then advise them to go directly to the NCLT, file an application under 65 that they want to withdraw. So that will
that also has been done, and I have also filed a contempt application because not following the directions.
So it is in which bench actually?
In Kolkata, bench 2.
Okay, fine. I think you will find that solution there. In fact, if you want, I can share that judgment with you. I mean, not a judgment, it is an order. I mean, you can connect me with offline. I'll share that. I'll ask my office to pull out and share it with you. You can show it to Kolkata bench.
Okay.
But a bail-level warrant was also issued. Okay. Yes. Okay. I think, yes, I think Mr. Amin is there. Yes.
Yeah, good afternoon, sir.
Good afternoon. Yes, sir. Go ahead.
Yeah, so basically, in case where the IRP is getting replaced with the RP, new RP, incoming RP, And nowadays, as it has been seen that it is difficult to get dates to get the application listed. Now, as a IRP, the COC has been constituted, but now the 60 days is the timeline for Form G. And if you see even for the PUFE transaction, there are tight timelines.
Right.
So as a IRP, in one of the case, one has tried to convince COC that the Form G has to be published because that is though it is a model timeline, but ideally it should be, the process should move on irrespective of the replacement. On the other side, COC had a submission that, this is a very peculiar situation where an incoming RP may have issues to handling all these EOI document, correspondence, emails and all. So we want to vote to defer the Form G. In that case, what should be the ideal stand which IRP should take? Because see, the model timelines and the publications, though require COC's approval, but then as a IRP, he has to step into the shoes of RP wherever the appointment has been delayed or it has not happened. So what should an IRP ideally should do to safeguard himself from running a process point of view as well as from the IBBI point of view? Because these type of actions are at times viewed as a negative points from an IRP point of view, that why you didn't initiate. So again, so for PUFU also, why I mention is that at times, the transactions or the volume is large. The IRP typically, if it is on account of OC application or maybe whatever may be the reason, and if he's getting replaced, appointment of an agency also becomes very critical when there are transactions which are in larger and complicated nature. So in that case also, what should IRP do? Because it puts a question mark on how the process has been conducted by the IRP, though the COC is completely not in view of allowing the IRP to continue the process, considering the model timeline.
Okay. You want to say something else or is it done?
No, I'm good.
Okay.
Thank you, sir.
Well, before I answer, I believe many of my friends who are experienced RPs, including Geeta ji, they can answer it. And that's a simple answer, right? Let me share it with you. Maybe if somebody wants to value add to that, they can definitely do it by their experience. So number one is, as you have also rightly mentioned, that as per IBC, you are supposed to work as an RP, right? So what you have to do to protect yourself and also to work in the best interest of the corporate debtor, because you have to follow the process in a time-bound manner. And that timelines, the courts may say it is directory, but please mark my words, friends, it is mandatory for you. You can't say it is directory. Somebody else may say directory, that's all right. But as far as IP is concerned, because we are bound to follow regulations, it is mandatory for us. So what you need to do is, you hold a COC meeting, place that Form G for their approval because it needs their approval also before issuing. Do it not once, maybe 2 times. And explain in the minutes also to them, and also write down in the minutes that it is a time-bound process. IRP also exercises the power of the RP. Despite the fact that application is pending, this process of publication of Form G cannot be deferred to any extent. Please write down all those things in the minutes to safeguard yourself and put the entire onus on COC. Now, you mentioned that they want to defer the process of Form G. COC will be in trouble, my dear friends. They cannot do that. Because there are a lot of strictures have been passed in one of the cases where they did not approve the Form G for a continuous period of time, and the court and the time for liquidation came, RP filed a liquidation application. The Kolkata bench, that's a Kolkata bench, came down very heavily on the COC. They said, what nonsense you have done. He says, I will report it to your managing directors that why you're doing like this. So therefore, my dear friends, protect yourself, do everything what is required under the law, follow the process, have it recorded. And I mentioned, do you remember what I said in the beginning? Minutes are your savior. Minutes will save you, my dear friends. So record everything, create evidence by sending them email and also recording in the minutes. Okay. I hope that answers. Anyone wants to value add? Geeta ji, you want to add something to it?
No, sir, I had a question. That's why I put a hands up.
Okay. No, that's all right. But I mean, if you want to add something to it, because we are all learning, and you are definitely very experienced RP. So
no, sir. As you rightly said, minutes is going to be our savior. So anything that we want that to be a record forever, minutes has to be very, very strong enough to ensure that it is all taken care.
Right.
In fact, that's what I learned from you and Mamta ma'am every time, because both of you keep repeating this time and again. But the minutes has to be very, very proper. Thank you, sir.
Absolutely. Yes, go ahead, Geetam.
Yeah. See, I have a question, sir. See, in one of my case, actually the liquidation application was filed way back in January 2021. But unfortunately, the directors, went approaching court after court, and then the matter was pending in Supreme Court. So NCLT, every time the hearing comes, the directors will come and say that it is in Supreme Court. So they were so frustrated, and they said, we will adjourn it sine die, let the Supreme Court decision come, and then we will take it up. And then February 2023, the and Supreme Court dismissed the appeal. So then I made an application to bring the matter for listing for liquidation. Again, the liquidation application is yet to be considered, because now they came out with a lot of EOIs, because see, the IMs were not prepared because the director did not give me one piece of paper. And that was a COVID time. We were completely under lockdown, travel restrictions and all that during the period of 2020. The entire period went in, lockdown and doing things through mail. Unfortunately, nothing could move. See, that is not the question. For me, it is that so from the date of filing of the liquidation application to till date, I have not been paid. In fact, none of my expenses are being covered by the COC members, because I've gone court after court defending myself, paying the lawyers, because Supreme Court, I had attended about 10-12 hearings, and I paid the advocate for that. And then NCLT, I've attended 12 hearings, and then I paid for that. And arbitration in Chennai, I paid for the advocate. So all these bills are yet to be reimbursed by them. They have. None of the, and one of the COC member has not paid even during the ARP period a portion of fees for which application is pending in NCLT. So where do I stand, sir, in the light of this situation?
Okay, Ajay, tell me one thing before I answer it. Have these expenses been ratified by COC, or they are not even ratified?
The COC was not there, sir, because after liquidation we did not meet. And then in the last COC meeting, because under the direction of NCLT, we conducted a meeting a month back. In that, I've actually placed. They said they will come back, but then they never bothered to respond.
Okay. See, this is actually a very grave problem for most of the RPs, because where the liquidation applications are not taken up and they take a lot of time, right? In your case, it was peculiar because it was pending in Supreme Court and the bench decided to adjourn it sine die. And therefore, much of the time has lapsed. But in normal cases also, sometimes 3 months, 6 months, and more than that also takes place in many cases. So the question that arises is whether the RP is entitled to their fees or not. The answer is yes. The only point which a new concept has come right now is, in one of the cases, NCLT, and that has been upheld by NCLAT recently. I think last month itself, if I'm able to share, I'll share that judgment also. NCLT, what it did, they said instead of 3.75 lakhs per month, they fixed the fees of the RP as 1 lakh rupees per month during COVID period. They said you did not do anything. So therefore, they on their own, they reduced it from 3.75 lakhs to 1 lakh per month. Now, this was challenged by the RP before the NCLAT, and NCLAT has upheld that adjudicating authority has rightly done so. Unfortunately, NCLAT's judgments are not very favorable to RPs as far as the payment of the fees is concerned. So all I'm saying is, yes, you are entitled to fees. How much? Naturally, now the NCLT will decide whether at the same level or at a lower level. But the expenses which you have incurred, right, for advocates and other things, naturally they have to be paid. I mean, there cannot be any concession, because you remember one Supreme Court judgment where the expenses were not paid and arbitrarily some of the fees of the RP was fixed, right? And then the Supreme Court said, what is this nonsense? You have not fixed on a proper basis. While we are remanding it back, fix it now on a proper basis. So
they mean to say that we have to file an application, sir, and asking for a...
Naturally, if they are not complying, I mean, they are not paying the fees, not approving the expenses, naturally the recourse is the NCLT only. And nowadays, they are not appointing the same RP as liquidator also, isn't it? So you can tell the bench that, look, my lords, if you are not appointing me, please pay me so that I can safely sit at home and enjoy that money. Anyhow, these things are taking new turns every day. So these kind of things are there. Okay.
Thank you, sir.
Yeah, thank you so much for being here. Okay, friends, now let's move forward.
Sir, I have a question. Shall I, sir?
Yeah. I think there were two more questions. Yeah, please go ahead, sir, Mr. Sudarshan. I think then we'll come back to the questions which were asked before lunch. Okay.
Okay. Sir, I am an IRP of a company. Recently, it got admitted. And in 2020, all the assets of the IRP, the assets of the corporate attire has been attached by ED in 2020. So from 2020 onwards, there are no operations in the company. Now is the new, the assets are, a lot of assets are there in the company. If a resolution applicant comes, the successful resolution applicant, will he get complete protection under section 32A? Have you seen such orders where, whatever the attachment happened, that will be released to the successful resolution applicant and he can safely run the business and there will not be any trouble to him? Any such cases have?
Yes, sir. There are a number of cases. And in fact, the best example is Bhushan Steel case, right?
Okay.
Where Tata Steel took over. Now that problem, actually 32A came because of that. What happened in that case when Tata's took over, there are a lot of, pending attachments and pending cases, investigations were going on by the side of ED and CBI. So when Tata's took over, those new management people were also called for investigation, to join the investigation. Now then this opened a whole lot of debate that, if somebody is spending money, now he should get the company at a clean slate, right? That was the purpose. So therefore, section 32A came. Now, 32A talks about three things, which is very important. Like briefly, I can tell you, number one, but there is a one condition. A, the plan has been approved by the adjudicating authority. That's the first condition. Second condition is that there is a change in the management. If the same management is continuing, then that benefit of 32A will not be given. It will be given only if there is a change in the management under a plan approved by the AA. These are the two conditions to be satisfied. Then the first immunity is that no case can continue or the company cannot be prosecuted, right? So therefore, all the cases will abate against the corporate debtor insofar as that is concerned. Any properties which have been attached, this is subsection 2 of 32A. It says any property attached will be deemed to be detached if the resolution plan has been approved by the adjudicating authority. So my suggestion to you is this.
Okay.
I hope you must have done that once a resolution plan comes, please in this clause also, that in terms of section 32A, the moment the resolution plan is approved, because there is a change in the management also, there will be attachment in terms of section 32A. Please include that also. Naturally, if you don't include, even then it is given, but please include that, that's better. And the third, section 32A talks about the third thing. It says this immunity will not extend to past employees or suspended directors. So immunity is given only to the corporate debtor and not to the employees or the suspended directors or the promoters. But the immunity will be given to new promoters. Naturally, they will not be part of this. So this is a very good section, and I think I'm happy that you brought about it. So I think it's a very important section. Okay.
Thank you, sir.
There are three more questions which were raised. So let's go one by one. The first question, which was very important, and I think I've seen a lot of debates on WhatsApp groups also, but let's put that to rest. Try to put that to rest. Can an RP consider a claim which is time barred? Let's take an example. The company comes into CIRP on 1st January 2023. Let's take the cutoff date. A claim which was due, say in 2016 or 17, it is filed because now the company has come into CIRP. He also files a claim. The person whose amount was due on, say, 17 or 16 or 18, which is naturally time barred by 2023, should the RP accept it? That's the question which was asked by one of our friends. Now, I would like to, before I answer that, I would like to have the opinion of our all friends who are here. Friends, can I request you to please open your videos? I think it's better. I'm speaking to some blank screen, so I think it is better if I can see smiling faces. I know it is after lunch sessions are most difficult, but I'm trying my best. We'll take a break also, comfort break for a coffee break after some time. Yes, I think that sounds good.
Sir, may I ask the question? May I share my understanding in this?
Yes, sir. Yes, sir. Please go ahead, sir. One by one.
What I understand. Sir, limitation is a mixture of law and facts. So when job of RP is to collate and verification. Collation and verification, that is related to facts only, not about law. So when something is related to law, if RP enters into that, then that will be treated as adjudication. Therefore, in my opinion, RP cannot enter into look into the limitation aspect. Without looking into the limitation aspect, RP will take its decision. If RP goes into limitation aspect, then that will be treated as adjudication.
Okay, chaliye. I think this is one view. Okay, any other who wants to give another view, or what you have been doing while you are acting as an RP? What you have been doing? Just share your views. See, we are not saying somebody is wrong or right. We are not commenting on anyone. We are just trying to understand what your views are.
I am when it is time bad, RP as RP, we do not admit time bad debts. Generally, practically, we do that.
Yes,
I am not accept.
Yes, Anilji,
Sir,
go ahead.
Yeah, I am not accepting any time barred cases, time barred claims.
Achha,
And
okay.
I am giving justification for that also. BLIRC committee reports also have on view on this that time barred claim, and also those claims are not legally challengeable at all in any court of law. So by this, I am not accepting any claim of this time.
So you said one is they are not acceptable in any court. Other reason what you mentioned, I just missed that.
The BLRC committee also discussed on this issue, I think.
Okay.
That is there also, and also.
Okay, so your view is that the limit, the claims which are time barred should not be accepted by the RP. Okay.
Yes.
That is the second view. Let's respect. I mean, this is a matter of opinion. I think we must respect each one of us' opinion. Yes. Neither in support or against.
I also endorse the what we have done is we usually write to the claimant, asking them to establish as to why to establish that whether how it is not time barred.
Okay, so you
and then we wait for their response.
And if he is not able to demonstrate, then you don't include.
Yes.
Okay, so you are basically going by what Mr. Anil has said, but you are going a step further, saying that we give them a chance to prove that it is within limitation. Okay, and naturally, I think Mr. Anil would also be doing the same thing. Okay, and naturally, we have to do that before we reject. Obviously, we'll have to give another opportunity. Okay, yes. Any other friend? Anyone else?
Also endorse
Mr. Anil's views.
Yes, sir. Ajay, you endorse Anil, Mr. Anil?
Yes, sir.
Okay. Jena साहब आप अकेले पढ़ रहे हो लग रहा. Anyway, it doesn't matter. I mean, it's always, you see, a discussion is always useful. If there are...
Sir, I do that. I have also rejected. But this is my understanding. So if I reject something or on the basis of limitation, then I am adjudicating that. That's my point. I do not have power of adjudication as a RP.
Okay. Friends, let us try to answer this now. The fact of the matter is that limitation law also applies to IBC proceedings, right? But if you read actually section 238A, it talks about that it applies to IBC proceedings before NCLT, NCLAT, and DRT, DRAT. It doesn't say IBC per se applies to IBC. I mean, unfortunately, I mean, this limitation law applies to IBC, but fact of the matter is there are Supreme Court judgments now. There are hundreds of Supreme Court judgments that limitation law applies to IBC. There are clear facts, right? There is no quarrel now. There are hundreds of judgments now on that issue. And we also know that Article 137 applies for this thing. So now let us counter this by way of a logics, one by one. The first logic is, if a person whose claim is time barred, say OC or FC, can they start CIRP? The answer is no, because the Supreme Court says so. So let's take arguments little further, and it has to be based on logics and reasons. So if as an OC time barred, I can't start, but somebody else starts, I can file a claim. Does that sound logical to anyone? It does not. I mean, it is not in the same scheme of things. So that doesn't sound very, very logical. I mean, I can't say I'm sitting on the chair is sitting on the floor, therefore I'm sitting on the floor. I mean, that logic doesn't cut ice. So these are the things. Now, let us look at from the second standpoint. Let me pose a question to all of you. Forget about time limitation, right? Marginal cases, there may be some confusion. But supposing somebody is who says my amount was due in 1991, time barred can be any amount, any period of time, and he comes and files a claim for 30 years. Will you be silent? Will you accept that claim? So therefore, the same logic applies. If 30-year-old cannot be admitted, then naturally, the 3-year-old plus cannot also be admitted. So this is the second, round of logic. The third one, now that's the most important one. And rather, there is one more after that. As an RP, my dear friends, you are the board of directors. You step into the shoes of the board of directors, the entire power of the board is vested in you. Will you not think like the board of directors? Supposing a claim is, say somebody writes an email to the corporate debtor, if the company was not in CRP and it's a time bar debt, what will be the answer given to the managing director by the managing director of the company? They will simply say that look, this is not admissible. Sorry, we are not paying. Do whatever you want to do. Because they also know that if they go to the court, then naturally nothing is going to happen. Now, let us go to the last logic. If you admit the claim of a time-barred claimant, say 50 lakh of rupees, and the other claims are 1 crore of rupees, don't you think those creditors will object tomorrow? They will say, why you admitted it? This is beyond law or limitation, and you have to comply with all laws. So, according to me, I will also endorse the view of Mr. Anil. I will also endorse the view of Geeta ma'am that look, if there is a time barred debt which is there, it is our duty to see that it is not time barred. It is not, Mr. Jaina, that's my view.
One point.
We can differ. Just a sec. It's my view. It is not adjudication. It doesn't fall under adjudication. It is falling under the verification or substantiation because it's substantiation. Please substantiate. So I think,
Sir, one point.
Yeah, please go ahead.
Sir, then actually, when a debt becomes time barred, the right to recovery debt does not extinguish. But the taking the legal step, he cannot go to take the legal recourses. Creditor cannot take legal recourses, but the right of recovery that does not extinguish. But that I understand, sir.
No,
So
that's
therefore, when
I'll tell you. I'll give an answer very quickly to that. See, the right to recover is not died. Right? I agree with that. It is not extinguished. It is only right to file. The legal remedy has been extinguished. But please understand, the right to recovery is also dependent upon my admission. Now, the moment you admit the claim, assuming now you are saying you are not time barred. Please understand, now you are extending it is an acknowledgement of debt under section 17 of the under section 18 of the Limitation Act. Then it will be a problem. You are admitting now. So therefore, such claims cannot be admitted because otherwise he will say, oh, there is an acknowledgement of debt by the corporate debtor now. You admitted my claim.
Then just a follow-out question to this discussion, sir.
Yes, sir.
Then if the RP or the liquidator, if the RP collects some claim or the liquidator admits some claim,
right?
Will that amount to acknowledgement under section 18 of Limitation Act?
See, that's a different question because at the end of the day, please understand, you will naturally write back to the person that your claim is admitted. You have to give it in writing, isn't it?
Sir, will that amount to acknowledgement?
Yes, sir, it will amount to acknowledgement for a very simple reason. Please understand what the section 18 says. That even if it is not acknowledgement, because there is one condition that acknowledgement has to be before the expiry of the limitation. Forget about even acknowledgement. But a time bar debt agreed to be paid or admitted, that you are admitting your liability to pay, then the limitation will start again. That's the problem. So therefore, it is advisable
The
that
limitation will start only when it is acknowledged. Only when it is acknowledged by the corporate debtor by its agent. Sir, my simple question, sir. Then in this case, is the liquidator or the RP is an agent of the corporate debtor?
no, he's not an agent, sir. He's the boss of the company. You are
Sir,
the,
as per
you are
section
enjoying,
18,
you are
section 18, only the corporate debtor, only the company or its agent, if acknowledges, then it will be treated as acknowledgement. So my point is that if RP admits or the liquidator admits, suppose it is within the limitation period, suppose that is admitted, will that be treated as acknowledgement? Because unless until the RP or liquidator is treated as agent of the company, then that will not be treated as acknowledgement.
I think, Mr. Jaina, you are over analyzing it right now. It is not the situation. Let me explain. The acknowledgement has to be on behalf of the corporate debtor. Forget about agent. There is no agency principal relationship here. Naturally,
I am talking about section 18. As per section 18, only company or its agent can acknowledge. So when somebody is giving acknowledgement on behalf of the company, that means he or she the agent of the company. Therefore, I am asking whether RP or liquidator can be treated as agent of the company.
Let me answer, sir. I've understood you are talking about section 18. I'm also, answering in the light of section 18, but I'm trying to create a background to it. मैं थोड़ा भूमिका बना के so that everyone gets knowledge about it. Number one, you are the board of directors of the corporate debtor, so you are nothing but a corporate debtor. But corporate debtor always acts through somebody. They act through directors or employees. To that extent, directors are considered as agents. So similarly, to that extent, you may also be treated as an agent. But the fact of the matter is you have got powers of the board. So every action you are sending an email, you are sending in the capacity of the RP for so-and-so corporate debtor. So you are the corporate debtor. In fact, please understand. Don't get confused. You are running the company. You are the CD. You are entitled to take any decision on behalf of the CD. So the moment you admit, like in case of liquidation, let's take the example, you admit it. After admission, if it is not an acknowledgement, then will you pay that person under 53 or not? If you have admitted a claim, you're bound to pay it. So therefore, it is an acknowledgement, my dear friend. Let's not get into that. But under section 18, the conditions are a little different. Under section 18, there are three conditions. A, acknowledgement must be in writing, signed by the borrower, right, or by his agent. And third, that condition is that this acknowledgement must be given before the expiry of the limitation period. Now, that may not be satisfied in your case, right? Because you are admitting a claim after 5 years of it. But having said that, look at the Indian Contract. Indian Contract Act says that a contract or agreement to pay a time bar debt is also a contract. So your new contract will start now. So the moment you admit, it becomes a contract under the Indian Contract Act. So then you are bound to honor that contract. So therefore, this is an admission to that extent, right? I hope I'm clear on all these aspects. So therefore, friends, let us not get, I think this discussion tells us, let's not create acknowledgement. So we should do what the previous board or the suspended management was supposed to do. We are sitting in their place. So we have to think according to that. I think Mr. Anil Anchali has also shared one of the articles. Maybe I've not gone through it. Is it an article or is it a judgment, sir? Article. Okay. So anyway, you can download. See, even articles are opinions. So we don't want to.
That is on time bar claims, basically.
So that's a matter of opinion. So I'm also opining that we should not be admitting or accepting the time bar.
So regarding this subject, just a query. See, my section 9 application is within the time, and suppose CIRP initiated on that application, but when I will submit my claim before RP or IRP, it is time bar. Suppose because 3 years lapse after this period. So whether this claim can be admitted or it is time barred.
Okay. Friends, let us understand one more thing. The moment you have initiated a process, your time limitation stops. And now I can draw your attention to section 60, subsection 6, but that is on a different footing, but that will also help you to some extent, right? See, there are two things. Let's say you filed an application on 1st January 2023 and it was admitted on 1st April 2023, right?
Correct.
And so the limitation can expire within this period or after that also, but before you file the claim. So there can be two situations. Section 60 subsection 6 covers after the CIRP period. Let's look at 60 subsection 6. I think most of us are aware, but let us look at you see that aspect. Okay. Section 60 subsection 6 says, notwithstanding anything contained in the Limitation Act or in any other law for the time being in force, in computing the period of limitation specified in any suit or application by or against the corporate debtor for which an order of moratorium has been made under this part, the period during which moratorium shall be excluded. So everyone gets a benefit of the moratorium period, but moratorium unfortunately starts from the date of the ICD. But date of filing of the application and ICD, there may be a time gap.
Correct.
But the fact of the matter is, yes, by the time you file, it might have gone, under limitation. But still, since it was your application, naturally your claims will be admitted or might be admitted, but maybe others not. But a concession probably can be given to you. But please bear in mind, there could be a different judgment tomorrow. ABC is not a recovery proceeding.
Sir, I have also said that reply which I generally send to the operation creditor for on time barred claims.
Yeah.
The RPs can go through this also for their reply.
Right. Okay.
Makhija sir, I have a couple of points to share, if you permit.
I'll just complete this and we'll come back to you. So therefore, it is extremely important that as a person who is starting CIRP, and if my claim is also getting barred, I must also file a suit. Because what will happen? Supposing CRP is admitted, that suit will automatically come under moratorium. So I have nothing to lose. So such OCs and FCs whose claims are getting time barred, they must protect themselves because these are additional remedies, right? These are alternate remedies.
Suits or arbitration also.
Arbitration, whatever you want to do, start that also. Because pata nahi application admit ho ya na ho. Or agar ho jayegi, if it is admitted, then that naturally moratorium will come into effect. So you have nothing to lose. So protect yourself, I think. Yes, Geeta ma'am, go ahead.
I actually wanted to share 2 points, sir. One is, in one case, we had sought a clarification from the home buyer.
Okay.
And since he did not respond, we've not actually collated his claim.
Right.
And then he moved an application in NCLT.
Right.
NCLT actually observed, I just wanted to share this for the knowledge of the members. They have actually recorded one fact is that the RP should have placed this matter before COC for a decision.
Right.
To accept this claim or not.
Right.
So, but then he did not respond. The applicant did not respond to the mail that was given to him. So that was one instance. Second instance was, I just wanted to share, and I also want to check myself whether what I did was right. In this case, what happened was, the applicant, that is who brought in the CRP, actually had an arbitration also against the corporate debtor. And since the corporate debtor had a counterclaim, the arbitration matter was continued during CRP.
Okay. I've got a different view. I can share a judgment, but anyway.
That is right. Because I actually wanted. So what had happened was, towards the end of the CRP period, when the liquidation application was being considered, the arbitration award came. And the saddest part was, the arbitrator had passed a fantastic order in the sense that on one side she said the corporate debtor has to pay some money to the applicant who brought in the CRP, and the applicant himself has there was a payment from either side. Both the parties have to pay each other. That was the award that was given.
Yeah.
So based on that, what I did was, because the applicant in the who was the CRP is also the applicant in the arbitration case, his claim was redone based on regulation 14.2.
Right.
I recasted the voting. wherein his voting percentage substantially dropped, because I took an opinion to say that when I have admitted him as a financial creditor, then I have no authority to remove him as a financial creditor, because the court is also, the CRP has commenced based on his application.
Right.
So what I did was applied 14.2 and reduced the amount. So that was what I could do, because that is the opinion that was given to me. But then what had happened was when the applicant came to NCLT, they said they had gone and appeal. 34 application was filed against the arbitration award. They said, and that award, there was an interim stay. The interim stay only for the, it is for the operative party. The interim stay was very clear to say, for the operative part, there is a stay. So they wanted me to reconstitute the COC, that is to revert back the original position, which I refused. So I just want to know whether I was right in doing that.
Refused to whom? To NCLT you refused? Or to...
No, sir. The financial creditor
Financial creditor, okay.
Raised it in the meeting to say that their position has to get restored. But I said, because it's only the operative part that is stayed, there is no stay on the arbitration award as such. So whatever I did under regulation 14.2 stands the same till date, till the 34 application is disposed of.
Aja, I'll answer this, but I have your address, so I'll send my invoice.
Sorry, sir?
I said, I will answer this, but since I have your address, I will send an invoice to you.
Thank you, sir. You're welcome.
Okay, so the point is, you see, you must read the Arbitration Act. The Arbitration Act says that the award has not attained finality. Award attains finality if no 34 and no 37 is pending. Please understand, stay or no stay, forget about that. So section 35 is very clear that when the award attains finality of Arbitration Act. So it says that award attains finality if the setting aside of the award under 34 or appeal under 37 is not pending, or even the time period has not expired. The time period for 34 is 3 months, 90 days plus 1 month, right? 1 month can be granted extension. So you have to typically wait 120 days. I don't know whether you waited for those period 120 days to reduce their claim or not. So you should have waited for 120 days, because that award does not attain finality till the time that 120-day period expires. So I think for all members, RPs who are hearing us, this is a very interesting situation which she has mentioned. If the claim of the is reduced because of the arbitration award, because some recovery is to be made, naturally that claim has to be updated, right? And that is to be reduced. But please do not do so till you wait 120 days. And if they have already gone ahead and filed 34 or 37, whatever it is, you wait for that decision to happen. So therefore, it is, I would say, since you have already taken that action based on a certain legal opinion, now you need another legal opinion to revert back. Because you reverted, because otherwise this fellow, if he goes to NCLT or goes to IBPI, there will be some difficulty. So therefore, this is my prima facie. Of course, we need to look at the papers, because without looking at the papers, without going into those details, my opinion can also be wrong. Okay. But this is the broad advice which I can give you. Okay. I think interesting situation. Friends, we are learning from the experience of this thing. And ma'am is a very, I would say, is a very dedicated person, very serious player. And also she knows a lot about, you see, RPs and all. So if you need any practical aspects, I think you can always get in touch with her, ask about those questions, and she'll be very happily able to answer that also. And she comes forward and answers all these questions. So please take her number, contact her. I think that will be good. Okay. So that's one. Okay. So time barring, I think we have all discussed. I think everyone is clear that they are not going ahead with this. And our friend Anil ji has shared that letter also. Anil ji, thoda sa main usse differ karta hu. Maine abhi just glance kiya hai. You are saying that it is not even a claim as per section 3.6, right? Since it is not a claim as per section 3.6, so therefore I will not admit as a claim. This is what you have mentioned in that, based on the article.
Time barred claim. The definition of claim does not include a time barred claim, as the right to payment or right to remedy as contemplated in clause A and B of section 3 subsection 6 are not available in respect of time barred claims.
मैं समझ गया सर, मैं वही तो बोल रहा हूँ, सेक्शन 3.6 का सहारा ले रहे हो ना आप, 3 का सहारा ले रहे हो. I beg to differ. That's what I'm saying. I differ with that. So try not to write that. Because just now, I think, where is Mr. Jaina? Mr. Jaina, if you can hear us. See, he right now pointed out, and that was a great learning for all of us. What he mentioned? He mentioned, and I fully agree with him, that it does not extinguish the right to receive payment. Limitation, please understand, what is the logic behind limitation? Limitation means that if you're sleeping over your rights, then you can't approach the court and your right of remedy is extinguished. Remedy is extinguished, not right to payment. Right to payment आज भी है. Right to payment, अगर देखिए, अब मैं एक और logic देता हूँ. If the right to payment is extinguished, then the company, after 3 years, every company should write off. फिर तो books में ही नहीं आएगा ना. Because nobody can claim that amount, but they can still claim. Please understand that only right of remedy to file a suit and claim the amount in a court of law is barred by limitation. It is not barred कि मैं payment ही नहीं दूंगा. If the corporate debtor wants to give payment, that's why I said please read Indian Contract Act. I think let me give you a section. Jaina sir, can you just find out what is the section for that? I just don't remember it right now.
कॉर्पोरेट डेटर अगर बोलता है पेमेंट ही नहीं दूंगा तो
इंडियन कॉन्ट्रैक्ट एक्ट,
सॉरी, इंडियन कॉन्ट्रैक्ट एक्ट में टाइम बार डेट का आप एक बार जरा पीडीएफ में सर्च मारिए, वहां पे आ जाएगा, बार्ड बाय लिमिटेशन और समथिंग. देयर इज अ स्पेसिफिक सेक्शन. सो कॉर्पोरेट डेटर, सपोजिंग you want to claim from me, right? It is time barred, I'm not paying you, but I can still pay you. So your right to payment is still stands. Nobody is denying that. What is barred by the law is right to recover in a court of law. So आपका जो लॉजिक है पहला से जो है वो थोड़ा सा मैं उससे डिफर करता हूँ, थोड़ा सा उसको रिविजिट कर लो. That may not be there. That's about. Okay. In the meantime, Mr. Jaina will tell us. Okay.
Sir, my laptop is not working. I am just watching over my tab only.
Okay. Let me see if I can have a look at it just very quickly. I'm just forgetting the section number. Otherwise, it is there in Indian Contract Act. Just give me a moment. Okay. It was already open. Okay. Okay, section 25.
On 25.
Section 25. Promise to pay a debt barred by limitation. So therefore, the point is, if that would not have been the case of that amount also extinguishes, then there is no contract. फिर तो consideration ही नहीं होता ना. So today there is an amount which is payable, but I am agreeing to pay and I am entering into a promise to pay that says it is not void. Section 25 very clearly says. So therefore, one can always enter into pay time bar debt. And in fact, if you look at section 60 also, which talks about appropriation. Now, supposing you are paying, corporate debtor is paying say 5 lakh rupees as a lump sum on account payment without mentioning against which bill you are saying. This is another problem. You see, please advise your clients whenever you are making payment, please point out which bills you are making payment. And this payment should be adjusted to against which bills. Because if you don't say that, because first right is with you under section 59 of Indian Contract Act. Section 60 says that if the person who is paying is not mentioning, then the creditor has got a right to appropriate, and he can appropriate even against the time barred debts also. Yes. Time barred debt तो live हो गए ना फिर, तो right to recover तो था ना, उसका right to recover payment था ना section 60 में. Therefore, and if both of them do not do, then it is by the chronology of time, first in, first out. So section 61. So please read 25, 59, 60, 61 of Indian Contract Act. Okay. I hope things are clear now. Let's not debate further. Let's move to a very interesting 2 questions which were asked. Okay. By our friends. One was relating to the priority to the people who are not voting in favor of the resolution plan. So let me give you a background, and I think our friend, I believe, who asked that question? I am not seeing him. Okay. Sir, can you open your video?
I think Mr. Kshitij asked it.
Kshitij. Yeah. Right. Okay. Kshitij is there or not? Okay. Chalo, anyway, I'll try to answer. So what Kshitij asked, my dear friends, was this. Go to section 32B. What does it say? 32B provides a guarantee, minimum guarantee, to the operational creditors first, that they should not be paid less than the liquidation value. That is the guarantee which is inbuilt under 32B. Along with that, the clause also provides some kind of a guarantee, minimum guarantee, to the financial creditors who have voted against the resolution plan. So please note this word, friends. Voted against the resolution plan. Do not use the word dissenting, because dissenting can be two ways: voted against and not voted, absenting. So here the specific words used in this section are voted against the resolution plan 32B. And I'll just read that portion. And the resolution plan must provide for this, provides for the payment of debts of the financial creditors who do not vote in favor of the resolution plan in such manner as may be specified, which shall not be less than the amount paid to such creditors in accordance with section 53 of the in the event of a liquidation. So I think my friends are aware. As far as OCs are concerned, you have to compare three figures. What they are getting under the plan should be compared with what they are going to get if the liquidation value is distributed in accordance with 53. And third is, if the resolution plan value is distributed in accordance with 53, so they are entitled to get higher of these three. Right? So I think most of the time, the amount provided in the plan is naturally higher because OCs definitely don't get anything under liquidation. So typically speaking, that is the situation. But yes, we have to do that check. एक आपको template बनाना पड़ेगा Excel sheet में. The second is relating to dissenting. Here there are only two limits. One is what they are getting under the plan must be compared with the liquidation value if distributed in accordance with 53, what they are going to get. So compare these two figures, they are entitled for higher of that amount. But his question was not relating to that. His question was, in fact, one of the regulations also says very clearly that the amount payable to operational creditors under section 32B and also the dissenting, and also to the creditors, financial creditors who have voted against the plan under section 32B must be paid in priority over other creditors. This is the regulation which talks about. The plan must provide for that. And naturally, every plan says, yes, we are going to pay in priority. His question was not this priority also. He said, one of the creditors said, this means you pay me upfront. That means the day the plan is approved, you have to pay the next day. He was saying that, look, my view is that I am not going to pay you upfront because the law doesn't say. It simply says your debts will be settled in priority of other debts. That means before I pay to the other financial creditors, you will be paid. And I think to that extent, my dear friends, I agree with him. The law is very clear. It is not talking about upfront payment. That the day the plan is approved, you have to pay to the dissenting the creditors who have voted against the plan or the OCs as per section 32B. That is not the intention. Okay. I believe Mr. Jaina is also agreeing with me. Okay. So that is one. The second, he touched a very, you can say, a sentimental chord, isn't it? Everyone is facing the problem. What was that? PF and gratuity dues. Now, PF and gratuity dues have created a lot of problems for everyone. And there have been different opinions before the different benches also, right? But ultimately, the Supreme Court view is naturally supreme. And that has come in an indirect manner in a Jet Airways. Now, NCLAT upheld that because it was the appeal was filed by the Jet Airways employee union or something, workers union, saying that the dues of their PF and gratuity dues must be paid, you see, before, and the plan is silent about it. So the NCLAT said, no, you must provide. And the liability is not less than 200 to 300 crores. I think that's the amount. Naturally, if I have submitted a plan of, say, 4,000 crores and I'm asked to pay 300 crores more, I'm in a great difficulty, isn't it? And unfortunately, I don't have an option to withdraw my plan. That is another problem in the CIRP or IBC, because the situation has changed dramatically now. Now, the appeal was filed before the Supreme Court, and Supreme Court in this appeal has written very clearly that we are not entertaining this appeal, and we are directing that please pay, please provide it, and they have been directed to provide for this payment. So 200 crore, that amendment has to come under the plan now as per the Supreme Court judgment. So in a way, they have upheld the unclad judgment, and they have said that they have held that the PF and gratuity dues are not forming part of the entire gamut. They are much above. So therefore, they must be paid in super priority. That's the problem which has arisen. And now, the problem can also arise in liquidation matters also, and in some cases it has arisen also. And NCLAT in one or two judgment has said that, look, they are a priority as per the Supreme Court. And Supreme Court, honestly speaking, my dear friends, today, if you approach Supreme Court, Honorable Supreme Court, filing an appeal against the PF and gratuity dues, it will be dismissed the same day. They're not even entertaining. This has happened for the fate of other appeals. They have been filed in last 6 months. 3-4 appeals I have seen. They have all been dismissed on the same first day itself. Sorry, we don't want to interfere in this. So Supreme Court is very particular right now. I mean, I don't know whether it goes for a larger bench or later on. We don't know what will be the fate. The problem actually, why it is arising is because of the background of the things. Let me share with you, when the insolvency bill 2015 was being debated in the parliament, right? Or was being considered by the standing committee of the parliament. Discussion to khair hota hi nahi hai, but only thing is it was being considered by the standing committee of the parliament. So in that case, the standing committee of parliament invites comments from all fronts. So what they did, PF department also represented. And PF department said, particularly in respect of individual, because it also has individual insolvency. And if you look at the excluded assets definition, which is given in section 79 of individual this thing, it does not exclude the provident fund. So they actually, on that basis, they approach. So look at the logic of the PF department. The PF authorities said, look, these are the dues, gratuity and PF, which a person has worked over a period of time. These are his retirement dues or whatever you may call it. So they should also be excluded from bankruptcy. I mean, he has to provide for his family or whatever it is. So please exclude that. And naturally, the courts are little, you can say, tilted towards they favor this workman and other people. So in any case, Parliament also, I mean, the standing committee also considered that. And they, change that provision. They put in one provision that this money cannot be touched by bankruptcy trustee, right? That exclusion was provided. Now come to the liquidation part. What they wanted to say, see, for the individual, PF and gratuity is an asset for that individual, right? It is an asset because he has to receive the money. But for a company, is it an asset or a liability? Actually, it is a liability because it is to be paid on behalf of the workman or for the benefit of the workman. So it comes as a liability. It is not an asset. But unfortunately, the language which was used for individual was also brought in section 36. Let's look at 36. It makes an interesting reading. So that is why I always say, there are a lot of drafting errors are there. 36, my dear friends, deal with liquidation estate, isn't it? So, and it says, subsection 3 says liquidation estate will consist of following assets. Subsection 4 says liquidation estate shall not include the following assets. And the word is, the following shall not be included in the liquidation estate assets. Underline the word assets, my dear friends. And shall not be used for recovery in liquidation. Fine. The first one says asset owned by third party which are in possession of the corporate debtor naturally, right? Similarly, then they say assets held in trust, bailment contracts. Then the third one, this third clause was added after the representation of the PF department. But मुझे लगता है गलत जगह पे डाल दिया. Now what they are saying is all sums due to any workman or employees from the provident fund, the pension fund or gratuity fund. Now please tell me, I have not been able to understand so far, is it an asset or is it a liability of the company? Again, if this is a liability of the company, why it is coming under exclusion under the asset? So it is a placement under a wrong section. But forget about that. Forget about that. The intent was the money due to the workman on account of pension, gratuity, and pension fund should be excluded. For individual in their hands as an asset, and for the company from their this thing. So they should not be able to use this kind of money if it is not paid. But uske placement thodi galat section mein ho gaya, but that doesn't mean. So therefore, Supreme Court is going on that logic. They have gone into that history and they have said that, look, this is what we are also agreeing. But fact of the matter is, on this issue, there is one NCLAT judgment. I don't remember the name right now, but there is an NCLAT judgment which says that PF authorities dues
Sir, we
Sir,
can't
you are
hear
on
you.
mute, sir.
Yes, sir. Please, sir. Anyone who wants to speak?
You are on mute, sir.
Okay. Am I audible now?
Yes.
Okay. Yes, I think some people wanted to speak on this.
Sir, you have to repeat your last sentence. We're not able to hear.
Okay. Acha, no, I am saying that there have been a lot of contrary judgments. One of the judgments say that they have to stand in the queue as far as the PF and the gratuity dues are concerned, and they will be paid in accordance with the priority. That means under as a government due. But there are contrary judgments also which say they are the topmost priority. So typically more judgments are favoring the super priority, but there is still a confusion. I think in liquidation particularly, I think that things have to go to the Supreme Court to get a clarity. But unfortunately, what is happening today is the moment you say it is a PF matter or gratuity matter in IBC, they say, sorry, we are not hearing you, dismissed. Actually, this is happening in these matters. Particularly, our Honorable Chief Justice right now, Chandrachud Saab, is very, clear on this issue. He does not entertain. So I think we don't know. The things may change, you see, after some time, we don't know. But right now, the opinion is that they are the super priority. Okay. I hope I'm able to answer that question. Friends, let's get back to our presentation now. And I think there are 2-3 aspects which I would like to mention. And then we will take it from there. Okay. Just give me a moment. Yeah, this we can close. Yeah. Okay. In the meantime, if there are any more questions are there, naturally we can put it in the chat box or you can unmute yourself. We will have a discussion. Okay. So this is what we were talking about. Now here is a slight contradiction also. It says first COC meeting is to be held within 7 days of its constitution. But if we go to the regulations, my dear friends, it talked little differently. We'll come back to that. We'll discuss that. So let's look at this. So these are the voting percentages for decision by COC. I think we are all aware that 90% is required under section 12A, 66% is required under 12.2, 27.2, 22.2, 28, 34, 33.2, and also regulation 29.2. Regulation 29, I believe my friends are aware that if you want to sell any asset outside the ordinary course of business, then you have to take permission of the COC. Supposing it's a perishable asset lying with you and you want to sell it, get rid of it, you can do that, but provided you take approval of the COC with 66% under regulation 29. And naturally, any decision which requires anything which requires a decision making, typically it is 51%, but for these specific matters, it is 66 or 90%. I think we are all aware. This is what regulation also says, and section 24 also says meeting in person or by electronic means. RP will conduct, in fact, the RP is the convener and the chairperson. And it also says, it doesn't talk about the frequency of the meeting, right? In one of the case of IBB, I said there is a gap of 8 months, which is too large. But factually speaking, the IBC is silent on the frequency. So when that meeting should be held, the law simply says he can convene as and when it is deemed fit. And he must convene if 33% of the COC members request for COC meeting. Friends, here is one of my suggestions. That suggestion is this. Do not keep too much gap between one COC meeting or another. Typically speaking, if it's a reasonably sized company, if it's a going concern in any case, I think you need to hold a meeting once in a month, minimum. Please mark this. If it is not a going concern, but still you are able to say, because when you move forward in CIRP, you start discovering many things. Like you may get hold of some asset, you may get hold of some other data, information, and Form G, kai cheezein aapko karani hai. So I think I would still suggest, whether it is going concern or not, please hold meeting at least once in a month. और 2 महीने से ज्यादा तो delay कभी भी मत करना. I think that's my advice which I can give you. So this is, though the frequency is not mentioned, but we need to look at that. We should be reasonable in holding. Okay. Then, and in any case, if more than 33% of the COC members, that is not the numbers, voting share. If they request for the COC meeting, then it has to be convened. No quarrel on that. And meeting notice, I think all of us, here also there are 1 or 2 issues are there, we'll discuss. Notice has to go to the COC members and also to the AR. Okay, I think we promised to take a break also, isn't it? Okay, 3-4 minutes are left. Okay, at 3 p.m. I think we'll take a break for 5-10 minutes. Is that okay? Okay, so yeah, okay. Let me cover this 1 or 2 slides and then I think we'll take a break. Suspended directors are also required to send a notice. Naturally, they don't have the voting right, but which suspended directors? Now that sometimes becomes a question. So those directors who were directors on the date of ICD, right? Insolvency commencement date, because they will be categorized as suspended director. Jo pehle resign kar gaya, so he was not a director on the date. So this is very clear. Now here comes a little problem. OCs or their representatives, if the aggregate dues are not less than 10% of the debt, then they must also be given a notice of the COC meeting. Look at the words, and I think I've repeated what is mentioned in section 24. OCs or their representatives, if the aggregate dues are not less than 10% of the debt. Now here comes, sorry?
OC having more than 10% of debt, then they are participant, but no voting right.
Naturally, no voting right, but here comes the confusion. And I think I've got maybe one slide on this. Yeah, look at this. This is an issue. If I read 24(3)(c) plain reading, the question that arises is whether notice to be sent to all OCs. Now here comes a judgment here. I mean, I'm telling you, I defended the RP. Now, okay, let us deal with that judgment first. And okay, let's look at this and then I'll come to that judgment. Now, whether all OCs, now another question which arises is whether all OCs who have 10% or more of the debt are to be sent notice of the COC. Like, let us take an example. All financial creditors, the debt owed is 10 crores. There is an OC who is A, to whom 1 crore is owed. And there is no other OC. There is only one single OC, A. So now his debt is not less than 10%, right? It is 10% or more. So naturally, he will be invited to participate in the meeting. There is no quarrel on that. But let's take a second example. The second example is all FC's dues is 10 crores. OC to OCA 1 crore, but there are other operational creditors 10 lakh. Now the question is whether OCA will be invited or a representative of OCA plus other OCs will be invited.
OCA.
Achha, now one more aspect. Supposing, let us change the example. Supposing there are 3 OCs, right? 3 OCs, OCA, B, C, and all of them are owed 1 crore rupees. 3 OCs are there. So will you invite all the 3 OCs? Or will you invite only one representative of all the OCs?
All OCs.
One representative.
Yeah. So
all, sir. Here it is OC having total credit more than 10%. That means everyone who holds more than 10% is to be invited.
Okay. Okay.
Sir, one more query here. So regarding your example, so you stated that FC debt is 10 crore, OC debt is 1 crore.
अच्छा उसको छोड़ दो, चलो वो मैं समझ गया आप क्या पॉइंट आउट करना चाह रहे हो. आप उसको
कैलकुलेशन
आप इसको 9 करोड़ मान लो, चलो ठीक है.
yes.
नहीं वो वैसे भी 10% ऑफ दी यू सी. हाँ ठीक है, चलो
10% of the total debt हो ना. This will be 10% of total debt only.
Okay, okay. I agree. I understood your point. So let us say FC's का 9 crores है, ठीक है. Let's change the example. I'll definitely. Thanks for pointing it out. I'll change my this thing. Okay, यही होता है सर जब रात को बैठ के बनाओ तो नहीं. Anyway, क्योंकि I'm very you can say I don't really usually borrow from something, so I do it ingenuinely. So maybe there is a slight mistake which has occurred. I think that's right. Let's treat that all FC's claim is 9 crores and OCA is 1 crore. So therefore it is 10 crore and he becomes not less than 10%, right? Okay. So I think the questions are very interesting. Let me explain once again. If there is only one OC who has got more than 10%, right? And there is no other OC, there is no quarrel, he will be invited because he is more than 10%. कोई doubt नहीं है किसी के mind में. But supposing there are 3 OCs whose debts are more than 10% individually. Now the question is whether all the 3 should be invited or only one. That is the first question. I'm not answering it right now. I'll answer it in a little while. This third situation. There are 3 OCs of more than 10 CR. Plus there are other OCs also. So now should only these 3 be invited or should one representative of A, B, C and other OCs should be invited? That is the question. That is the question. Friends, and second aspect, which I argued before NCLAT, and I'm happy that because there was an allegation against the RP and I got him, you see, and the NCLAT said RP has done right. So he was not, you see, this thing, put in a dock. I can share that judgment with you also. But what all I'm saying is this. What you need to do, let's understand this. The law, my dear friends, if you read, and we have to read 24(3)(c), right? Along with 24(4). We can't read alone because it is why I call it as conjunct reading. If we read only one, our answer will be absolutely wrong. What does 24(3)(c) says, which I have produced on my slide also? The resolution professional shall give notice of each meeting of the committee of creditors to operational creditors or their representatives if the amount of their aggregate due is not less than 1% of the debt. So if I read it plainly, it is not using the word operational creditor. It is using the word operational creditors. That means the entire body of operational creditors is treated as one. Operational creditors or their representatives, if the amount of their aggregate due, if there, it does not say if it's, if there. So therefore, if the combined debt of the operational creditor is more than 10% of the total debt, then these operational creditors have to select one person as their representative. It is not individual 10 crore. If there is only one creditor who is more than 10 crores, more than 10%, fine. Naturally, he will be invited because he's the only one. But if there are more than one, please do not make a mistake of inviting one only and not the others. Even others are not invited, but what you need to do, and this what I explained, and what this is actually because we were advising the RP and therefore he was saved. He saved his skin. So therefore, another suggestion is, if you are doing CIRP or RP, please always attach with a good lawyer. भाई साहब जो उस टाइम वो ओपिनियन देगा ना, वो आपको बाद में बचाएगा. मैं आपको 100% बोल रहा हूँ. आज आप पैसे बचा लोगे, 25,000 रुपए दे दोगे, लेकिन बाद में फंस जाओगे. So please do not do that at the cost of your professional this thing. And I tell you how he was saved. There were 40 operational creditors were there, and one was more than 10%. But and naturally the combined will also be more than 10%. अगर एक का 10% से है तो naturally बाकियों का भी overall में भी aggregate is more than 10%. So he took my advice. What should I said, what is your duty? Now there is a meeting. You write to all OCs and don't send in BCC. Send in CC only. Give the email IDs to the other OCs also. Don't worry. Write to them. Please select one of your representative and tell me whom should I send the notice of the COC. I'll include you. I'll invite you. They did not respond. Second time he also mentioned, I said, repeat it after 7 days. He repeated. Then one of the came, I can be your representative. One person responded. The other from Chennai said, no, majority are from Chennai. Representative should be from Chennai. So they start fighting within each other. So RP said, please decide, only then I'll invite you. Sorry, till the time you decide, I will not invite you. So naturally, COC meetings held, plan approved, they were not invited. So when they raised the objection against the plan, this was the objection that RP never did that. Then I justified, I showed them all the emails, and NCLAT, while looking at these emails, has said we are not able to find any fault with the RP. And there was also another query, another objection by one of the creditor. He said, I was more than 10%. He should have invited me alone. The bench said, sorry, you are not entitled. It is the whole body of the operational creditors that they will select one representative. Because now I made them read, because once they read 24.3c, the bench also asked me the same question. Then I made them read 24.4. Let's read 24.4, friends. I said, my lords, one section cannot be read alone. 24.4 says the directors, partners, and one representative of the operational creditors, as referred to in subsection 3, may attend the meeting of the committee of the creditors. So 24.4 says very clearly one representative of the OC. So 24.3c read with 24.4, it is not that 5 people on behalf of OCs can come. It is only one representative combined, provided their aggregate dues of all the OCs together is more than 10% of the total debt. So friends, single individual more than 10%, you are not obliged. Write to him and write to others saying that please select one of your representative. If they select that person, that's fine. I mean, I have no objection to whom they select. So, and NCLAT has fortified what I mentioned. And Shiv Shakti Elmex, I think that was the name of the judgment. I'll just try to pull it out and I will share it with you. So that is the judgment which was in our favor, and we got relief for the RP in this particular case. So friends, I hope I'm clear on this particular aspect. Okay. Let's take a break now.
Sir, just one point, sir. Sir, in case of 21.6, that home finance case, that they will decide, and each vote, each creditor, one vote. Here, how will they decide? Suppose one operational creditor is 10 crore and others all total they're less than 10 lakhs. And less than 10 lakhs, they're 100. And 10 crore operational creditor, he is telling, I am the representative. So in that case, how will we take the authority, the representative of all the operational creditors?
Okay, you are talking about the voting share, but you see, in fact, the NCLAT also raised one more question, which is quite similar to what you raised. They said, why did not the RP hold their meeting? RP should have organized a meeting of the OC and decided the representative. Then I said, Malords, this is not my responsibility. He said, how? Then I read section 20, then I read section 21(6)(a), regulation 4(a), 16(a). I said, for the home buyers, the process, the law very clearly says that AR to be decided with the facilitation of the RP. Here, the law is silent. I will not facilitate. It is for them to decide. So therefore, how do they hold their meeting? How do they decide? I'm not concerned. But to answer your question, I think again it will not be on the debt value. See, अभी हो क्या गया, हम IBC पे बड़े ट्यून्ड हो गए हैं, हम डेट पे ही चलते हैं, तो डेट में मेरा वोटिंग परसेंटेज वही रहेगा, ऐसा नहीं है. If there are say 500 OCs are there, probably I would believe that one person one vote kind of situation will be there. Otherwise तो वो जिसका highest है वही ले जाएगा फिर all the time. So, but anyway, law is not clear. I agree with that for that with you, but it has to be simple only. Otherwise, if we start complicating things, अब देखिए एक ओसी को दूसरे ओसी का तो नहीं पता ना वैल्यू ऑफ डेट, वो कैसे डिसाइड करेंगे? तो इस फिगर तो आरपी के पास है. So then there will be a fight. So it is better to go भाई ठीक है आपस में बैठ के डिसाइड कर लो. You send it to me. So RP should not get into that.
Yes.
If you poke your nose there, you will be in trouble. So don't do that. But your duty is to inform them time and again. हर हफ्ते एक मेल भेज दो बस. That's all what you do. Okay, friends, it's 3:10 now. Maybe this time we can take a 10-minute break. Okay, I think I need a good cup of coffee right now. So we'll meet at 3:20. Okay, thank you.
Okay, sir. Well deserved, sir.
Thank you. Okay, friends, I'm back. So maybe we can start now. So I'll request everyone to please join back and open your videos. Okay. So I think let's move forward. I think there is some portions are left in the slides because there are a few more issues which we'd like to debate. And then, of course, we will keep it open for discussion on several aspects. Okay. So let's look at this. After this example, now there is one more aspect which is important. Probably many of us are aware whether suspended directors are entitled to notice agenda papers and minutes of the COC meetings. That's a question which was answered by Honorable Supreme Court in Vijay Kumar Jain versus Standard Chartered Bank. And this judgment is 31st January 2019, where it was clearly mentioned that yes, the suspended directors are entitled to notice agenda papers and minutes of the COC meetings. Now, typically I saw, you see, in 2018 and 19, what people were doing, most of the RPs, that whenever a discussion was taking place on, say, avoidance applications, avoidance report, whenever a resolution plan was being considered, whenever any other important aspect was being discussed, the suspended directors, they were asked to move out of the meeting, go out of the meeting. Now, this was a practice which was going on. Now, friends, let me share with you, this was not a good practice. And Supreme Court has actually come down very heavily in this particular judgment of Vijay Kumar Jain. They have very clearly mentioned that, look, what is the purpose of the suspended directors? The purpose of keeping the suspended directors in this is because these are the people who have been running the company for such a long time. So they are the best people to assess the resolution plan. And also, if the companies are going concern, they can really help you in organizing there to keep the company as a going concern. So therefore, they are very important subject. Now, as far as somebody raised a question, look, the data will be leaked out, the confidentiality will not remain there. Then the court said that, look, insofar as confidentiality is concerned, it can happen with any COC member also. So what do? You always take the confidentiality undertaking. You have also taken it from them. So what is the problem? If they breach, file a case against them. So therefore, that cannot be a ground to deny them the document. So friends, my request is, do not hide anything from the suspended directors. They are, and somebody also raised an argument in this judgment that they are only participants. And there is a one can distinguish between the participant and the members. Supreme Court rejected that argument also. He says, sorry, we are not going to hear on that. All participants are, they require all documents. So friends, do not tell them to go out of the meeting at any stage. Do not, say that you are not sharing the minutes of the meeting or agenda papers or notice with them. Be complete transparent with them, and of course you can have the confidentiality undertaking as that is required in any case under the law to have it. So whether they are entitled to all documents, the answer is yes. That is very, very important. Now, friends, one more aspect. I think we were just discussing with Geeta ma'am also. She said,
I have a small question on this point.
Yes, Yatish, go ahead.
So what if the promoters are themselves resolution applicants?
Okay. See, if the promoters are resolution applicants, then when you are discussing the resolution plans of the others, then definitely you can ask them to move out.
For that part of the meeting, we can request them to.
Yes. Because right, you are absolutely right when you say otherwise also that they know many things more than the other resolution applicants. So there is no level playing field. But be that as it may, law doesn't say that they have to be sent out if they are interested as an RA. But yes, when the other plans are being discussed or debated by the COC, naturally they are interested party. To that extent, then they will ask to leave the room.
So we do have a right to make them exit the meeting room, because sometimes the promoters don't agree to that also. They quote this judgment of Standard Chartered Bank. Say, boss, we are.
So only when they are also the RA.
Yeah.
If they are not the RA, then they are right. But if they are the RA, then you say that this judgment doesn't talk about that. So if you have any question, go to Supreme Court. We'll handle it. That's providing a level playing field. Otherwise, what will happen? I mean, they are discussing other plans also and improving on their plans. No, that's not done.
Right, sir.
Anyway, for that, I think I would also suggest that Swiss challenge ko aap adopt kar lo, so that then there is no question who is better, who is not better, isn't it?
Correct.
Achha, now we were also discussing earlier whether because Geeta ma'am said in one of the discussions that the CIRP period was over, the application for liquidation was filed, so we could not get it ratified. Now, this was a problem which was being faced, that we were not able to hold COC meetings after the CIRP period is over. Either the approval of resolution plan application is pending or liquidation application is pending with the adjudicating authority. Now, friends, I think all of us are aware that these regulations have been amended now, and now after this amendment, right, the COC meetings can also be held after the expiry of the CRP period, and while your liquidation application or approval of plan application is pending before the adjudicating authority. So there is no bar in holding the COC meetings even after the approval of the resolution plan. This has been added as an explanation to regulation 18.2. And let me read that explanation. It says, for the purposes of sub-regulation 2, it is clarified. So it's added as a matter of clarity that meetings may be convened till the resolution plan is approved or liquidation order is passed, and decide on the matters. Now, this is only one restriction which is there. You can hold the COC meeting for all purposes except one. And that is what is mentioned, to decide on all the matters which do not affect the resolution plan submitted before the adjudicating authority. So you can hold a COC meeting to talk about the going concern, to talk about approval of the expenses, to talk about legal updates or whatever you want to discuss. But if you are talking about the resolution plan or amendment of the plan, which has already been submitted, that is prohibited. But let me share with you, one of the RPs came to me. He said, sir, KB developer, and he was a RP of a real estate. And their resolution plan was silent about the home buyers who have not filed the claim. Now, he came to me, he said, sir, KB developer says that you must consider. So can I hold a COC meeting to amend my plan? Now, we gave him a 20-page opinion, and where I have mentioned in conclusion, saying that yes, you can hold it. Because we weighed this explanation, 12.2 explanation, sorry, 18.2 explanation as against the judgment of NCLAT. I said, if the judgment wants that this provision should be there, in fact, in that KB developer case also, they were allowed to amend. Of course, that was a specific case. But here also we took an opinion, we gave an opinion saying that yes, you can amend your plan because it is based on a judgment, and which has not, been set aside so far by the Supreme Court. So therefore, you can hold the board, who can hold the COC meeting. So meeting was held, plan was amended, and amended plan has also been submitted to the NCLT, and NCLT has not raised any objection so far. Of course, it will come for final hearing for approval of the plan. So these things are also possible. Try to set precedents, as much precedents as possible. Okay, so let us try to come back to the presentation now once again. Okay. So I think this we have already covered. So we can hold a COC meeting after the CRP period is over, but we are not discussing any matter affecting the resolution plan. That is what is the condition. Now, there is one more clause which is there, which I don't know how many COC members are making use of it. I think you guys are handling more COC meetings. So you must tell me whether financial creditors or other members of the COC are appointing IPs to attend, or they are attending, or their officers are attending.
Their officers.
Their officers, typically, yes, no?
Typically.
Okay, but not the IPs.
Never. They don't. They'll not never pay fees. They'll say that why are we paying our officers?
और पता चले कुछ भी बोल के आ गया.
Correct.
True. All right. Okay. Voting share to be determined by RP. I think this is what all of us know. Item or resolution. This was what we had discussed earlier. Item or resolution proposed by minimum 33% of the COC members in voting share, of course, must be placed before the at the COC meeting. So this is very important. Now here comes another important part, that 5 days notice must be given to call the COC. I think everyone is aware. This time limit can be reduced to 24 hours. So generally speaking, what the RPs are doing in the first COC meeting, they are getting this resolution passed that a meeting can be called with 24 hours or 48 hours, what the COC wants. But in case of the home buyers, particularly where AR being is appointed, this shorter period cannot be less than 48 hours. And the sending of the notices by email is a must. So you must do that. So that is very, very important. Okay. Email communication is must. Now, this is very important. I don't know how many of you are following it. When you call a COC meeting, do you state the name of the CD or the place, time and date of the COC meeting in the subject column? If you are doing it, friends, you are good. If you
Yes, sir.
Okay, good. If you are not doing it, please start following it. सब्जेक्ट लाइन में ये लिखना मैंडेटरी है. सिंपली सीडी का नाम लिखने से नहीं चलेगा, या नोटिस ऑफ 8 COC मीटिंग से नहीं चलेगा. So you'll have to write down the COC meeting had to be held on so and so date, time and place, and the name of the CD. All these things. Okay. One more aspect. Sometimes you transmit that email or bounce ho jati hai. So in fact, the regulation also tells you it is your responsibility that you must maintain or preserve those details. So please see that if the email is bounced, you retain that data also. Responsibility of COC members to update their mail. Obviously, that is their responsibility. Naturally, there is an option to attend virtually. Nowadays, most of the COC meetings are happening virtually only. And then, of course, this is also very important, friends. Notice must contain matters to be discussed, matters to be voted upon, and copies of all documents. So agenda papers जिसको बोलते हैं वो सब साथ में होना चाहिए. And manner of voting naturally has to be disclosed. I think most of you are doing it क्योंकि वो तो एक template बन गया, so copy paste ही चलता है. Okay, this is the quorum which we were talking about earlier. 33% of the voting share representatives must be present. Quorum can be modified for future meeting. Now this, I don't know how many of you are aware. So if it is 33%, now there is a question. I think Khatri Saab bhi hai, is a legal this thing, legal person. So let us discuss and debate. Here the regulation 22 provides that quorum can be modified. Now my question is, can it be modified even lower to 33%?
Lower 33% not possible. It should be more than 33%.
Okay. Okay. Can we just go through regulation 22? Let us read the exact language and then let's try to debate on that. Let's try to debate on. Okay. It says 22(1). I'll just read it for you. A meeting of the committee shall be curate if members of the committee representing at least 33% of the voting rights are present either in person or by video conferencing or other audio and visual means, provided that the committee may modify the percentage of voting rights required for quorum in respect of any future meetings of the committee. Now, Jana Sahab, aap ye bataiye. I'm just asking. I mean, I'm not saying whether we are right or wrong. Does the law restrict reducing it to 33%?
At least 33%. First, it is written at least 33%. Then it can be modified. That means, from that I understand. Next meeting, we can make it more stringent. That means we can increase to 50%, 60%, like that. We cannot make it lesser stringent. That is my point.
Okay, but the proviso which is there, that is not restrictive. Let's read the language again.
Sir, in the first line, it is written at least 33%.
It is all right, sir. वो तो at least तो लिखा ही होगा ना. अगर 20 होता तो भी at least लिखा होता. Point is not that, but here the proviso says, provided that the committee may modify the percentage. It is not saying increase the percentage.
Then spirit is that it can be more stringent.
We can make it more stringent. We cannot make it less stringent.
Okay, don't you think there is a flexibility which they are giving it to the COC members कि ठीक है कोई बात नहीं आप 10% भी quorum रख लो हमें क्या फर्क पड़ता है? Don't you think that that could also be an idea behind it? Okay, anyone who wants to?
Yes, I think so.
Okay.
So
So
there is a liberty. You see, proviso is very clear,
right,
which gives some liberty. The word is not shall at least.
right. हाँ, at least लिखा
So
है.
when, yeah, when
So
the word is at least means basically, if I understand, kam se kam.
Okay.
So when we read the proviso, then follow the proviso. That means you can reduce it. May I read it
Okay.
again?
Yeah, please go ahead, sir. Please go ahead.
The committee may modify the percentage of voting rights required for quorum in respect of any future meeting of the committee. Suppose 33% quorum is not complete, then you have to adjourn the meeting.
नहीं वो तो ठीक है वो adjournment वाला is a separate part that is under subsection sub rule sub regulation 2.
But actually when we read the proviso it can be.
Correct. Because the impression which everyone is getting is provided that the committee may modify the percentage. So there, otherwise, if the law was very sure that it can't be reduced less than 33%, they could have said you can modify a higher percentage to a higher percentage. So therefore, even a lower percentage is also permissible if we just simply read the proviso. I mean, if we simply read the proviso that.
Sir, may I?
Yeah, please.
Sir, I believe if we read in conjunction with the Companies Act also, wherein for calling board meetings, board of director meetings, similar kind of quorum is necessary.
Yes.
And thereafter, we should always, keep in mind that if any provision of the use of any provision might create a prejudice to the maybe directors in the Companies Act or maybe to the COC members in IBC. I think we should always use that constructively to use that at least maybe more than 33%, because if we go say down to 10%, it might cause a prejudice or to the members who are not there in that meeting, and without those members that meeting was conducted and some resolutions were passed. So I think it would be better for us, or maybe suggestive for us, that you move ahead of it. I mean, at a higher percentage, not lower. Although the law is silent, but some fine day, any of the lender will go against the RP in the NCLT and just say that he reduced it, and by using this particular regulation.
We can't reduce it, boss. It is the COC which is reducing it. So let him go against the COC. In any case, this resolution has to be passed by 51% because there is no 66% requirement here, right? This resolution is to be passed by 51%.
So now how I can play with this, that any person who has got, more than that will just pass that resolution to reduce it down and just conduct their meetings without that.
So, you see, to answer that, Kshitij, if I am holding more than 51%, right, I can bulldoze that resolution. I can reduce it to 10%. फर्क क्या पड़ रहा है मेरे पास तो 51 वैसे ही है. Even if I am singly attending quorum, तो फिर भी चल ही रहा. So your answer to that, to bulldoze anyone, it doesn't matter. अगर 33% से किसी का ज्यादा है तो क्या बुलडोजिंग हो रही है? कुछ भी नहीं हो रही. So in any case, if I am a single person attending next meeting and I have reduced it to 10%, बल्कि मैं तो अपने केस जा रहा हूँ. I would like कि दूसरा ना attend कर पाए. Please understand. I would rather say increase it to more percentage because हाँ कम से कम otherwise दो लोग मिल जाएंगे तो उन्हीं का quorum हो जाएगा. And sometimes you see I am there. So rather it is counterproductive. It is beneficial for the person to increase, not to reduce. So reduction, but the point is reduction legally permissible or not? That's the question. So Khatri Sahab is saying that look, there is no prohibition insofar as the proviso is concerned. And in fact, if you gave a example of Companies Act, if I remember correctly, it says the quorum can be fixed by the board, but not less than 2. उसमें मिनिमम रिक्वायरमेंट है, मिनिमम 2 लिखा हुआ है. यहाँ मिनिमम कुछ लिखा ही नहीं है, क्योंकि here the proviso says may modify. Otherwise, legislature would have said may modify the percentage, but not lower than 33%.
Right.
वो लिखा नहीं है. So anyway, I think to conclude, the law is not clear. The intent may be that look, if you decrease it, then what is the purpose of holding a COC meeting? 10% लोग बैठ के decide कर रहे हैं. Then what is the point? I agree with that opinion. But if law is not limiting, according to me, I think I will go by Mr. Khatri's view also, and I'll subscribe to that. That yes, it is possible to even decrease it also. So there is
Because
no.
of the yes, because of the proviso.
Sir, anyways, if we even if you do a meeting with less than 33%, none of your resolutions will be passed, because unlike liquidation in IBC, it is always 67% of the total COC percent or 50% of the total. Present and voting का concept ही नहीं है इसमें.
Actually, no, present and voting वाला concept ही नहीं है. So even those people who are not present in the voting, they also get a right to vote later on.
Correct.
वो manipulation हो भी नहीं सकता.
Right.
So therefore, even if we reduce, at least the meeting will happen. Otherwise, क्या होता है? See, you are spending so much of money, time, and effort in holding a meeting.
Absolutely.
Quorum नहीं आया तो सारा पैसा waste. So therefore, it is आपने cameraman भी बुला रखा है, video वाला भी बुला रखा है, and all those things go waste. I hope Jana sir, with discussions, things are slightly clear. Okay. Okay. I think it's always good to have different opinions, so everyone learns. Okay. Now, of course, adjournment is in any case that the adjournment is not to the next week, just like in Companies Act, it says it will be adjourned to the next day if the quorum is not present. And now you see, there is one more thing. Can we read 12.2 once again, sir? 18.2, sorry, 22.2. Can somebody read that?
Yes. Where a meeting, may I read it?
Yes, sir, please go ahead.
Where a meeting of the committee could be held for want of quorum.
Right.
Unless the committee has previously decided. Otherwise, the meeting shall automatically stand adjourned at the same time and place on the next day.
Okay. So here, what is the meaning or the impact of the word which is used unless the committee has previously decided otherwise?
Otherwise.
No, what is the meaning? What is the impact of this particular sentence? Does the lawmakers are trying to say that the committee can decide that, look, whether a quorum or no quorum, this will not be adjourned? Is that the situation? Or they can say, no, the meeting does not stand adjourned to the next day, but it will be stand adjourned to say 2 days later. So what is the meaning of the word the committee has previously decided otherwise? Now, I was just trying to, gather your views on this, because I've got my views on this, but I just want to hear from you. Do you have 22.2 before you, all of you? I think that's very important. Let's read it and try to interpret this. Where a meeting of the committee could not be held for want of quorum, then there is a comma. Unless the committee has previously decided otherwise, comma, the meeting shall automatically stand adjourned to the same day, same time and place on the next day.
That means COC has power to decide if the quorum is not there, then the meeting is cancelled. But if they don't do that, then automatically it is adjourned to the next day.
Okay. Or they can also decide it is adjourned for 2 hours.
Yes, they can. If they can also decide in that manner also.
Okay. Or they can decide not to the next day, but 2 days later.
Yes.
I mean, they can decide differently than the law provides, because here the law is providing that it will be adjourned to the next day on the same time and same place.
Law is providing the flexibility in both ways.
Yeah, both.
Actually, both the ways. You previously decide. If not decided, then 24 hours next day.
Absolutely. Absolutely. I think I also agree with that. That is the view which is coming. And in any case, as far as the quorum modification is concerned, that is covered by 18.1, right? Or 22.1, which is not covered by 22.2. So I think, friends, this is also one of the important aspects which I thought we should discuss on that. Okay, here, friends, small important things. RP to be the chairperson, we all know that, and RP is a facilitator. Roll call is to be taken. I believe you must be taking the roll call, but there is one more, requirement which is there in Regulation 24, probably which you are aware, but I think it's my duty to recapitulate. In the roll call, friends, please make sure, and please get it recorded also. Please understand, virtual meeting kar rahe ho, to recording is very easy. You just press a button and it's recorded. But if you are holding a physical meeting, Many RPs are involving the photographers or the videographers to capture the essence of the meeting, complete meeting. Please do that if possible. This will help you in times to come. But if you are holding a virtual meeting, then what you need to do through video conferencing, if they are attending, they must say their name. They must say whether they are attending as a capacity and as a member or as a participant. They must say the location from where they are participating. They must confirm whether they have received the agenda of the meeting, and they must also confirm that no other person is attending from the location or is accessing that from the location from which he is attending. So these 5, 6 things you must ask them to repeat. It's very important. I've seen RPs are not doing it. Tomorrow it will become a problem for you. So follow this. I think that will become very, very crucial.
So, sir, can you repeat these 5 actually aspects?
तो 24 में लिखा हुआ है, आप मैं फिर भी रिपीट कर देता हूँ. Name, whether attending as a member or a participant. Third, location. Fourth, whether they have received agenda and other material or not. And lastly, location. Sorry, location तो हो गया था. The whether they are attending alone or somebody else is having an access or attending from that. So they should confirm that they are alone in the meeting, in the room.
This is very important. A person who is accompanied actually.
Right. Because कई बार क्या होता है, एक बार क्या हुआ मैं आपको बताता हूँ. अब SCC में ये conditions नहीं है शायद. Right? I don't know whether they have changed it or not. Initially it was not there. अब SCC में क्या हुआ? When the meeting was happening, one RA was appearing. RA was there. अब उसके वीडियो पे आवाज आ रही है, लेकिन वो बोल नहीं रहा. I mean, I can see that he is not speaking. There was somebody else who was sitting along with him, but उसको पिक्चर में नहीं था, फ्रेम में नहीं था. So then I said कि यार कम से कम उसके आगे भी कैमरा तो लगा दो या लैपटॉप को मोड़ दो, so that we are able to see him also. So please make sure that you are doing these things. और एक केस में बता देता हूँ सर, आरपी ने क्या किया, which is very dangerous. Generally, क्या होता है in IPEs, one person is the main person. Typically, 1 or 2 persons are main person. I think you must have experienced that, right? Whether he is an RP of that company or not, he or she will attend the meeting and he will control the meeting. Total meeting भी वही चलाता है. ये तो आपको मालूम है बात. अब एक केस में क्या हुआ, I was appointed as an representative for the financial creditor. क्योंकि वो फाइनेंशियल क्रेडिटर को थोड़ा कुछ तंग कर रहे थे, तो उन्होंने कहा सर आप आ जाओ. चलो, मैं कहा अथॉरिटी दे दो, उन्होंने इन्फॉर्म कर दिया, तो मैं पहुंच गया. अब उन्होंने क्या किया, when the IPs were speaking, because it was a virtual meeting during COVID period, they were sitting in their office and they were not opening the videos. उनका खुद का वीडियो बंद था, और बाकी भी जितने भी फाइनेंशियल क्रेडिटर्स थे, से SBI or whatever, they were all videos were closed. I raised this point of order. I said, Mr. RP, your video is off. Forget about the others. And this is not a faceless meeting. How do I know that somebody is appearing? Who is appearing on behalf of the SBI? I want to see them. Why are you not requested them to open their videos? And even your video is also closed. Why was not opened the video? Because जो सामने तो RP बैठा था, बोल उसका बॉस रहा था साइड में. So because actually I know most of the RPs, so I could recognize कि इसकी आवाज तो है नहीं.
Can the RP's advocate join the meeting?
See, sir, one thing.
RP advocate can join the meeting.
See, yes, RP's advocate is typically not allowed. No, RP's advocate.
Yeah.
RP can ask any person. उसका तो कोई भी आदमी जाने, उसकी टीम भी कर सकती है.
Sir, what happens? Sometimes banks they come with 4 or 5 officials. Is it allowed, sir?
Well, typically speaking, it is not. I'll tell you. But problem क्या है? RPs के पास आपके पास choice का है. आप उनको मना करोगे, वो आपको हटा देंगे. Let's be honest about it.
पूरे process में नहीं है actually.
No, sir. My point is that if I am capturing that in a video, then later on I may face problem.
What you do is, then in that case, what we used to advise RP, We said, look, only 1% is allowed, but here there are two people on behalf of Canara Bank or some other bank are sitting. Is any COC member has objection? They say, no, we don't have any. This is all right. So आपने अपना पॉइंट भी बता दिया और ये भी ऑब्जेक्शन भी ले लिया. अगर किसी को ऑब्जेक्शन है किसी बैंकर को तो निकाल दो उसको बाहर. Kaya then this is objection. So please.
But Mr. Makhija, when you are conducting the meeting, COC,
right,
you have to engage professionals at the particular time to explain the ratios. You know, most of the time we have seen a problematic. You see, we are not the expert of everything.
Correct.
जब ये resolution plan approval placed before the COC, we face technical questions from the banker side most of the time.
Correct.
So for this reason, we have to engage the special person who actually will answer all the queries.
Correct. You can do that. There is no bar.
Most of the time, we have seen the RPs are not able to answer those queries.
No, naturally, देखिए कोई ना कोई limitation हो ही जाता है. Supposing somebody is not a legal person, right? And certain legal question is asked. That is why Kshitij also asked, can lawyers be present? The answer is yes. In fact, Kshitij, you see, in most of the early meetings in 2018, 19, and 20 also, as lawyers, we were always present. It was a part of our mandate कि आप हर meeting हमारी COC attend करोगे. And in fact, what RP used to do, कोई भी trouble आती थी, हो गया, Mr. Makhija, you respond. अरे मैंने कहा मैं But anyway, so if you need the presence of your team members, you need the presence of an expert or a valuer or whatever, RP is free to ask and invite them as a special invitee. They can.
Makhija sir, एक problem बहुत है. I tell you what is the problem.
Yes, sir.
The meeting take place. There is no question actually coming up from the financial creditors. Surprisingly, you know, we are asking them, you please send us a question if you have any agenda question, so that easily we can prepare it and we can answer it.
Right.
So what they are doing is, surprisingly, they open the Pandora box. In order to stall the proceedings, to create a ruckus in the meeting actually.
Right.
Even we are writing the agenda, always writing, you please, you know, this is a general sentence we are using it. If any other agenda.
Right.
That means if you have any question, please endorse the question so that actually we can answer it during the course of the meeting itself.
True.
So that way, nobody take care of actually, you know, financial creditors mostly.
You're absolutely right. I think the point is, this is very important. When you put this kind of a question to all the financial creditors, that if you have any question, feel free to ask. This shows that you are being transparent. So I think this goes a long way in demonstrating that, look, you are opening yourself to any questions. I think that's a good practice which must be followed. In fact, friends, Ankush has also shared in the chat box the statement of best practices. Probably, I think, Ankush, it is by ICSI, IIIP, I believe.
Yes, sir. It is, yes.
Right. So, in fact, I'm happy that I was also involved in creating this. So please follow this also. I think this gives you a lot of information. And these are not merely papers, friends. These will actually save your skin if any complaint is filed tomorrow. So you'll be able to, justify yourself. I think that's very important. Okay. अच्छा, नॉन बेलेबल वाला है, एक क्वेश्चन रह गया था, वो अभी डिस्कस करते हैं सर. Okay. What if the member present in the meeting but abstains from voting on the resolution? Okay, so he is counted as a quorum if that is the question. As far as the quorum, he is counted, but as far as abstaining is concerned, it will be treated as a negative vote that he has voted against.
So basically, there are three parts: and yes, no, or abstain. So I think they might go in abstain. Yeah.
Correct. So abstaining is treated as a negative vote.
Yeah.
Right.
Okay. I think before I move forward, I think let's debate that question which Khatri Sahab asked. Friends, the point of contention which he raised was, number one, he raised that whether the person concerned can be sent to judicial custody or not. I will add another angle to it. And this happened actually when I was the standing counsel for the OL in Delhi High Court. If a person comes through on a summon for a bailable warrant or non-bailable warrant, does he require to obtain a bail? Is he required to furnish a bail bond? That's another question which we want to see. जुडिशियल जेसी की तो बात बाद में आएगी, पहले तो ये आएगा बेल बॉन्ड भी लेगा कि नहीं लेगा. So that is another thing. And before that, now let's come to the one basic question. Does the NCLT or NCLAT have power to issue bailable or non-bailable warrants? That is the first basic question which needs to be asked. Well, this was being done. This practice was started by Delhi bench. Then it was followed. It has been now followed by most of the other benches also. And ultimately, the NCLAT has actually approved this and say yes, NCLT can issue bailable and non-bailable warrants. क्योंकि कोर्ट तो कभी नहीं कहती मेरे पास पावर नहीं है. So anyhow, so this stands decided. So there is no query.
These are the judicial proceedings.
These are judicial proceedings, or in any case, they have gone into NCLT and NCLAT rules, which says that they can enjoy the power of a civil court and all that.
Yes. Yes.
So those kind of things are there. But now the second part to it, that when the person appears, supposing a suspended director, he's issued an NBW and he appears. Naturally, he has to appear in person. Should he obtain a bail? The answer is yes. He's supposed to obtain a bail.
Now, another question comes, sir.
Yes,
Question
sir.
comes, who will be the complainant?
नहीं, इसमें तो complainant है नहीं, sir.
That is what I am saying. In the absence of complainant, now the bail, obtaining bail and prosecution started. How it come?
Okay. Let me try to, bring forth another aspect. When we were handling, winding up matters under Companies Act 1956, there was a specific section of Section 454. I don't know how many of you are aware, but let me tell you one thing. When a company comes into winding up, just like it is in liquidation, वहाँ पे एक बड़ा अच्छा system था, जो ये system यहाँ missing है. And I have suggested to the government that do that. What they should do, that when an CIRP application is filed and the corporate debtor responds, the corporate debtor should not merely respond, but they should be asked to file their latest balance sheet, latest financial position, everything latest. List of directors, क्या factories हैं, कहाँ, एक chart बनना चाहिए, जिसको हम statement of affairs बोलते हैं. This statement of affairs was required to be filed by the company which comes under winding up. वहाँ पे requirement है section 454 में. We call it a statement of affairs. उसका बड़ा 26 page का format है. Already company court rules 1959. There is a format given. So IBC, they do not have to lift their little finger. They can adopt that, document by just modifying. उससे क्या benefit होगा? The moment the company comes into CIRP, you have the basic data. You will not have to struggle. I think this is a very small thing which can be done. But anyhow, and this also happened. We were facing problem in winding up under Companies Act 56. When Companies Act 2013 was being drafted, we gave our suggestions from the OL side. And this was added into Companies Act 2013, and it is there. What does it say? It says, while filing the reply to the winding up application, the directors of the company should file statement of affairs. और उसका format दिया हुआ है वही 26 पेज का. And if they don't file along with the statement of affairs, their reply will not be taken on record. Friends, can you believe this? This is written in Companies Act 2013. Unfortunately, this was not brought in companies, this IBC. This amendment, if done, I think it will go a long way in supporting the RPs. Anyhow, that's besides the point. Now, let me go back to 454 again. And that was section 454, that once the company comes into winding up, they have to file statement of affairs. And if they don't do, then those can be penalized, they can be put behind bars. And typically why Mr. Khatri is asking this question as a lawyer, because putting behind bar, only a criminal court or a metropolitan magistrate can do it. MM can do it, no other person. Of course, High Court can do it, but not any other court.
That means the person should send the concerned magistrate having the jurisdiction.
So मैं वही आपको बता रहा हूँ sir, 454 under Companies Act 1956 was a unique section,
yes,
which gave power to the company court to send the person to a jail. तो बड़ा unique section है 454.
Yes,
So उसके अंदर, but the similar section is missing in IBC. So therefore Khatri Saab is asking a question कि आपके पास power कहाँ है JC में भेजने के लिए, judicial custody में? आपके पास power कहाँ है bail bond लेने के लिए? So here, typically speaking, if somebody is sent to jail और कोई ऐसा ऑर्डर कभी आ जाता है तो ये सुप्रीम कोर्ट ही डिसाइड करेगी कि क्या होगा.
There is one judgment, sir, Vikas Puri and CLAT actually. Vikas Puri, in that judgment they held, yes, the NCLT has got power
yes,
to make presence, but actually this vague, actually not clarified, the proper answer has not been coming up from the bench.
Available warrant challenge किया था ना, PW challenge. अभी वो जेल वाली बात तो आई नहीं थी.
आई नहीं थी. There was no question, but actually there is a half of the judgment.
So what exactly typically what they will do is they will now the NCLT will make a complaint to the Metropolitan Magistrate.
That is the requirement of the law actually, rules.
Yes.
That means they have to constitute some body. That body is going to become the complainant.
Yes.
In order to pursue the complaint. That is actually the solution.
In fact, when you say that, and I can very delightfully tell you that I was a part of the committee which created NCLT rules and NCLAT rules. Our committee submitted a 900-page report to MCA, and that was adopted, and they were converted into NCLT and NCLAT rules. So ये सारे issues debate हुए थे, और हमने object किया था as lawyers because there were 2 lawyers were there, and we said, look, we can't give judicial magistrates power to NCLT. आप दे दोगे तो बहुत मिसयूज होगा, तो कल पता नहीं कितने अंदर जाने लग जाएंगे. There is a process. आपको याद है SFIO ने अभी किसी को अरेस्ट कर लिया था, and that person challenged before the ये भूषण को ही करा था, और ये they challenged in Delhi High Court, और Delhi High Court में जस्टिस मुरलीधर थे, कितनी डांट लगाई थी उन्होंने. What nonsense? You don't know the practice. आप बताइए मुझे, आपकी वो अरेस्ट रजिस्टर कहाँ है? हाँ, मीमो कहाँ है, डेली डायरी कहाँ है? वो उनको कुछ बनाया नहीं था उन्होंने, कुछ भी नहीं था. उन्होंने कहा you are not following the criminal law. So therefore, my dear friends, Mr. Khatri is right when he says that even आप बेलेबल वारंट इशू कर दो डराने के लिए, नॉन बेलेबल कर दो, लेकिन अरेस्ट के लिए बड़ा टेढ़ा काम है. हाँ, it's not that easy.
You see, if ex-director, suspended director comes, he will say, sir, I will not cooperate. Even whatever you direct, I will not cooperate. I will not give any document. Then you have to send him in judicial custody.
Correct. But ऐसा तो कोई नहीं बोलता जब कोर्ट में आके.
नहीं सर, देर आते हैं सर, ऐसा नहीं है.
वो ठीक है, वो सामने बोल देते हैं कि we will cooperate, but they will not cooperate later on.
Actually, yes, practically they don't cooperate in fact.
Yeah, practically they won't cooperate. Yeah. So friends, this is the position as far as the this thing. I think good discussion with my friend. Okay, let's look at So quorum. This is also another important thing. I don't know how many of you are making sure. Quorum must be present throughout. ये नहीं कि start of the meeting. Companies Act में बोलता है start of the meeting, isn't it? Companies Act में throughout की बात नहीं है. But in IBC it is.
Board meeting में है सर. Board meeting में है ना.
Throughout है.
Board meeting में throughout है ना.
मेरे ख्याल तो नहीं है सर ऐसा.
Board meeting में throughout है. General meeting में नहीं है. General meeting में throughout का बात नहीं है. At the beginning.
Okay. But I don't know why I'm holding a different opinion. Anyway, you might be right because I don't remember. Any company secretary here who can confirm? अब कोई वीडियो नहीं खोलेगा. Okay, anyhow, doesn't matter. I think we need to check on that, right? Okay, so circulate minutes within 48 hours. This is something which is very time bound, friends. Please do not delay it.
SS2 weekends and holidays.
नहीं सर, इसमें वीकेंड हॉलीडेज कुछ नहीं है सर. 48 आवर्स मींस 48 आवर्स. आपकी फैमिली में चाहे डिवोर्स हो जाए, आपको मिनट्स बनाने हैं. So therefore, you see this. Please take care of this. Okay. इस इशू पे बहुत कंप्लेंट्स गई हैं IBBI के ऊपर. That minutes have not been. And IBBI is very strict because they say how a person will vote unless you circulate the draft minutes. So voting to take place after discussion. अब तो मीटिंग के अंदर ही कर दिया है. Announce decision taken with who voted for, against and abstain. Circulate minutes and then seek a vote of members who did not vote. But most of the bankers don't vote. वो सब कहते हैं साहब हमारे को तो बता दो कब वोट करना है. We'll vote later on. they are not voting at the time of the meeting. But somebody who votes at the meeting, then he does not get a chance in the electronic voting. Again, please make sure. Because here the law says votes once cast cannot be changed. Now this has been amended, right? Earlier this clause was not there, but it has been amended for quite a long time now, of course, Regulation 25. And inform the final decision to the participant. I don't know how many of you are doing this. Minute circulate करने से काम नहीं चलेगा.
To Tessa's report, I think we should circulate.
Right. Voting ka jo, matlab, what is the decision? So then you will have to do that within 24 hours of the conclusion of the voting. So please make sure, friends, that these are followed. Otherwise, there can be issues. Now, one last aspect people ask me is that can the voting be kept for more than 24 hours?
Yes.
Because law is silent, isn't it? So law is absolutely silent. It does not say that how long the voting window is to be kept open. So you can keep it open for longer than 24 hours.
Sometimes you have to keep open for 1 month also.
So absolutely right. No.
1 month वाले होंगे लेकिन कम होंगे केस
mostly. So plans वगैरह जहाँ decide होते हैं ना, they take time.
Banks में बहुत सर, when the banks SBI, when the Canara Bank, when the Central Bank, when the Union Bank, then at least 20 days.
हाँ वो कोई ना कोई email भेज देगा.
हाँ एकदम last night सर, 1 घंटा पहले भेज देता है.
Oh, please give us some time. हम अभी कुछ नहीं कर पाए. और अगर if you refuse that, then it is a problem, isn't it?
Yes.
उसमें एक काम आप कर सकते हो सर. I think what you can do is to protect yourself and to protect the delays. At the time of the COC meeting, get a resolution passed. इसको एजेंडा में डाल दो कि how long the voting window should be open and which will not be extended despite any request being made.
Yes.
So आप चाहे पहले ही 7 days दे दो, 10 days दे दो, but don't give them beyond that. I think you have to protect yourself.
We have started writing like this. Okay, no attempt and no defer of the meeting request will be considered in future.
Yeah, if he doesn't vote, then it will be treated as not voted.
Not voted.
तो प्रॉब्लम वही है ना, वो फिर क्या होगा, नेगेटिव वोट माना जाता है.
Sir,
exactly.
प्रॉब्लम है कि फिर आपका रिपोर्ट कार्ड खराब हो जाता है कि देखिए साहब इस आरपी का प्लान अप्रूव नहीं हुआ.
सर उस टाइम पे यू एंड अप इन अ बिगर डिलेमा. वहां पे आपके पास डीजीएम सीजीएम से फोन आ जाएगा एंड देन वो एक्सटेंड करो, वो बोलेंगे, आप बोलेंगे नहीं करेंगे.
You're right. So I think that flexibility should be allowed, because at the end of the day, I also agree that it is for the benefit of the corporate debtor if the plan is approved. That is always better.
Mr. Makhija, one question is also coming in my mind. May I ask one question?
Yeah. Please go ahead, sir.
Whether
आपके क्वेश्चन से मुझे थोड़ा डर लगता है, बट कोई बात
नहीं. Sir, I'm basically sitting with all.
I know.
People. So I am just asking whether infringement, in the trademark cases, whether infringement can, in the going concern entity, whether infringement can continue during the period of moratorium.
Okay.
This is the complex situation. Every case we are facing actually, because we go to the High Court also. So now this question actually nowhere it is decided, in fact, because you see, stay is granted by the High Court.
Right.
Now I am running a company as an ongoing concerned entity.
True.
Right. Now I am making the profits from the company and disbursing all these payments, employees and everything. Company is ongoing concerned entity.
Right.
So I am already infringing. So this question is basically how to answer these questions, these practical difficulty we are facing.
Well, the infringement stay order is being passed against the corporate debtor. That's what
the corporate debtor. And that corporate debtor actually has gone into the CIRP, moratorium declared.
Sir,
now,
if you ask me, my prima facie answer based on section 14 is yes, that it should be barred. Moratorium should apply to even to these proceedings, because if we go by the wording, it says institution of suits or continuation of pending. So, and this is also a suit. This is also a suit.
Yes.
Right? Of course, this is not a suit for recovery, but it is suit for infringement or suit for stay or
suit for damages,
negligence or this thing. So, according to me, that will be covered. But having said that, I think Khatri Sahab ne ek bada acha important point raise kiya hai. Friends, you will recall there was a judgment of Delhi High Court, Power Grid versus Jyoti Structures. Now, what happened? That was under arbitration. Let me give you small brief facts of the case to understand. there was an arbitration going on between Power Grid and Jyoti Structures. And Jyoti Structure won that award. The award was in favor of Jyoti Structure. This happened before CIRP. Now, once the award was challenged under Section 34 by Power Grid because it was against the Power Grid. In the meantime, while that Section 34 application was pending, company came into CIRP. So when the matter was taken up after the CIRP, the lawyer of the RP said, my lord, Section 14 moratorium applies, so stop these proceedings. The judge, Mr. Justice Yogesh Gupta was there. He said, sorry, I will not stop it. And he gave a very detailed judgment. And he gave reasonings. He said, the word which is written in the IBC is proceedings. He says, all proceeding kahan likha hai? Bada technical, bada dissect kiya unhone. And then he said, the only those proceedings which result into dissipation of the assets of the corporate debtor, they will be barred. Bola, in this Section 34, what I'm deciding, whether this award is valid or not, I'm not asking for the corporate debtor to pay. So therefore, these will not be stopped. And similarly, on the basis of this judgment, Power Grid, there was another judgment by Justice Pratibha Singh, SSMP Industries. और उन्होंने भी उसको फॉलो करके इवन 37 को भी बार नहीं किया. ये 34 पे थी, वो 37 appeals under arbitration act. Now, naturally, I had a different opinion, and that time they said no, even that should be barred because उसका एक logic है. What happens in a suit? Supposing a suit is filed against the company, the decree will be passed. Recovery तो नहीं हो रही ना. It is only a decision making. So then why other suits are barred? See, then only those suits where recovery is being made should be barred and not all the suits. So logic does not cut ice. Because judge said, I am not ordering for recovery of the money. I am only deciding whether the award is valid or not.
Award should not be implemented. That is the...
But the point is, suit में भी तो यही होता है सर कि कितना पैसा किसने देना है. वो कोई recovery थोड़ी है, उसके लिए तो execution file करना पड़ेगा. So anyhow, what happened? You remember that P. Mohan Raj judgment of Supreme Court?
Yes, yes.
Where Section 138, whether these proceedings are civil proceedings or criminal proceedings, whether they are covered under Section 114 or not, moratorium. And yes. Supreme Court ultimately decided that these are akin to civil proceedings. So therefore, even the proceedings under 138 will also be covered by moratorium against the corporate debtor only, not against the directors. But in that judgment, Dr. Abhishek Singhvi, he actually quoted Power Grid. And he also quoted SSMP. Rather, he only quoted Power Grid versus Jyoti Structure. He said, even the single bench of the Delhi High Court has decided that the moratorium does not apply to the arbitration. So therefore, the moratorium should not apply to 138 also. The Supreme Court, while dealing with the argument of Dr. Singhvi, in one of the paragraph, I think it's para 50 or something, they have mentioned that in our view, Power Grid does not lay down the good law. और एक बार नहीं, दो बार लिखा है एक ही पैराग्राफ में that it does not lay down the good law. So typically speaking, that Power Grid judgment has not been overturned, and somebody can argue that this was only by way of observation. It is an arbiter.
Even we have stopped citing the judgment Power Grid any of the forum now.
That's what I'm saying. So because you see what happened in one of our arbitration matters, very interesting. In fact, friends, this is very interesting. You must also hear. Some party started an arbitration proceeding against the corporate debtor. Right? Oh, sorry, we started. Sorry, the RP started the proceedings, an arbitration proceeding against some company. We are the claimants. Those people, as naturally happens in any arbitration proceeding, they filed a counterclaim. Defense तो file किया, साथ-साथ counterclaim file कर दिया. I moved an application before the bench, which was an international arbitration, and that included Justice Sikri and another judge of Supreme Court, and then Justice Indermeet Kaur of Delhi High Court. So, 3 bench ki arbitral tribunal tha. I said that, look, they cannot file a counterclaim because moratorium applies. It is a suit against the company, and a counterclaim is a separate suit as per the limitation law, Section 3. Justice Sikri agreed. He said, yes, it is a separate suit. We don't deny. But then he said, Mr. Makhija, if we are deciding your claim, naturally we have to decide their counterclaim also. Otherwise, what is the point? It will be futile. Then I explained them. Then he was in that mood कि yes, hona chahiye. The other party quoted Power Grid and also SSMP. I quoted P. Mohan Raj. I said these have been held not to be laying the good law. The other party argued that, my lord, this is only an obiter. This is not a ratio of P. Mohan Raj. P. Mohan Raj was on 138. So I said, my lord, there are 10 judgments. मुझे पता था ये argument आने वाला. I was prepared. I said, my lord, there are 10 judgments of Supreme Court which says even the obiter is binding on the lower courts. And मुझे तो सिर्फ एक line बोलने की देर थी. And Justice Sikri is such a fantastic judge. He said, yes, Mr. Makhija, don't quote the judgment. We know that. वो Supreme Court से आए हुए हैं. उनको पता ही था. So, and ultimately, can you believe they passed 20-page judgment in my favor saying that counterclaim in an arbitration proceedings cannot continue because it is barred by section 14.
Moratorium.
Moratorium. And they challenged before the single bench of Delhi High Court who rejected it. They challenged it before the DB and they knew that they are going to face music. They came and settled. चलो वो तो एक अलग बात होगी. RP को benefit मिल गया. And RP got how much money? Do you know that? We settled for 17 crores. RP is very happy. कह रहा है यार मेरी फीस मिल गई. मैं कहा तुम्हारी तो मिल गई, पहले मेरी फीस दे दो. So anyhow, so friends, these things you see do turn into very interesting case laws. And I think if we are clear in our mind, अगर हमारा concept clear है ना friends, then stick to it. I mean, I'm not saying be adamant. Obviously, you have to change if somebody is presenting a better view. But if your concept is clear, then try to persuade the benches on that matter and set precedents. And you will find number of precedents in that particular aspect. So I think a lot of interesting things have come up. So if we look at all these scenarios, coming back to your question, even the trademark infringements, I believe will be covered under moratoriums. That will be covered.
Sir, I have a question, shall I?
Yes, sir. I think Mr. Amin also raised a hand earlier. So, Amin ji, कुछ बोलना चाहते हैं आप बताइए.
The same issue IPR. So, in one of the case, what happened is that subsidiary where we don't have a direct control.
Okay.
So, promoter tried to use this trademarks, or rather, he tried to transfer it. Okay. Then now he is using it during the moratorium. So, issue is that there is a stay. Now, but the stay from NCLT is not very clear on whether they can use it, we can use it. So we are interpreting that both can use it. Okay. Now the issue is that after NCLT decides on that part, that whether because we have filed it again against that promoter under section PUFE, that this transfer was just before CRP and it is not valid.
It's bad. Okay. Okay.
Yeah. So now the issue is the recovery on part of the usage of this trademark, because that becomes a challenge now. Because see, after that judgment comes, there will be challenges. Now, CRB is a limited time frame where we have to conclude the entire thing. Now, how to proceed against and the recovery becomes a nightmare because he has used it. He has created a parallel business. Though we are challenging it, the benches and other things are nowadays, they changes, the judgments are reserved. So it becomes, from RP point of view, it becomes a nightmare, particularly this, IPRs usage, and then how to basically avail the benefit of usage by the other parties. So even if they are right, I am right, we both may be right. But in that situation, how to deal with this recovery part? Because that becomes a very critical thing. How to plan it out.
Okay, see, in a lighter vein, you are giving all credit to NCLT. Give some credit to lawyers also, right? That litigation goes on. Naturally, we have a right to file application. We always advise the clients to file appeal. Yeah. Anyhow, besides that, friend, my dear friend, you see, what you need to do is, as I mentioned in the beginning, endeavor. You may not be able to recover during your tenure, but you have to take an action which shows that you acted, you worked. Because if you remain silent today, tomorrow a finger can be raised upon you कि आपने action ही नहीं लिया. Why didn't you file this application? So don't bother about whether it sees the light of the day during your tenure or not. Let's not be bothered about it. हमें अपना काम करना है, right? Let us see what happens. What will be the result? आपकी जगह वो liquidator आ जाएगा, RA आ जाएगा, कोई ना कोई तो litigation continue करेगा. So do your job. That's all what I can advise you. Okay? Yes, sir. Mr. Sudarshan. Yes, sir. Go ahead.
Sir, this is in connection with the 12A petition.
Right.
There is an agreement entered between the applicant and the corporate debtor, but the applicant has given me the form FA only. They have not shared the agreement or memorandum happened between the applicant and the corporate debtor. They say we don't want to share it. You file with the form FA only. Will there be any objection from the court, or will it go through? Is it mandatory to file the copy of the agreement entered with the corporate debtor and the applicant?
Okay. In fact, let me tell you, it differs from the bench to bench, right? Some benches want that you must disclose. Some benches are very happy. Those who are very seasoned benches are there. They will not like to have the copy of the agreement. Because you see, what happens is, if they take the agreement on record, and if that agreement is not followed, it becomes a matter of contempt later on. So they don't want to get into that question. He says, you have settled, we'll record, file an affidavit that settlement is done, we will record that settlement, that's end. What you have settled, what you have not settled, we don't care. So I think seasoned benches will not insist for that. But yes, there are certain benches which can ask for it. If they ask for it, then naturally it is the responsibility of them. For you as an RP, if you have got a Form A, go and file the application to the NCLT. If they ask for it, then you ask them to join the proceeding. Obviously, the OC and other people will also be there. He is the applicant only, isn't it?
Yes.
So let them answer the bench then. But typically, if you ask me if I am also the judge, I will never ask for it. Either हमने settle कर दिया यार, मेरे ऊपर क्यों pressure डाल रहे? That's all right. So otherwise, वो फिर होता है कि if any of the condition of the agreement is not satisfied, then consequences के लिए फिर आप मुझे involve कर लोगे. I mean, I'm involved as a judge also, isn't it? Okay. What is your take on this, Mr. Khatri? Anything you want to add on this? Sir, you are muted. I mean, we can't hear you.
I'm so sorry, actually. No, I like the wording, So Mr. Makhija deserves the judgeship, actually. The reason, you see, the expert people should join the, as expert people. I mean, they should choose an eyepiece, a few eyepiece, and place into the judges. So something is required to, because the revenue officers are coming, it takes time to understand things, actually. So that's my view.
Thanks for your comment, sir, but I'm on this side. And in fact, just like I had taken a session, I've also taken a session of the NCLT members also. So I'm happy with that way.
Training, yes.
Yeah. I mean, that's okay. That's a part of this thing. So, yeah. So friends, I think we are almost close to the end now.